who are members of the Senate and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in the Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, a serious issue has been raised with me via correspondence, which I have determined warrants my early and urgent intervention. Parliamentary privilege provides essential protection from external interference of any kind. It guarantees members of this parliament the freedom to speak, deliberate, and vote without fear or coercion. This is enshrined in Section 55(1) of the Constitution of the Republic of Trinidad and Tobago, which provides, and I quote, "Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of the Senate and the House of Representatives, there shall be freedom of speech in the Senate and the House of Representatives." End of quote. This freedom is not a mere courtesy. It is a fundamental constitutional right, sacrosanct and beyond challenge or compromise. As further affirmed in Parliamentary Privilege in Canada, second edition, by J.P. Joseph, Megan, QC, page 253, and I quote, "To reflect improperly on a vote in the House and motives of some members is a breach of privilege." Let me be clear. Healthy criticism is not only permitted, it is expected in any functioning democracy. No one is suggesting that expressions of disappointment over policy outcomes or disagreement with a vote are out of bounds or out bounds. But what we are dealing with here is not mere criticism. When words or actions cross the line into harassment, intimidation, or attempts to shame senators for how they vote, or pressure them to vote in a particular way, that is something entirely different, and it will not be tolerated. Such actions strike at the very heart of parliamentary democracy and may constitute a serious breach of privilege. They will not be taken lightly. Every single member, be you independent, be you opposition, be you government of this Senate, possesses the inalienable right to speak and vote freely, guided by conscience and without due influence. These are not abstract ideas. They are binding principles. Let this serve as a clear warning to all. This House, and certainly this chair, will act firmly to protect the privileges, rights, and immunities of this Senate collectively and each senator individually. That protection will be exercised to the full extent of the Senate's authority, and if necessary, the appropriate avenues for redress will be pursued without hesitation. I so rule. Honorable members, I have received the following correspondence from the Speaker of the House of Representatives, dated Friday, June the 27th, 2025, in relation to the appointment of members of the House of Representatives to joint select committees. As a result of the large number of committees and appointments listed in said correspondence, the clerk was directed to circulate same to all members in an effort to efficiently utilize the Senate time. I hope that we would be in a position to conclude our part of this exercise before we go into the recess break. That is the appointment of all members to our sessional committees and all members to our joint select committees. This is directed by the Constitution. So I'm looking forward to those committees being properly populated.
Bills brought from the House of Representatives. The Prime Minister's Pension Amendment Bill 2025 in the name of the Attorney General.
Minister of Planning, Economic Affairs and Development, and Minister of Finance.
Mr. President, in accordance with Standing Order 621B, I beg to move that the next stage of the Prime Minister's Pension Amendment Bill 2025 be taken later in the proceedings.
Honorable Senators, the question is that the next stage of the Prime Minister's Pension Amendment Bill 2025 be taken later in the proceedings. Those in favor say aye. Those against say no. I think the ayes have it. The next stage of the Prime Minister's Pension Amendment Bill 2025 will be taken later in the proceedings.
Peoples.
The Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Finance. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Office of the Procurement Regulation for the financial year ended September 30th, 2023.
Questions on notice, questions for answer.
Leader of Government Business.
Mr. President, there is one question on the order paper for a written answer. And this is question number 4. I have spoken to the Honorable Senator Dan Paul, and he has no objections to that written answer being circulated over the next 2 weeks.
In the next?
2 weeks.
Okay,
So we can defer, please. Yes.
okay.
Oh.
Okay, well, this question will be deferred till next 2 weeks.
Public business, government business, bill second reading.
The Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled an act to amend the Prime Minister's Pension Act, Chapter 2, 5051 be now read a second time. Mr. President, good morning. Good morning, colleagues. Before us today is the Prime Minister's Pension Amendment Bill 2025, aimed at introducing the requirement that a person is required to serve at least 1 year as Prime Minister in order to qualify for a Prime Minister's pension. The bill also seeks to introduce a tiered system of meritocracy, where maximum benefits of pension are earned rather than bestowed for an individual serving for 4 years or more as Prime Minister. And Mr. President, the bill has retroactive effect from March 10, 2025, thereby requiring a special majority of 3/5. It nevertheless seeks to address a serious inequity in the governance of this country, where there is time-based benefit structure for diplomats, civil servants, police, teachers, members of the Defense Force, but not for the top-tiered leadership of our country. This therefore constitutes a grave injustice perpetrated against the people of Trinidad and Tobago and against the principles on which we stand. Mr. President, there is disproportionate pension benefit system. It can be considered an unfair, human resource practice, as one parliamentarian receives generous, fully funded pension for life, regardless of the length of service. And in contrast, ordinary public servants must have minimum periods of service to be eligible to receive pension benefits. In fact, as Senator Brown would know, when we were in our first incarnation and an early election was called, at that time, we were not entitled to pensions, not having served the requisite time. And I went to Barbados fully understanding that. The Prime Minister's Pension Amendment Bill 2025 seeks to address the current reality that a member who has been appointed as Prime Minister is entitled to a pension for the rest of their lives, regardless of their tenure. So essentially, a person can be Prime Minister for a nanosecond and is still entitled to a pension of someone who has been Prime Minister for 4 years or more. I wish to wholeheartedly indicate that this notion is not only unacceptable, it is unfair and unjust and against sound human resource principles from which we have all established and abide by from the beginning of our republic. Mr. President, please permit me to provide some background to this bill before I share my thoughts on the matter at hand. Mr. President, at the core of this bill and this ensuing debate is the interpretation of Section 76(1) of the Constitution, an important legal provision that deals with the appointment of a Prime Minister in Trinidad and Tobago. And Mr. President, Section 76(1) reads, sorry, Mr. President, I just lost my train of thought. So, Mr. President, as clearly envisaged, this government recognizes the fact that while we have given citizens the assurance that we will manage the country's affairs reasonably and equitably, for far too long, we have been crying out, especially for those who have served across the board. And I just want to give another anecdotal story, Mr. President. I spoke to a former soldier of mine, Brian, this morning. And he called me he served, when I was there, he had probably served about 5 or 6 years of his service. But he has now served 19 years and 4 months. And for Brian to get a pension, he had to serve 20 years. And the only way that he could have received his full pension is if he had either gotten a promotion or found a way where they could extend his service by 4 months. He was honorably discharged, and though he served 19 years and 4 months, he would not be able to get a pension from the Defense Force. These are the kinds of principles of which we speak to today. That public servants are fighting for wage increases, that persons across the public service have to serve particular thresholds of time in order to qualify for pensions. And therefore, the type of actions that are envisaged that we are addressing today would seek to correct this particular anomaly and bring it in line with what we are trying to do and what we have done across the entire public servants. So, Mr. President, this bill before you serves to implement a legitimate area of reform, the introduction of a mandatory minimum period of service to gain a tiered system of meritocracy, where one looks at the landscape of pension laws in Trinidad and Tobago, one will see that most officers have a minimum period stated in law. Members of Parliament, Section 51A of the Retiring Allowance Legislative Service requires a period of not less than 5 years. Diplomatic Section 71A of the Retiring Allowance Diplomatic Service requires a period of not less than 8 years. Public servants, Regulation 2 of the Pensions Regulation, required a period of 10 years or upwards. Teachers, Regulation 4 of the Teachers' Pensions Regulation, required a period of 10 years or upwards. Police Regulation 185.3 of the Police Service Regulation required a period of not less than 10 years. Fire Service, paragraph 3.4 of the fifth schedule of the Fire Service Act requires a period of not less than 10 years. So, Mr. President, the proposal for reform as contained in this bill is to have proportionality and proportionate pension benefit system across the country. It is a result of the genuine need for reform that has arisen, based, albeit, on a set of very peculiar circumstances. But it is either we believe in the principles of good human resource management that have guided our entire public service and our financial and regulatory framework, or we don't. So, Mr. President, this bill has regional consistency, as our CARICOM neighbors such as Antigua and Barbuda and the Bahamas have established in their laws a minimum period of service in order to obtain a pension. Furthermore, international territories such as Canada and the United Kingdom have reformed their legislation to effect a tiered pension system of meritocracy. So with this bill, Trinidad and Tobago will be aligned with global norms as applying time-based benefit structures to top leadership, which reflects best practices and keeps our system consistent and transparent. And so, Mr. President, going even further, the population may ask whether the very real and sensible question, which is there any precedent for what the government is seeking to do anywhere in the world? And Mr. President, the answer to that question is yes. We find examples right here in the Caribbean. In Antigua, the Prime Minister's pension is paid in accordance with the Pensions and Gratuities Parliamentary and Special Offices Act, Chapter 2, 322. Mr. President, Section 3 of that Act states that every person who having held office of Prime Minister on or before the date, this day, 27th day of February 1967, for one fully parliamentary term or for a period equal in the aggregate to 5 years, ceases at any time thereafter to be Prime Minister, shall be paid a pension under the Act with effect from the date on which he ceases to be Prime Minister, and subject to subsection 2 and section 16, such pension shall continue to be paid during the lifetime of that person. So, Mr. President, if we turn to Bahamas, a Prime Minister's pension is paid in accordance with the Prime Minister's Pension Act, that every person having held the office of Prime Minister on or after the coming into operation of that Act ceases at any time thereafter to be Prime Minister and has served that Prime Minister for at least 8 years shall be granted a gratuity equivalent to annual base of his salary. So, Mr. President, so when government seeks to introduce the period of 1 year's service as Prime Minister for a person to be eligible to receive a pension, this is a very balanced and fair approach. Mr. President, I now turn to the bill at hand, which consists of only 6 clauses, a short title, which is straightforward and requires no further explanation. Clause 2, Mr. President, seeks to establish March 10, 2025 as the effective date of the bill. Mr. President, this ensures that the bill has retroactive effect, and because of this, the government is being cautious and ensuring that it passes with a special majority. Mr. President, Clause 3 of the bill contains the required statement that the Act is inconsistent with the Constitution and again arises the retroactive nature of the bill, but is being included out of an abundance of caution. Clause 4, Mr. President, is the interpretation clause and simply refers to the phrase the Act to mean the Prime Minister's Pension Act. Clause 5 amends Section 3.1 of the Prime Minister's Pension Act and introduce the requirement that a person is required to serve at least 1 year as Prime Minister in order to qualify for a Prime Minister's pension. Mr. President, this is done by inserting the words 1 year from the date of in Section 3.1 as follows. Every person who having been appointed Prime Minister on or before the 31st of August 1962 ceases at any time after 1 year of the date of such appointment to be Prime Minister, shall be paid a pension under the Act, with effect from the date on which he ceases to be Prime Minister and subject to subsection 2. The pension shall continue to be paid during the lifetime of that person. Mr. President, Clause 6 of the bill introduces a tiered system of meritocracy, where the longer a Prime Minister has served, the more benefits they receive in relation to that pension. So, Mr. President, for the benefit of those viewing and those listening, this simply means that where an individual has served as Prime Minister for not less than 1 year, but not more than 2 years, a pension of 1/3 of the highest annual rate of salary paid as Prime Minister. Not less than 2 years, but not more than 3 years, a pension of 1/2 of the highest annual rate of salary paid as Prime Minister. Not less than 3 years, but not more than 4 years, a pension of three-quarter of the highest annual rate of salary paid as Prime Minister. Not less than 4 years, but not more than 5 years, a pension of the full amount of the highest annual rate paid, salary paid as Prime Minister. This government is taking the position that a tiered pension system is necessary to ensure that there is fair and balanced approach for compensation of holders in such a high office. A Prime Minister who has served for 1 year and one who served for 10 years should not walk away with the same retirement package. And leaders should be rewarded based on their length of tenure. And so, Mr. President, that means that from a budgetary perspective and from a fairness perspective, that the public service ought not to carry the burden of the type of remuneration that is being contemplated if this legislation is not approved today. Our failure to amend this and put in the tiered system would therefore require the public service the onerous responsibility of having to carry an existing pension arrangements that will lead, based on one's lifetime, to millions of dollars, beginning immediately. And that is why, Mr. President, this tiered system also reduces the possibility of exploitation or abuse. There should not be a scenario where one receives a lifetime pension benefit having served outside of the tiered system that this bill contemplates. Additionally, this measure will promote the continuity and leadership example that will strengthen public trust and confidence in all of us and in the system. This bill has also been introduced to protect public financing by ensuring that pensions are all equitably given and earned based on merit. Mr. President, we cannot set a precedent where the majority of public officers receive their pension having served specific periods of time and others not. We must be fiscally responsible and prudent, particularly in these challenging economic times. Our taxpayers must be reassured that we are doing what it takes to ensure that public funds are not misused and that public officers all form part of the same system. It goes back to the example, Mr. President, that those of us who sit in higher offices are expected to be held to better standards. In closing, I want to emphasize, Mr. President, that this bill is attempting to correct a wrong that is a glaring example to all of us. So, Mr. President, this bill is proportional, it is fair, it is just, and it is responsible. I wish to encourage my colleagues in this Honorable Senate to support this bill, which is based on merit, to support this tiered structure that is based on fairness, to support this amendment that is based on being responsible and is based on bringing parity across our entire system of compensation. Mr. President, in one of my former lives, I was a human resource director, and I would have also worked across many organizations where we have had to design programs such as this. And I remember I was the HR director for Hilo Food Stores. And we had over 3,000 employees, worked with several unions. In fact, all the majority of unions worked across the Massey Group. And I remember sitting with one of the larger unions. And at the time, we were discussing terminal benefits for persons. And one of the things that we were challenged with is making sure, despite the differences across the groups, different industries, because Massey would have spent from retail and distribution to logistics to motors. We had companies in Barbados, Guyana, Miami, Jamaica. And one of the challenges was to make sure we find an equitable system that would be able to be administered across the entire group. What we are seeking to do here today, Mr. President, is bring back some equity into the system of compensation where public persons or persons who serve in public life are all treated the same. This tiered system brings back that order of parity, prevents political abuse, and maintains fiscal responsibility. So, Mr. President, I thank you, I thank my colleagues for their attention, and I beg to move.
Yes. Honorable members, I shall now propose the question for debate. The question is that a bill entitled An Act to amend the Prime Minister's Pension Act, Chapter 251, be now read a second time. Before I recognize the Honorable Faris Alwari, I'd like us to warmly welcome the children from the following schools who are now located in the public gallery: the Civil Private Primary School and the St. Mary's Government Primary School. Could be warmly welcome. The Honorable Faris Alwari, please.
Thank you very much, Mr. President, and thank you for that acknowledgement of our young audience with us. Mr. President, we have a bill before us today that causes me great concern. Let me at the outset say that I think I must, on behalf of this bench, declare an interest insofar as all of our members who are belonging to the People's National Movement, we contribute 5% of our income to our party to run itself. And therefore, as my submission is developed a little bit further, let me say, therefore, I believe that the subject matter that I'll come to means that there's a potential that some income can come back to us, because I intend to speak about a past prime minister and a prime minister receiving pension. And therefore, I think it proper as a person in public life to declare that interest up front. The bill before us is a bill to amend the Prime Minister's Pension Act, Chapter 251. And that law has been around for some time. It was amended 3 times. In 1976 by Act number 41, and twice in 2019. Firstly by Act number 13, and secondly by Act number 16 of 2019. The law before us in this bill, put forward by the government, has 2 real limbs. The first limb is quite simply to introduce a tiered system for the entitlement of benefits for prime ministers in their retiring benefits. And the opposition has absolutely no difficulty in supporting that 100% in its prospective form. I think it is commendable to introduce a tiered system. It does indeed match up with retiring legislators. It does match up with other laws in the Caribbean. There is some international precedent. The fact that the longer you serve is the more you ought to be entitled, including the office of the Prime Minister, is laudable. It is a legitimate aim, and we do support it. No issues at all. The second aspect of the bill, however, causes deep concern. And as an attorney at law and as a legislator, I am therefore compelled to raise those concerns for consideration. Section 2, Clause 2 of the Act proposes that the law is deemed to have come into effect at a particular date. It doesn't actually use the word retrospective as most laws say, but the point is, and just putting it in very plain English, the law is intended to have effect at a date prior to the sitting, prior to when it is assented to. There's no proclamation clause, so this will come into effect the minute it's assented to. Clause 2, this act is deemed to have come into force on the 10th of March 2025. Perhaps we'll hear it from the honorable members opposite as to why this date was selected. Why was it not 9 years ago, 10 years ago, or not? But if we historically look at the circumstance of where we stand today, there is a very short list of persons who have occupied the office of Prime Minister. As the honorable senator was going to say, and then he was interrupted, Section 76 of the Constitution, which is the supreme law of the land pursuant to Section 2 of the Constitution, is the section of our supreme law that speaks to the appointment of a Prime Minister. The Prime Minister is that person who is the leader in the House who commands the majority and is willing to accept. In our short list of Prime Ministers, those who can receive pension are only 3 in number. They would be former Prime Minister Stuart Young, there would be former Prime Minister Dr. Keith Rowley, and there would be former Prime Minister Mrs. Kamla Persad-Bissessar. I'm speaking prime ministerial terms. I recognize she's the sitting member for Siparia and the Prime Minister of this country. In fact, the last person that is the member for Siparia enjoyed the position pursuant to this law, which we seek to amend, the parent law, of receiving, as a legislator who was a prime minister, but who served in the parliament as leader of the opposition, the honorable member would have been entitled, in the context of this debate, to receiving the salary of the leader of the opposition, and then pursuant to the law, which we seek to amend today, a top-up. The honorable member, by law, was properly entitled to and would receive as a former prime minister the balance of money which would take the sum to what a normal prime minister sitting would be. You see, in 2019, by Acts number 13 and 16 of 2019, we amended the law to say that we would adjust the entitlement to pension for sitting prime ministers, for retired prime ministers, so that they would receive every 5 years a review of salary to keep the RPI index in play. And every 5 years, any former prime minister would have the benefit of an uplift in salary going forward, no back pay. There would only be a go forward every 5 years. And therefore, the qualification of who this bill applies to can only be 3 people in general terms as former prime ministers, That would be Dr. Rowley. That would be the member for Port of Spain North, St. Anne's West, Mr. Stuart Young, SC, and the Honorable Prime Minister in a former capacity. This law in clause 2, in saying that the law is retrospective, it applies in the past from the 10th of March, will therefore only identifiably strike at one human being in the Republic of Trinidad and Tobago, and that is Mr. Stuart Richard Young, Senior Counsel, who is the Member of Parliament for Port of Spain North, St. Anne's West, sitting right now as a former Prime Minister. As we know, that honorable member, as a former Prime Minister, sat for a very short period, 6 weeks. Immediately upon appointment as Prime Minister on the 17th of March 2025, the day after a general election was called, and many people in society quite properly view that as perhaps one day of service until you called an election, but the fact is you go out as a Prime Minister when your successor is appointed and takes office. So it was a 6 to 7 week period. It is indeed a very short period. But any law that we pass has to have certain prerequisites. It must have a legitimate aim. We know there's a legitimate aim in saying there's a tiered system. We support that. We say we support that on a prospective going forward basis. When we get to section 2 and we identify that this law, notwithstanding the fact that no name is called in the law, this law can only apply specifically by virtue of section 2, with the date to come in force being deemed as the 10th of March 2025, it can only apply to one person, that is Stuart Richard Young, Senior Counsel. This bill correctly calls for a 3/5 majority. And there is a general principle of law that I have no issue with. Not every retrospective law is unconstitutional. Not every retrospective law is deemed to be in trouble just because it's retrospective. We pass retrospective laws all the time. Statutory interpretation tells us that. Bennion you can refer to. Multiple cases refer to that. The classic case being Leonage versus the Queen and in 1967, and more recently in the Steve Ferguson versus the Attorney General judgment in the Privy Council on January 2016. And the citation for that is 2016 UKPC at number 2. The question which calls in the use of the preamble of the Constitution is fine. Again, the leading case of Surat, as confirmed by Suraj most recently by the Privy Council, says it's axiomatic that rights will be infringed from time to time. And what are the rights that I'm speaking about, Mr. President? The rights that I'm speaking about are Section 4 and Section 5 rights. So the Constitution of the Republic of Trinidad and Tobago sets up in Section 4 that we recognize and we declare that Trinidad and Tobago has certain rights. And every person has a fundamental human right and freedom, including the following: the right of an individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process. That's 4A. B, the right of an individual to equality before the law and to protection of the law. 4B. D, the right of an individual to equality of treatment from public authority in the exercise of any functions. So we have these established rights. We have one identifiable person, Mr. Stuart Young, member for Port of Spain North, St. Anne's West. We know the law is going to apply to him and to him only. We're passing a law. The members of the government have said that this is a law for general purpose and for the benefit of all persons in this circumstance. But the fact is, that member, Mr. Stuart Young, has a property right which has vested in him. The minute he became the Prime Minister of the Republic of Trinidad and Tobago pursuant to Section 76 of the Constitution, and I will mark that I found it interesting that the honourable member was stopped from speaking about Section 76 of the Constitution. That's something that I'll come back to in an appropriate forum. But the minute that the honourable member for St. Anne's West, St. Anne's North, Port of Spain North, St. Anne's West became Prime Minister, he became, under the law which we seek to amend, which this bill seeks to amend, he became entitled to a property right by virtue of law. The law is the very law which we seek to amend. Now, I want to make a distinction. Our Constitution actually entrenches how people are to be treated in pensions. Section 133 of the Constitution, which is instructive but not fully applicable, treats with the issue of pensions. But it is pensions for public servants. But there's some persuasion that I think is relevant to this debate. Section 133 of the Constitution treats with pensions. It specifically defines that for the purposes of Section 133, a judge of the High Court, a judge of the Supreme Court shall be considered to be a public office holder, and that the President of the Republic is also there. The Prime Minister is not there. The pensions sections of the Constitution, which are deeply entrenched by Section 54, also say that you cannot take away a right, a benefit for a public officer without consent. Now, we as an opposition, having declared our interest, we are aware that there are three things that can happen. We can support this law, we can oppose the law and say no to it, or we can abstain. If you look to the language of the Constitution, Section 133 onward, you look to the fact that a right, a property right, which is properly on the table, the member for St. Anne's West, for Port of Spain North St. Anne's West, has a property right, has an entitlement to a pension, which is vested by virtue of taking the oath of Prime Minister. That was upheld by the Privy Council, the oath taking and entitlements in the Chandra Sharma case. That is now trite law for us. There is a vested property right to this individual. The question is, should it be taken away without consent? Now, there's only one human being, one person who could say, I agree or I don't agree to the right being taken away. And it would save us all a huge problem in the law. And that is, of course, the same member for Port of Spain North St. Anne's West. He could voluntarily say to the world, I accept this position. He has not. And therefore, we in the Senate have to now wrestle with the law. We are flagged and we're aware. We've skirted around it in the piloting of the bill, but it's there. The newspapers say in livid form, expressly, that it attacks one individual. One individual is permitted this reflection. He has not consented publicly or otherwise, as he's entitled to not do. That is a personal decision of the honorable member. However, we are making law under Section 53 of the Constitution for the peace, order, and good governance of our country. And in making law, and in calling in aid Section 13 of the Constitution, Section 13.2, which is that you can, under Section 13.1 and 2, pass a law which infringes fundamental rights. Surratt has upheld that. Suraj has upheld that. Lady Hale is a classical quotation. Not every Section 4 and Section 5 right is one that is so sacred that it can't be trampled, because our Constitution expressly says, if you get a 3/5 majority, you can affect a fundamental right. But the caveat to that is in Section 13 of the Constitution. And when we look to Section 13 of the Constitution, there is a formula which we must treat with. Section 13, which is the exception for certain legislation, 13.2 says, an act to which this section applies is one, the bill for which has been passed by both Houses of Parliament and the final vote thereon, supported by votes of not less than 3/5 of the members. And 13.1 says, if the act so declares that, it shall have effect accordingly, unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. So let me explain Section 13.1. Section 13.1, as it proposes a tiered graduated scale for all future prime ministers, no problems. It's reasonably justifiable. It's explained. People will come in with their eyes wide open. Section 13.1, the reasonably justified in society and respect for rights and freedoms of the individual. We must look at the rights of the individual. Member Stuart Young, member for Port of Spain North St. Anne's West. We know he has a vested right under the law. It's plainly clear. We know that prime minister's pensions were not entrenched in the Constitution. They are only dealt with by the Prime Minister's Pensions Act. The Prime Minister was not declared to be a public office similar to the President or judiciary in accordance with Section 133 of the Constitution, which you cannot change without a 2/3 majority. So we know that in amending this act, we have to look to the rights and freedoms of the member for St. Anne's North, of Port of Spain North, St. Anne's West, North. Good Lord. Minister Stuart Young, previous minister, previous prime minister. Question is, Minister Piloting said, this law is proportionate. It's indeed proportionate, go forward. Is it proportionate as it applies to that member, former Prime Minister Stuart Young? That is very, very, very debatable. In fact, I think it is quite clear that the law runs afoul of a principle of law referred to as ad hominem, against an individual, against a person. Now, I'm going to speak very plainly and simply about what ad hominem means. The dicta that is best in guide to us is the judgment in the Steve Ferguson versus the Attorney General of Trinidad and Tobago and others. It is a judgment of the Privy Council 2016 UK PC number 2. And there is a wonderful exploration of what ad hominem legislation looks like, in particular at page 9. And it refers to, at paragraph 19 under ad hominem legislation, the paradigm case of a statute which infringes both the separation of powers and due process clause is a bill of attainder. Bills of attainder were legislative acts which convicted a person of an offense. The last attempt to pass one was the Bill of Pains and Penalties of 1820. Sounds rather fitting today. Paragraph 20. The objection to a bill of attainder is the same as the objection to the exercise by the legislature of an inherently judicial function. Now, let me accept that Lienage, Ferguson, and the general cases on ad hominem were treating with an issue of separation of powers, where a law was being passed to tell a judiciary, you shall have no purpose, you can't decide something because we have passed a law which will treat it. But today we are passing a law which says to former Prime Minister Stuart Young, you will be disentitled to your pension because we passed a law that says you will not get your pension. That's quite simply what clause 2 of the bill does. And therefore we'd be telling a court, sorry, you can't have a view on this law because there's a law that says we could do this. So you could stretch the argument into a separation of powers argument. You can bring to life the dicta. But listen to what the quotation in paragraph 20 of the judgment in Ferguson was. And they're quoting here from Blackstone commentaries. And Blackstone's quotation is, if I may with your leave, it is a rule, not a transient sudden order from a superior to or concerning a particular person, but something permanent, uniform, and universal. Therefore, a particular act of the legislature to confiscate the goods of Titus or to attain him of high treason does not enter into the idea of a municipal law. For the operation of this act is spent upon Titus only. Substitute that language. The operation of this law will apply to former Prime Minister Stuart Young only. Let's call out the elephant in the room. And if you take Lord Pearce's reflections in the case of Lienage versus the Queen, to be found in 1967 appeal cases 259, we have now to say, can this law be saved on the basis that it is of general purpose? Because there's absolutely nothing wrong with a law of general purpose. In fact, in the Ferguson versus the Attorney General case at the Privy Council, they upheld the retroactive application of the abolition of Section 34 in the face of arguments as to ad hominem, breach of due process, breach of separation of powers, etc. They upheld it because the Privy Council viewed that the law was sufficiently clothed by the fact that it was general in its purport. But the words of Blackstone in referring to the goods of Titus Titus being a ruler of an emperor of Rome, of ancient Rome, the Caesar, a prime minister being a Caesar, it does cause me concern that in this law, there is no gainsaying that there is only one target to the law. Now, if we wanted to look at proportionality and there was general purport, I think we are bound to investigate, well, why are we not amending more than just the prime minister's tiered position retroactively? No problem, go forward. Why are we not amending, for instance, the provisions of other parts of the Parent Act? I referred you, Mr. President, to the operation of this law as it related to another former prime minister. Another former prime minister, pursuant to Section 6 of the Act, is certainly entitled, if I get to the law itself, listen to Section 3 of the Parent Act. If we want to have proportionality, this is of general purport. The aim expressed by the Honorable Minister in piloting said, this is to save taxpayers. I like that. Look at Section 3 of the Parent Act. Every person who, having been appointed Prime Minister on or after the 31st of August 1962, ceases at any time after such appointment to be a Prime Minister, shall be paid a pension under this Act with effect from the date on which he ceases to be a Prime Minister. That applies to three former Prime Ministers, the Honorable Dr. Rowley, the Honorable Kamla Prasad-Visesa, the Honorable Stuart Young. And subject to subsection 2, the pension shall continue to be paid during the lifetime of that person. Accepted. The Prime Minister's pension shall, if the person to whom it is payable becomes a legislator or is again appointed Prime Minister, cease to be payable during the period in respect of which that person is a legislator or holds the office of Prime Minister. As the case may be, but where the rate of the Prime Minister's pension exceeds the rate of salary as a legislator, nothing in this subsection shall prevent the payment of a Prime Minister's pension to the extent of such excess. In other words then, a former Prime Minister, now Prime Minister, when leader of the opposition, received leader of opposition salary, but was topped up to the Prime Minister's salary, but the Prime Minister's salary was enlarged by the 120th report of the Salaries Review Commission. There was song and dance by members opposite that it was obscene, etc. But every single human being in the opposition, now government, has accepted the salary. They, like former Prime Minister Young, could easily agree that they will not take the salary. They could give it to the Children's Life Fund. But until that salary was raised, as former Prime Minister Kamla Prasad-Visesa, forgive me for using it that way, but I'm trying to make it simple, was entitled to, why not, are we not today in the broadening of proportionality and saving the taxpayers saying, most respectfully, go retroactively on that and give the top-up retroactive effect so that the member for Siparia, when serving both as leader of the opposition and as a former Prime Minister, did not receive the top-up. Why are we not doing that? Why are we only retroactively affecting Stuart Richard Young, former Prime Minister? We have the ability, as there's one person to whom Section 3 of the Act applies, that is the top-up. How come we're not doing that if it's so proportionate? How come? Because that member for Siparia is entitled to a back pay of close to $1 million. Is that $1 million any different from the $1 million that former Prime Minister Stuart Young is going to receive? You see, Mr. President, there's a problem with selection in this bill. Why am I raising that? Because it points more and more to the words of caution as far back as Blackstone, talking about the goods of Titus, and as recent as Ferguson versus the Attorney General in the Privy Council on the retrospective effect of Section 34. We cannot make sense of the general purpose. it is barreling into ad hominem legislation. And therefore, as much as an opposition listening to the people will say, listen, Minister Young will be receiving by the life expectancy of 35 years. The honorable member, as a former prime minister, might receive $35 million in 35 years. Yes, I can understand that there's a public sentiment about that. There is an easy escape. Former Prime Minister Young could easily say, I agree to the law, but he hasn't. So therefore, we in this Senate must now wrestle with whether the law we are passing truly meets with Section 13 of the Constitution, because we are using the formalistic approach of a 3/5 majority. We're entitled to do that. The Constitution says if you're going to affect a right, put Section 13 into effect. The Honorable Attorney General, who would have assisted in the drafting of the law, or done the drafting of the law, was perfectly correct in saying that it affects a right. There's a property right, Section 4A. There are other rights inside of Section 4. Go to Section 13, put the preamble that affects rights, pass it with a 3/5 majority. But the problem that we have as a Senate is that we must look to whether this is reasonably justifiable in a society that respects due process and the law. And we know that the case law tells us once you can target the individual in precise identifiable terms, then you're in trouble. And the law targets the individual in precise terms by selecting arbitrarily two things. One, tackle the date as at 10th of March 2025. There's only one person, Stuart Young. But it also omits to treat with a very large benefit that the member for Siparia will receive as a former prime minister in the top-up pursuant to Section 3. And therefore, you have to ask yourself, well, why is the government not coming today to say, well, look, we'll amend Section 3 equally. So is that not one man suffering or one woman suffering? We'll give all former prime ministers the problem. We'll give member for Siparia, the Honorable Kamla Prasad Bisesa SC, the same problem. We will make sure that the taxpayers don't have to pay the $1 million in back pay. We'll make sure that the top-up provisions of Section 3 don't apply. Had you done that, we easy. Because it's the general purport to two former prime ministers, not one. Am I happy to debate this law today? No, Mr. President. Do I have a personal view? Yes, Mr. President. Has the government selected to go into an excursion and exploration of Section 76 of the Constitution? They have not, which is why the leader of government business sensibly interrupted the honorable minister in piloting to say, don't go there, when he was about to read Section 76 of the Constitution. I'm sure. So, Mr. President, we have a tough decision here. We in the opposition, I think we're bound to abstain because we have an interest. If there is a benefit to the honorable member for St. Anne's North, Port of Spain North, St. Anne's West, we stand to benefit by collecting 5% of that. Under the Integrity in Public Life Act, Section 29, we had to declare that. We are an interested party because the PNM receives 5% of that. Do we wish to be in those circumstances? No. Should we participate in something that offers assistance in that debate? I think respectfully, no. So, Mr. President, this is no simple bill. There is the public sentiment, but there's the law. And I can't divorce the fact that I am a lawyer and I have been a legislator for 15 years. So what do we do? Where do we go? It's interesting that we have an independent bench because all eyes have been on them since an incredible attack against the independent bench by the government yesterday. We've dealt with that. We don't need to go there. I think lesson perhaps marked and learned. We're new to this parliament, and I don't think anybody means anything pejorative. Let's start with a fresh slate, Mr. President. But Mr. President, I respectfully believe that the Honorable Attorney General can assist us in better clarification. I confess that it's no easy task. I'm sure for any Attorney General, it would not be a pleasant task to draft a law such as this when you're possibly going to face litigation if the member for Port of Spain North St. Anne's West decides to do so. So, Mr. President, I don't want to say more. I think that I've identified the parameters of the debate. I'll tell you, it gives me no pleasure to have to make the debate in the circumstances that I have, but I want it to be very plain in this. We can either vote for, but we have a problem with part of it. We 100% buy the argument of let's graduate the service, longer the service, more the reward, no problems. Perfectly reasonably justifiable. However, when we get to affecting the individual right of one identifiable person pursuant to clause 2, could only be Stuart Young. As much as you feel one way or the other in the public, the law must apply. Can we participate in law that we believe is ad hominem? There's a big problem with that. But even if we wanted to participate, I think we have to declare that the PNM receives 5% of the salary of Stuart Richard Young as a member who contributes under our levy scheme. So we have a material benefit. We have an interest. And therefore, it would be improper of us to participate in a decision one way or the other. Both the parliamentary rules tell us you must declare an interest at the start, but also persons in public life are bound to declare their interests pursuant to Section 29 in the Declaration of Interest Clause. So, Mr. President, all eyes will be on the Senate today in how we balance sentiment and emotion versus law. Ultimately, perhaps the arbiter will come from the courts, which is why we have the separation of powers. I accept there's a material distinction between the Ferguson matter as it relates to the Privy Council decision and the judicial direction and the arguments on due process and abuse of process, etc. But I think that we need to think carefully insofar as this law is retroactive and says that you are disentitling somebody who's received an entitlement. You're ousting, arguably, in a sense, the jurisdiction of the court by saying, no, court, you really can't change the view on this property right because the parliament decided so, as it can. It's the supreme law, the Constitution. The Constitution says you could infringe a Section 4 right on property if you use Section 13. Section 13 says it must be reasonably justifiable in a society that respects due process and rights of individuals. We have a problem. I look forward to the debate. In particular, I look forward to the contributions of the Honorable Attorney General. He's a very learned man in the law. Certainly on this matter, his parliamentary record will certainly speak to that. So I look forward to the guidance that will come from the government, and I look forward to the debate coming from honorable members on the independent bench. Thank you, Mr. President.
Honorable Senators, we have another group of students, and they are with us. They are from the St. Madeleine Secondary School. Could be warmly welcome. With the cooperation of Senator Vieira, I recognize the Honorable Attorney General.
Mr. President, I know that I recognize that debates in this chamber are, generally speaking, fluid in nature. My leader had asked me to speak later in the debate, but in light of some comments on the law that have been made by my learned friend, Senator Arawi, who served a fairly decent, well, he served a long stint in the office of the Attorney General. I felt it best for me to deal with those I think that some of them are clearly wrong. Some are misstatements of law, and I felt that this was the appropriate time for me to speak to those. Now, the senator spoke extensively from Blackstone's commentary on the law, and he spoke in passing to the Ferguson case. Now, I will concentrate on the Ferguson case in a bit, because in that case, there is a comprehensive discussion and analysis of the couple paragraphs from Blackstone's, including the relevant bit on the goods of Titus and the attainder point. And with the greatest respect, I think that the senator misunderstood or misconstrued or did fail to tell us what exactly Blackstone meant. I'll attempt to treat with that. So if I could begin with the contribution of the leader of the opposition in the other place, because to a certain extent, that has informed the view of Senator Arawi this morning. Now, in the other place, the leader of the opposition did not have a problem with the policy of the bill. She said so on the floor of the House. I heard her say so on the floor of the House. And then when we moved to committee stage, the only objection registered by the opposition in that place was with respect to the retroactivity, the retroactivity provision. Now, as I said that, I believe I recall one of the members, perhaps a member for Port of Spain South, raising an objection on the constitution, the clause which is designed to insulate, protect the bill from attack on the basis that it's unconstitutional. In any event, the policy, she said she had no problem with. And what is the policy of the bill? Well, first of all, we have to recall that the Prime Minister's Pension Act, which is the law that we are seeking to amend this morning, is a 1969 law. So that at the time the 76 Constitution is enacted, we don't use save law for measures which do not potentially affect the Constitution, but it's certainly grandfathered in. It's a saved law at the time the 76 Constitution is enacted. It's good. And why? Because it was legislated, it was enacted in 1969. The Republican Constitution is 1976. Predated the Constitution, it's grandfathered in as part of the body of law that existed at the time the 76 Constitution was enacted. Now, in 1969, if I could just mention some of the provisions, the law sought to make the pension non-contributory. What does that mean? For most of us inside here would recognize that what that means is that the beneficiary of the pension does not pay towards what he gets. Then there is this provision at the end of the law. It's a very short act. So it may be clause 5 or section 5 or 6, which says that the funds to meet the pension come out of the consolidated fund. Now, in 1969, it would not have been a tremendous burden on taxpayers because salaries were $2,000 or $3,000 a month, even at the top end. Exactly. That's a lot. $2,000 or $3,000. That's at the very top end. So the Prime Minister's pension in 69, even on the face of the 69 law, it was not a drain on the taxpayer. Now, less than 60 years later, this is 2025, so that's 96 years, if my math is, no, I'm sorry, that is 56 years, if my math is correct. Less than 60 years later, you have a situation where someone moves from perhaps a pension of somewhere in the vicinity of $30,000 a year. A prime minister entitled to pension moves from a position of somewhere around $30,000 per year to a sum north of $1 million per year. Now, if you read the Hansard, as I did in preparing for the debate here today, you'd see that a bench of giants, as we have here today, Senator Lee Kwai said, but what happens if somebody says, it wasn't Senator Lee Kwai, it was the senator who spoke after Senator Lee Kwai. Cannot recall his name now, but he raised the point frontally. He said, what happens if someone serves for a day? But you'd had a prime minister in office in 69 who'd been there for 13 years. And it was the sense of the Senate and the House that that was inconceivable. Now, the debate went on and the bill was enacted. In 76, the Republican Constitution came. There was no revisiting of this particular amendment. Why? Because the burden, I could just suggest that this is perhaps the reason why. There was no outcry because the drain on the consolidated fund was, relatively speaking, bearable, even in 1976, and continuing thereafter with the reports of successive salaries reviews exercises. What happened was the report of the last SRC. And that report catapulted the prime minister's pay is linked to pension, not under our scheme because, I'll leave the politics aside for the time being, but the pay catapulted and the prime minister's income catapulted to a level, if I am correct, just around the president of the country, maybe even, it's either equal for the first time with that of the president of the republic, or if it is not, it is less by $2,000 or $3,000. Now, I don't want to be held to that. My colleagues who will speak after me can check on it. And that's for the first time in this country. You have an SRC saying the prime minister is making more than the president of the republic, or as much. Because we have a clear hierarchy. The president is the head of state. Whatever you think of the president is the head of state. And we work, all of us are appointed by the president. The prime minister is sworn in by the president. The president is the commander-in-chief of the armed forces and so on. Point is this, that when the salary increased a year or two ago, what happened was that not only was the prime minister's salary the subject of serious criticism out there in the society, because here you have, at the very time that public servants are being told that they must tie themselves to existing wages after a decade of inertia. And I say that knowing that I'm subject to correction, someone will say, well, your wages were not tied to existing wages, they got a 4% increase or thereabouts. The point is that the Prime Minister was the only person in this country to get, at that time, what amounted to a 50% increase in salary. That is a fact. And there was an understandable political outcry. And my learned friends on the opposition benches know that that took place. Once you had that increase in pay, there would necessarily be an increase in pension because the two were linked. In 1969, when salaries were about $3,000 or $4,000 a month. Now, under the Constitution, okay, I'm just being passed a note that reinforces the point that I made. The SRC report jumped the Prime Minister's salary over that, I'm told, of the President. So for the first time ever, the President's salary is $81,000, just under $1 million a year. The Prime Minister's salary is north of $1.1 million. This happened for the first time. Now, when that happened, obviously there was a hue and cry outside in the street. And the after effects of that is this in front here, in part. And they would be disingenuous if they were not to see that their selfishness and their complete callousness towards ordinary workers, those people who work here with us in this place, those people who work with our colleagues in the other place, public servants, nurses, teachers, ordinary people were being said, they were being told, no increase for you. We can't afford it. And if you recall, even the judges of the court, the initial recommendation with them was that they should get no increases. This is the Supreme Court of Trinidad and Tobago. Something was wrong with that. Now, we had a situation where those increases, while there was a hue and a cry outside there, we are peaceful people. Nothing happened. Well, in some countries, I imagine people would take to the streets and express their views on something like this. In this country, as one of my colleagues on the other side said in a different context, the attitude was they ain't riot yet. Well, they didn't, but the people waited. And an election came and the people spoke. And Mr. President, Section 53 of the Constitution says that it is our function as a parliament to pass law for the peace, order, and good government of Trinidad and Tobago. And that is a clause that is in the 62 Constitution when the Prime Minister's Pension Act was passed. And that is all that we are here to do, to pass laws for the peace, order, and good government of Trinidad and Tobago. That is our job. You failed to do it, you paid the consequence of ignoring ordinary people outside on the streets of Trinidad and Tobago. We are not about to ignore them. So that if one gets back to the bill, that's the reason why we are here. Now, the words used by the Honorable Leader of the Opposition in the other place were, she said that there was a lacuna in the law. For those of, no, so she's taken herself out of it, as Senator Arawi took himself out of it this morning. Both of them, in different ways, concede that the provisions of the law are now unjust. That's what they concede when they say that there is a lacuna in the law. Their problem is with respect to it having retrospective effect. Both of them said so. In the lower house, the opposition did not vote against the bill. They voted against the retrospective clause. I think it's clause 2 or 3, the one that says the bill shall have effect in March. They didn't vote on the bill. They conceded that there was a lacuna in the law and that there was nothing wrong with fixing a lacuna. And we agree with them on that. No one can argue with that. There is a problem with this law. The law at present allows a person who was a legislator to collect an income, that's what pension is, an income of $1 million a year after having performed a job for, I'm taking Senator Arawi's calculation without question. After performing a job for 36 days, I think that's what he said. After performing a job for 36 days, you get a pension in that job for 30 or 40 years. And that is the lacuna that they concede exists. Now, the difference between us is this. They say, do nothing. Change the law going forward. Do nothing. That's their position in the other place. That's their position here. Change the law going forward. Because their problem is the fact that there is this clause which says that the law is retrospective in nature. Now, so let's look at that. Senator Rawi says that the retrospect, and I have to deal with this because Senator Rawi said that the law is targeted on one person, and he mentioned the name of that individual. I'm going to be careful because what we say here is going to be looked at, what we said in the law place is going to be looked at by others. I'm the Attorney General. My words will be scrutinized. And I'm going to say exactly what I can say and no more. Senator Rawi said this law is targeted on a particular person. Now, those of us who have any memory of the Ferguson Attorney General case would remember that that is a point that Lord Sumption, a colorful character, dealt with in respect of the AJIPA Amendment, the Administration of Justice Indictable Proceedings Act. The AJIPA Amendment came about because Parliament enacted Clause 34. Who did Clause 34 affect? Mr. Ferguson, I can say that today. It affected Mr. Ferguson and a small class of persons who were affected by the Piarco litigation. That's it. Small class of persons. Now, and it's in that context that Lord Sumption takes us to Titus, on Blackstone, but not in the way that Senator Arawi stated it. Now, I'm not sure if you understand what a bill of attainder is, but I'll tell it. Okay, so Lord Sumption pulls out the paragraph from Blackstone, and he says this, and forgive me if I repeat a bit. He says it's a rule, not a transient. Just let me get. No, he says. I'm sorry. He says the objection to a bill of attainder is the same as the objection to any exercise by the legislature of an inherently judicial function. Now that sentence sort of tells you what a bill of attainder is. A bill of attainder is a law that punishes a specific person or a group of persons without a judicial trial. So it's a bill that comes afterwards and says X is guilty of high treason. Titus is guilty of high treason. Well, and confiscate his goods. I mean, I don't know if a friend got, confused with the word attainder. It's not just a bill. It's a bill that deprives a person, that takes away his access to the court. And it goes on to, what Blackstone is saying is that the objection to any exercise by the legislature of an inherently judicial function, because the court's supposed to tell you whether you are guilty of treason, not the monarch. And so that is how Blackstone phrases it. He's dealing with a punishment. We're not dealing with locking up nobody here. What we are dealing with, our job here today, is to keep faith with the charge the Constitution sets for us. You have to pass laws for the peace, order, and good governance. This is a law that is passed and sought to be enacted for the peace, order, and good government of Our job is not to lock up Titus. We're not locking up anybody else. And more than that, we're not thinking of doing that without access to the court. Okay, that is the first thing that you have to do, access the court. So this has nothing to do. It has nothing to do with Blackstone commentary. It might sound nice to talk about a bill of attainder, but really and truly, it's just not relevant. So, but Blackstone goes on. He says, the reason a bill of attainder is objectionable is that it does not have the essential attribute of law, which is its generality of application. And he describes that as the first principle, first requisite of a law. Now, the Privy Council in Ferguson, and I'm taking Blackstone's from Ferguson because Lord Sumption actually pulls out the paragraph from Blackstone that my friend spoke to. And it was more relevant in that case because there was jail involved for Ferguson and Galbraithsing and others. That is not what we're doing here today. We are discussing and debating entitlement to pension. That is a general matter which falls within the good government of Trinidad and Tobago. Now, Lord Sumption goes on to say these words. He says, after he deals with Blackstone and what is objectionable retrospectivity, and he says objectionable retrospectivity is dealing with someone's access to justice. That's what he's saying when he speaks of a bill of attainder and titles. Don't lock up someone, or don't have someone at risk of being imprisoned without giving that person the benefit of passing a law, of having him know what is against the law, and above all, the executive should stay out of the business of passing retrospective legislation to lock up people. That's what he is speaking about. Now, and I know that because Sumption goes on to say, direct interference with judicial proceedings is, however, rare. And then he says, more commonly, legislation impinges on them indirectly by altering general rules. Now, and he gives examples. They might change the elements of a tort, take away a special defense, alter certain rules of evidence, interfere with a relevant period of limitation. And he says that where those things occur, then you have not objectionable retrospectivity, but you have a greater challenge. Objectionable retrospectivity is locking up people after the fact. But he says where these types of things occur, then you have something that is maybe more of a challenge. And I know he says that, he means that, because he says it. He says this kind of legislation gives rise to more difficult problems. He says, why is that the case? Because it is general, not particular. In Blackstone's terms, however, he says, it is a law, not a sentence. So you're not sentencing Titus to a period of time in jail. You're not sentencing anybody here to anything. And in that regard, he speaks about the principle of retrospectivity. And he says that you begin with the fact that it is just a presumption. He says that in Ferguson at paragraph 24. He says there is a presumption against retrospectivity. And understand that when he says there's a presumption, what he is saying to us is not, don't do your job to pass good legislation. He's saying that when it comes to him and the exercise of his judicial function, he's going to look at what we have done and begin with a presumption that the legislation can't be retrospective. That's his job, looking at what we do. We have a duty to pass law for the good order of Trinidad and Tobago. Now, it's important to look at what he says at paragraph 24, and I have to belabor these points because he says, this is no more than a principle of construction. So you begin with a presumption, but right away you tell yourself, it's a presumption. It's not a rule, not a hard and fast rule. And we know that he is saying that because he says, this is no more than a principle of how I approach construing legislation. And then he says these words, once I establish as a matter of construction, mere retrospectivity does not violate the separation of powers or the rule of law, is not contrary to due process, then I have a more general question to ask myself. Now, he speaks about cases like this, what he describes to be politically controversial cases, because if you remember the challenge in section 34, I mean, there was a hue and a cry, a public outburst, and the legislature was called back 2 weeks after the law was enacted. And I commented to deal with that point about vested rights, because once the law was enacted, rights became vested immediately. But the government of the day came back 2 weeks later and said, how many? Okay. The government of the day came back 2 weeks later and they said, we made a mistake. We vest rights in people. We've taken away those rights. Those are vested rights. Rights that were vested were taken away after the fact by retrospective legislation. Do you know by who? By members on this side. We recognize that we erred in Section 34. We recognize that we erred. We came to this parliament and we said, we pass in a law retrospectively because we have a duty to pass laws for the good order of the country. And there was a lot of debate in the society. You can't do that. The rights are vested. You can't interfere with those vested rights. We did it. And the case went right up to the Privy Council. And the Privy Council said, yes, that was not objectionable retrospective legislation. That is what happened. And the court dealt with that argument about focusing on what they said. I suppose my friend says that this law affects one person, but it's not written in that way. And the law in Ferguson was not written in that way. It was written to cover every person, including X or Y or Z or others who fell into that category and who might come to be in this position in the future. So what the Privy Council says there is that although framed generally, in practice, the law before them applied, because that's what we did when we changed the law. It applied only to a limited category of persons, including the appellants before them. And then they said, well, really, it's targeting them ad hominem. But the court says, this is manifestly not the case. Why? Because it does not only look like general legislation, it is general legislation. It affects, and this is important, all cases to which Section 34 would otherwise apply. And then this bit is crucially important. Past, present, or future. And that tells you, that's the complete answer to this argument that this is ad hominem. The Privy Council is saying that the test to determine whether something is ad hominem is whether as a matter of substance, not form, whether as a matter of substance, the legislation speaks to all cases to which the section would otherwise apply, past, present, or future. Mr. Speaker, I'm sorry, Mr. President, that's it. One of the parents are moving up and down. Last week, Friday, I was there. But, Mr. President, that is the complete answer to this legislation being ad hominem, it being retrospective. And it is captured in the remarks of one of the most brilliant jurists that we have had in this century, in Lord Sumpshire. He's the one who decides Ferguson and Galbraith's. A very interesting character. And I say that the decision in Ferguson, which my learned friend cited but skirted around, the decision in that case answers all of the objections that have been made by my learned friend, and that what we are about today is not punishing any person. We are about doing our business in faithful reliance to Section 53 of the Constitution, which requires us to make laws for the peace, order, and good government of Trinidad and Tobago. I thank you, Mr.
Senator Vieira.
Thank you, Mr. President. I would like to begin my contribution with a reminder about the rule of law. Now, I know many of us are aware of the rule in a general way, but as legislators, it may be useful to remind ourselves that the rule of law is fundamental to peace, security, and political stability. The rule of law demands that all persons, regardless of race, religion, or station, must be treated equally and are deserving of equal protection under the law. The rule of law prevents the abuse of state power. It requires that the law be followed by all, and it ensures that legal rights are fulfilled in practice. The rule of law is a fundamental principle underpinning our Constitution, which, as we all know, is the supreme law. The rule of law is a lighthouse to avoid the rocks. It is against this backdrop that I rise with considerable unease at the precedent this bill will be setting. My first concern relates, as I foreshadowed, to the rule of law, because at its core, this bill undermines the rule of law, specifically at the principle of legal certainty. The rule of law demands that laws be general, prospective, and known in advance, not retrofitted to remove entitlements after they have been earned under existing law. Now, I think we heard about Ferguson, but if memory serves me right, in Ferguson, no vested legal rights had accrued before the appeal. Lord Bingham, another brilliant mind, in his seminal work, The Rule of Law, emphasized that laws must be applied equally and fairly, not arbitrarily to disadvantage specific individuals. As I hope to show, this bill is fundamentally in conflict with the rule of law and should not be contemplated by any government which has respect for the rule of law. My second concern relates to the bill's retrospective nature, and this is and should be deeply troubling. In the well-known and highly respected text, Maxwell on the Interpretation of Statutes, the 12th edition at page 216, quoting from one of the most well-known statements of the rule regarding retrospectivity from the judgment of Justice Wright and Ray Alfmundley, it is written that, and I quote, "Perhaps no rule of construction is more firmly established than this, that a retrospective operation is not to be given to a statute so as to impair an existing right or obligation, otherwise and as regard matters of procedure, unless that effect cannot be avoided without doing violence to the language of the enactment." End of quote. And this is in accordance with the general principle that current law should only govern current activity. And there's a host of case law on this. So when I see legislation purporting to enact the retrospective deprivation of benefits already earned, I am troubled, because that offends settled constitutional and administrative law practice. In the case of Wilson against First County Trust Limited, number 2, 2003, UK House of Lords, the House of Lords confirmed that retrospective legislation interfering with vested rights is constitutionally suspect and must be justified by compelling public interests. I don't see any such justification in this bill. In fact, in Trinidad and Tobago, prospective application of salary or pension reductions is the settled norm, as reflected in the long-standing practice of the Salaries Review Commission and related statutory instruments. To do otherwise, as this bill seeks to do, is an affront to the fair administrative practice and the dignity of office. My third concern flows from a cluster of facts. Given that this legislation pertains to prime ministers, of whom we have only had 7 since independence, given the timing of the legislation, given the proposed time frame for a person to serve as prime minister in order to qualify for prime minister's pension, given the retrospective effect from the 10th of March 2025, and given comments in the media. For example, in the Express newspaper dated 18th June 2025, it was reported that, and I quote, "The government will today introduce legislation in a move designed to deny former Prime Minister Stuart Young a prime ministerial pension for life." In the other place, Legal Affairs Minister Saddam Hussein is reported to have said that it cannot be deemed fair for an individual to serve as a prime minister for a minimal period and subsequently receive a lifetime monthly pension of $87,000. He was critical of the fact that an individual could serve as prime minister for as little as 5 seconds, for 5 days, or 5 months, and upon ceasing to hold office, immediately become entitled to a lifetime pension of $87,000 per month. As an example, the Honorable Minister cited former Prime Minister Stuart Young, who, having been appointed in March, would have qualified for this substantial lifetime pension, despite serving for less than a month before the PNM electoral defeat to the United National Congress. In moving the bill, the Honorable Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance spoke of a set of very peculiar circumstances. He spoke about one parliamentarian receiving generous payments for life, regardless of length of service. Now, I accept and agree with Senator Alwari's reasoning and conclusion that this law will only apply to former Prime Minister Stuart Young. As he put it, there's only one target to this law. I'm not going to rehash so as to avoid tedious repetition. So given all this, I can see no escape from the conclusion that this bill is plainly ad hominem, aimed at a specific individual, the Honorable Stuart Young. And this must ring alarm bells in this Senate, because ad hominem legislation undermines parliamentary integrity. Lord Cook warned in Fraser against State Services Commission, 1984, 1 New Zealand Law Reports, page 116. He warned against legislation targeting individuals rather than setting general rules of law, stating the power of legislation is not a license to victimize. Now, history isn't a study of the past. It is the study of change. And in this vein, permit me to cite two examples drawn from legal history that illustrate ad hominem legislation, that is, laws targeting specific persons backfiring with unforeseen consequences. The first example pertains to the Act of Attainder against Thomas Cromwell in 1540. Now, as many of you may recall, Thomas Cromwell, chief minister to King Henry VIII, engineered the English Reformation and the king's marriage to Anne of Cleves. And when Cromwell fell from favor, Parliament passed an Act of Attainder against him, convicting him of treason without trial. Attainder was a legislative tool to punish specific persons, stripping them of life, liberty, and property without judicial process. But there were unintended consequences. First, the Act of Attainder established a political precedent of fear. Cromwell's execution set a precedent for using Parliament to settle personal or political scores. And this bred fear among the nobles and the councillors, weakening the stability of Henry's later reign, as loyalty became rooted in survival, not duty. Secondly, it undermined the judiciary. The use of attainder eroded the role of courts in ensuring due process. It later fueled a constitutional crisis over arbitrary legislative punishments. And thirdly, it laid the groundwork for what we call reciprocal vulnerability, as those who sponsored attainders soon realized that they themselves could be targeted. For example, the Duke of Norfolk later faced an attainder under Henry VIII. And finally, it triggered long-term constitutional reform. The misuse of attainder contributed to public and legal revulsion against such ad hominem laws. By the late 17th century, they were seen as instruments of tyranny, and they fell into disuse. Long story short, Cromwell's attainder exemplifies how laws targeting individuals rather than general conduct undermine legal predictability. They breed political insecurity, and they degrade the rule of law. This event is well documented in English constitutional and legal history as a classic example of ad hominem legislation producing destabilizing and unintended consequences. My second example pertains to the Roman Lex Julia de Adulteris, passed in 18 BCE. When Augustus Caesar became emperor, he passed the Lex Julia de Adulteris ostensibly as part of his moral legislation to promote public morality and social stability. However, while the law appeared general, in practice, it was targeted at his daughter, Julia the Elder, who was prosecuted under it for adultery and exiled. Now, that law also reaped unintended consequences, including erosion of Augustus's public image. It caused public sympathy for Julia, and it painted Augustus as a hypocrite. Roman citizens saw the law as an instrument of political control rather than moral reform. More than that, the law triggered social destabilization. Elite families became fearful that private conduct could be criminalized if it conflicted with imperial interests, and that it undermined loyalty to Augustus's regime. Worse, it became a political precedent for personalized law by normalizing imperial use of legislation to target rivals or disfavored family members. Long story short, this example demonstrates that laws targeting specific persons, even if cloaked in general language, can undermine legitimacy and public trust in our political institutions. My fourth concern should be a familiar refrain because lawyers often raise it in the courts. And this is the matter of reasonable and legitimate expectation. Mr. Young, upon acting as Prime Minister, acquired a legitimate expectation under the Prime Minister's Pension Act to receive the pension attached to that office. This doctrine was affirmed in Council of Civil Service Unions against the Minister for Civil Service, 1985 appeal cases at page 374, where Lord Fraser noted, and I quote, "A legitimate expectation arises either from an express promise or by reason of established practice," end of quote. Now, the practice in Trinidad and Tobago is that any person appointed or acting as Prime Minister qualifies under the Act, unless legislation, and this is a word, prospectively, not retrospectively, changes the entitlement. A fifth concern relates to the constitutional status of prime ministerial emoluments. As made clear in the explanatory note, the Prime Minister's salary, pension, and conditions fall under the Salaries Review Commission remit by virtue of Section 141 of the Constitution. And this is why a 3/5 majority of all members of each House of Parliament is required. Now, on this point, the ruling in Devant Maraj against the Attorney General of Trinidad and Tobago is instructive. The High Court, per Justice Rampasad, the High Court held that it was unconstitutional for Cabinet to alter the Senate President's terms and conditions without recourse to the Salaries Review Commission. And so by parity of reasoning, Parliament should not unilaterally alter the pension terms for the Prime Minister, an office falling under the purview of the Salaries Review Commission, particularly on a retrospective and targeted basis. My sixth concern relates to what is described as the slippery slope. That is to say, a course of action likely to trigger a series of other events leading to undesirable or extreme outcomes. Simply put, today it's Mr. Young. Tomorrow it could be any other office holder. This utilitarian approach, focusing on what is expedient or politically palatable in the short term, it risks eroding the constitutional guardrails that protect us all. In my opinion, if this bill is allowed to pass, we in the Senate will have to take responsibility for establishing a bad precedent. This is a moment when we should be thinking instead of ceding control to political impulses. The objective of this bill is to deny a certain person equal protection under the law. And that constitutes, in my opinion, an invidious discrimination. We need to understand the peril of this moment and that there is a significant hidden danger. When political parties see their counterparts as enemies rather than as political rivals, democracy is untenable. I am sorry to be so blunt, but it is my duty to describe the situation as I see it. We took an oath, and this is about being true to the oath we took. an oath set out in the first schedule of the Constitution, that we will uphold the Constitution and will conscientiously and impartially discharge our responsibilities to the people of Trinidad and Tobago. A seventh concern pertains to the fact that this bill is inconsistent with other statutes. For example, the Prime Minister's Pensions Act, Section 3, entitles any person who has held the office of Prime Minister to a pension at the prescribed rate. The amendment seeks to disapply this to appointments under a certain duration, contradicting that clear wording. The Pensions Act, which guarantees accrued pension rights for public officers, this bill subverts that underlying principle. And the Statutes Act, which requires clear and general drafting, this bill's targeted language is arguably inconsistent with the generality and clarity expected in legislative drafting. My eighth and last point pertains to the broader constitutional values at stake here. It behoves us to remember that constitutionalism is not merely about power, but restraint. When the law produces inconvenient outcomes, our duty is not to change it ad hominem, but to abide by its terms, amending prospectively, not retrospectively, where justified for the public good. This bill offends fairness, certainty, and constitutional propriety. And so for these reasons and in these circumstances, I respectfully urge all senators to consider whether the passage of this bill will not, in the fullness of time, prove corrosive to the very constitutional democracy we have all sworn to uphold. Ultimately, this is not about whether one likes or dislikes the former Prime Minister. While this way of thinking may be jarring to some people, this is not about quantum. Whether the former Prime Minister gets 8,000 or 80,000 is irrelevant. This is about constitutional rights. The Constitution protects rights regardless of popularity. Courts have warned against a referendum on rights mentality where benefits already earned become hostage to the next election cycle. A pension vested under law is not a privilege subject to public opinion or to party manifestos. When clawback is driven by campaign promises and majority sentiment, the retrospective provision becomes a political act, not a constitutionally valid one. And that's a very serious issue.
Thank you, Honorable Senator, for giving way. Earlier in your presentation, you may have quoted from an Express newspaper and quoted the member for Barrett area San Juan having spoken about an individual in a certain manner. I have checked, and the honorable member did no such thing. The Express report was wrong, and you can check the answer. So I know that you are a man of fairness, so I would want you to just correct the record so that that would not be used to make a point about ad hominem. Thank you.
Well, I didn't read the Express, and I did not. So I was relying on a report, and if what you're saying is accurate, I will withdraw that particular aspect, and I thank you for the guidance. But I want to come back to the point that this may seem like a little thing, but this is a very serious issue we're dealing with here today. And Parliament has a duty. We have a duty to act fairly and legally, not punitively. Retrospective adjustment is permissible only for fraud, misrepresentation, calculation error, or demonstrable inability of the state to pay. In Ray Harry Suknanan, a 1989 decision, the court held that genuine fiscal impossibility may justify a temporary reduction, but mere policy regret will not. Fiscal or policy regret does not reach the threshold of reasonable justification. So in conclusion, I sincerely urge members of this honorable House to weigh very carefully and to exercise caution on whether you will support or reject this bill. And I would put out these reasons again just by quick summary. In my view, this bill undermines the rule of law and legal certainty. It ignores the constitutional remit of the Salaries Review Commission. It is retrospective ad hominem legislation, which is improper. It erodes the doctrine of legitimate expectation. The law is always a balance. It's always a balance between competing and sometimes incompatible ends. And when we consider legislation, we must always be mindful of the broader implications for good governance. In my respectful opinion, the attempts to justify this bill are specious and unsatisfactory. No amount of moral disagreement can undo a pension lawfully earned outside of fraud, misrepresentation, or fiscal impossibility. And even then, it is the state that bears the burden of proving this. Under our Constitution and the rule of law, no one should get special treatment. These are fundamental pillars of democracy. They require an even-handed application of the law. We must live under the rule of law, not the rule of men. Thank you.
Senator Candace Simmons. Joan Simmons, thank you.
Thank you, Mr. President. Warm congratulations are due to you on your elevation to this esteemed office of President of the Senate. I would also like to take this opportunity to express my heartfelt thanks to the President, Her Excellency, Ms. Christine Carla Kanglu, for granting me this opportunity to serve as an independent senator. It is a privilege and an honor, and also a solemn responsibility. And it is from a deep sense of responsibility and a commitment to the adherence of the rule of law in the legislative process that I feel inspired to rise today to contribute to this debate on a very important matter. Now, Mr. President, the government has presented us with the Prime Minister's Pension Amendment Bill, which seeks to amend Sections 3(1) and 4 of the Prime Minister's Pension Act. The current Prime Minister's Pension Act, enacted in 1969, entitles a Prime Minister, regardless of the length of term of service, to a lifelong pension equal to the highest salary earned during his or her tenure. So a person who is appointed Prime Minister for 1 day, 1 week, 1 month, 1 year or more is entitled to the full amount of this salary, which is now, I believe, $87,847. And it is this figure which has caused a lot of concern. Under this act, there is no minimum service requirement. And there is nothing unique about that, Mr. President, because there is precedent for that in other jurisdictions. We've heard before in the other house, Barbados, Jamaica, and Guyana, to name a few. In those jurisdictions, there is also no qualification for eligibility. The role of a Prime Minister is crucial. The office holder is the head of the government. That person shapes national policy. They lead the executive branch. They manage national security matters, foreign affairs. It is a role of significant responsibility and also carries incredible personal sacrifice. So we can all agree that it is a role where the benefit of a pension must be commensurate with the obligations of the office. And the current legislation recognizes the significance of the responsibility and the sacrifice. Now, this current act,
Someone's, please. Sorry.
so, Mr. President, this current act was passed on July 23rd, 1969, and has been in force for 56 years without challenge. So it begs the question, what is the need for the proposed amendments? Section 5 and 6 of the amendment bill changes two key significant provisions. Section 5 amends Section 3(1) of the Parent Act by introducing a 1-year minimum service requirement. Section 6 amends Section 4 by implementing a tiered pension system based on the length of service. So the structure where a prime minister's eligibility is based on the length of service also is not unique, and there's precedent for that in other jurisdictions. Permit me to go through the proposed tiered structure. So a prime minister who serves essentially 1 to 2 years under the proposed legislation would get 1/3 of the full salary, 2 to 3 years, a half, 3 to 4 years, 2/3, 4 years plus the full amount. Now, since achieving independence in 1962, Trinidad and Tobago has had 8 individuals serve as prime minister. Now, of these 8 individuals, 7 have met the proposed minimum threshold of 1 year and have served for at least 4 years, thereby entitling all of them, save for one, to the full amount of the highest annual rate. So under the proposed legislation and the current legislation, the entitlement for almost all of the former prime ministers remains the same. So again, where does the mischief lie? What is the problem that we are seeking to fix? What is the bill targeting, or who? What is the mischief? The answer lies in the recent unprecedented circumstances of the 8th Prime Minister. In fact, the Honorable Attorney General said it was something that before was seen as inconceivable. And now the inconceivable has arrived. Now, this 8th Prime Minister, whose tenure in office did not meet the proposed minimum 1-year threshold, in fact, the tenure was just under 2 months or 42 days, that person is now eligible for the full pension. And the government has sounded an alarm on this matter. And we must be honest about that. And has decided to address this issue through legislative reform. And that is why we are here today. Most of us are aware of the public sentiment on this matter. In a reference to the amended bill, permit me, Mr. President, to refer to the Express newspaper on June 26, 2025, a prominent attorney is reported as saying, "No one is so stupid or disingenuous not to vote for this proposed bill." But I want to say, Mr. President, that a person who has misgivings is neither stupid or disingenuous. I agree that the proposals in this amendment bill for a minimum threshold of 1 year service and a tiered system of eligibility are reasonable, they're balanced and proportionate. No one could argue with that. It aligns with practices in other jurisdictions. And so I have no difficulty at all in supporting a bill that introduces these requirements and is intended to apply to all future prime ministers. In this way, the legislation is prospective. The general rule applicable in most modern legal systems today is that laws must be applied prospectively. That means the law will only change things in the future. Prospective laws are considered, and we've heard this reinforced today, by by Senator Vera, that prospective laws are favorable because they are considered to be fair, because they allow individuals to understand the rules that they need to follow so that they can adjust accordingly. So this brings me to my concern with the bill. My concern also lies with the fact that the provisions of the amendment bill are intended to come into effect from March 10th, 2025. This gives the bill retroactive effect. Another concern is that the inclusion of this commencement date appears to affect a specific individual who has served in the office of Prime Minister. Let me state at the outset that no one, regardless of office or reputation, is above accountability. However, accountability must be pursued within the bounds of legality, fairness, and constitutional propriety. The bill in its current form raises concern on these three counts. First, the retroactive nature of the proposed law. It undermines foundational principles of legal certainty. The rules regarding public service entitlements must obviously be clear and prospective. To change the law after the fact, reaching backwards to affect rights already accrued, not only offends this principle, but it sets a dangerous precedent. The Honorable Attorney General reminded us that we are not here to lock up anybody. But what we are doing is taking back rights. Both are objectionable, in my view. It should be noted that the current legislation, although passed in 1969, was amended by Act Number 41 of 1976. And while the 1976 legislation was retroactive, it conferred benefits. It didn't revoke any rights. However, this bill seeks to do just that. Constitutional propriety demands scrutiny. Secondly, the bill may be unconstitutional because Clause 3 of this amendment bill expressly states that it is inconsistent with Clauses 4 and 5 of the Constitution, and therefore it requires that the bill be passed by a special majority. And in these circumstances, I want to say to all of us here today, it is our collective responsibility to scrutinize the proposed legislation to ensure that it doesn't violate legal norms. Pensions granted by law form part of the legal rights of office holders, and to claw back those rights might constitute not only a breach of the principle of non-retroactivity, but also a violation of property rights and natural justice. And it may open the door to potential litigation. We're walking towards it. Thirdly, the bill has the hallmarks of ad hominem legislation. And we've heard that phrase before. And we know that ad hominem legislation targets a specific individual rather than applying generally. Laws must be framed in a way that they are impartial. And if we as legislators begin to draft laws to deal with persons rather than principles, we're going down a slippery slope that could undermine the very legitimacy of this very House. Today, it may be a former Prime Minister. Tomorrow, a public servant. Another day, a person who falls out of political favor. Where does it end? So some may be willing to depart from these well-established legal principles in the pursuit of righting a perceived wrong. But do the ends justify legislating retrospectively to correct the perceived unfairness? This is the question that we must answer. We must balance equity, Mr. President, with legal principle. We must be careful not to support political grievances cloaked in the language of reform. To be clear, I fully support prospective reforms to ensure fair treatment and avoid this issue in the future. But I ask us all to consider what we've heard here today and choose responsibly. And with that, Mr. President, I thank you.
Allow me to extend congratulations to Senator Candace Jones Simmons on her maiden contribution. I recognize the Minister of Labor, Small Enterprise Development and Micro Enterprises.
Thank you, Mr. President. Today I feel like in a courtroom. I've had the pleasure of listening to lawyer after lawyer after lawyer. Mr. President, I recall, I'm not no lawyer, but I recall at some point in time, some place I heard the maxim that where equity and the law is in conflict, that equity must prevail. And someone, in case it need little, or little, or brush it up, but I just remember my memory, I recall that need to allow equity to reign supreme over all that we do. Because if not equity, then what? We have had laws throughout this. I'm not purporting to be a lawyer by any stretch of the imagination. I'm talking here as a layman. But we have had laws throughout our existence that was wrong, that was unfair, that was unjust. Everything was legal at some point in time, including slavery. Didn't make it right. And sometimes we just had to do what is right. So that, let me leave the law alone and go back to my human people matter now. I'm dealing with the people matter. Senator McNeish, the legal matter, from where I sit, equity must prevail. So thank you for allowing me, Mr. President, to contribute to this important debate on the Prime Minister's Pension Amendment Bill 2025. I rise today in resolute support of this legislation, not merely as a cabinet minister, but as a citizen determined to defend fairness, sustainability, and fiscal responsibility in how we govern and serve the people of Trinidad and Tobago. What this government proposes today is a reasonable law. I want to stress, is a reasonable law. And let me be clear, what previously existed under the Prime Minister's Pension Act was not reasonable. It stood as a glaring contradiction of equity, justice, and fiscal prudence. A law that permitted lifetime pension benefits immediately upon appointment, irrespective of how fleeting or ineffective that service may have been. Mr. President, what this bill seeks to do, three vital things. One, it introduces a minimum service requirement of 1 year for eligibility. Two, it implements a tiered pension structure that scales entitlements based on years served as Prime Minister. Three, it aligns our Prime Minister's pension with international best practices. This is not merely bureaucratic housekeeping, this is fundamental reform. What is a pension? Fundamentally, pensions emerge to ensure income security in old age, promote workforce renewal, and recognize long-term service, principles that continue to underpin pension systems worldwide today. The goal has always been fairness, predictability, dignity. Yet for decades, as we all have acknowledged, the very laws we entrusted to guard that dignity did the opposite when it came to the highest office in this land, or the next highest office outside of the president, of course. I'm talking about political office. I'm talking about a case for fairness and consistency. In today's Trinidad and Tobago, fairness in pension arrangements is elusive. Let us consider what our ordinary worker must endure. Because we spend a lot of time here today. I like the level of energy and commitment to fighting the cause of the one. But we have a responsibility to fight the cause of the many. If we are to give justice to why we are here today, and any day and every day that we are here, the law must serve the interest. This is a democracy. That's what this is here. It must serve the interest of the many. So when we look at the ordinary worker, what do we see? A public servant must serve at least 10 years before qualifying for a pension. At least 10 years. That worker must serve 33 and a third years to receive a full pension. And Mr. President, and even then, that full pension is no more than 2/3 of his base salary. So a lifetime of service, modest reward. And that base pay, by the way, excludes any kind of monthly allowance. So if you're receiving other kind of compensation outside of your base pay, it is not considered for pensionable benefits. If you contrast that with the former system for the prime ministers, we're simply being appointed, however briefly, entitled one to a full pension at the highest salary ever earned. And just to note, the prime minister's pension is pegged, as we all know, to the incumbent prime minister's salary. When the incumbent prime minister's salary goes up, the prime minister's salary will go up also. Where is the proportionality in that? Where is the justice in that when compared to what the ordinary public servant has to endure? Mr. President, just this weekend, I want to get the human back why we're really here. Just this weekend, because we're talking about pension. I received a text message, a WhatsApp message. And the WhatsApp message, I want to read it out for you that with your leave, Mr. President. The message goes this way. Hi, pleasant day, Mr. Minister. I retired from WASA in April 2025, and I am not getting a pension from WASA each month. I am pensionless. I work 18 years and waiting on NIS still, which is taking a long time. I'm sick at the moment. I had a stroke recently, and I desperately need your help in getting a WASA pension every month. Can you talk to someone to help me, please? Thanks and God bless. I didn't call the person's name. That person was a hospitality assistant at WASA. That person worked 18 years of their life to that organization. That organization sent this person home without the possibility of a pension. At 60 years, they would have left that organization. And that person now have to what? Fend for themselves. Mr. President, that's the real world. That is what's happening. We're talking pension. I'm making all kind of nice defense. I didn't come here to talk about persons. I come here to deal with the bill. But a lot has been made out of a case for a person by dealing with the bill. And I hope that people understand this pension we're talking about. And this is the country that we live in. Where people, not just this one person, in many organizations, state-run enterprise, the HGC, WASA and the likes, people are working for 10, 15, 20 years. And they are not entitled to a pension when they reach age 60. And they're sent home to fend for themselves. And when we wonder what is going wrong with the country, what is going on with the country is not the justification of whatever people are justifying for whoever to get what. Here, today, is when we're not taking care of our people. Because that's what pension is. It was meant to give persons dignity in old age. That's what it was intended for. Not what I hear people trying to justify here. It was intended to give people dignity in old age. This is the human face of inequity. A woman who can give 18 years of her life and is now struggling to live. We have daily rated workers. I know that Senator Dan Paul will be aware of that, right in the central government. Daily rated workers. Since 1994, the PNM administration promised daily paid workers that, hey, they will treat with a pension plan for these workers. These workers work, and at age 60, they are sent off without a pension. Each and every one of them. Mr. President, that's a problem we have in this country that we have to address. And that must be contrasted to what obtains for a president, for a prime minister. That somehow we are comfortable saying one day equals $1 million for the rest of your life every year. When we treat with the average worker, collectively, thousands of workers under central government that are simply not entitled to a pension. Needless to mention, Mr. President, this whole pension issue, I reflect of how Caroni workers, since 2003, they're still waiting for terminal benefits when they were sent home. Up to now, people are dying without ever receiving their terminal benefits. I am not a lawyer, but I think I know what's right and wrong. There's some simple rules in life, you know, do unto others, do unto others as you'll have them do unto you. Those are simple rules. Or as we say it, if it's good for the goose, it ought to be good for the gander. And Mr. President, so when we have a situation with Caroni workers, you have the petition workers still in a dicey situation because they have stopped all contributions going to their pension plan. So right now, that's looking on the way to find themselves without pension in the not too distant future. That's part of the reality. When I, as a Minister of Labor, stand here to talk about pension, I talk about what is fair for not the one, but for the many, for the people of Trinidad and Tobago. Mr. President, where leadership ought to inspire confidence, it has bred contempt. Where service ought to be recognized, it has been ignored. The PNM administration found creative ways to fix the PM's pension, yet found none to address the cry of the average worker. And I make no apologies when I say fix. I don't covet. I just, if it's good for one, it ought to be good for all. I've seen what has happened. We all have eyes. Using the SRC, what happened with the Prime Minister's pension, they get a nice bounce to the youngs. When others were being told 4%, some people get 47%. But nothing wrong with that. When they took the housing allowance and they appended to the base salary and it becomes part of the pension of the Prime Minister, probably nothing wrong with that. But what I know, you can't, they say if your conscience condemn you, then God greater than your conscience. We have things that we must know what is right and what is wrong. Do it, fix yourself if you wish. But my God, that is when you have all workers that are suffering out here. You have where in places like the WASA and HDC, people are leaving. They work at a acting position, and then when they retire in lower substantive position. In other words, there is no matching of their pension with what they would have been enjoying all the years of their lives. When we want to ensure that we make sure that the retail price index is pegged somewhat to the PM salary to ensure that every 5 years he could get an updated pension. That is not applied to no one else in our community, to absolutely no one else. That is wrong. And I'm here simply trying to support good law. What is good law? Try to make it somewhat reasonable. Nothing that this government is in fact proposing on behalf of the PM salary would disadvantage anyone. No one. What people have sat here and attempt to justify one way or the next, from where I see it, just wrong. No one could justify a fleeting 6 weeks equal $1 million a year. That simply cannot be justified, not to the taxpayers of this country. Not to the taxpayers of this country. But more than that, Mr. President, I have looked to see if what is being proposed here is somehow unreasonable. So I look at the international best practices, and let me tell you what I have seen. I look at Australia, and under the Parliamentary Contributory Superannuation Act in Australia, a Prime Minister must serve at least 1 year in office to be eligible for a pension. I didn't stop there. Additionally, the pension is based on the year service as a Prime Minister and as a Member of Parliament. So it's prorated according to the year service. I went to South Africa. Under the Presidential Pensions Act, a president must serve at least 5 years to qualify for a full pension. At least 5 years to qualify for a full pension. If the president serves less than 5 years, but more than 2 years, he may receive a proportionally reduced pension. So in South Africa, they too have a prorated pension. I went to Singapore. You know, everybody like the Singaporean model. That's a thing people just love. Singapore, best thing since sliced bread. When you look at Singapore, a person must serve at least 8 years of reckonable service as an office holder, including Prime Minister, to be eligible for a pension under the Parliamentary Pensions Act. The pension is based on years of service with a cap at 2/3 of the highest annual salary held. So he never receives no 100% of his salary as a pension. It's capped at 2/3. You go to Canada, the Canadian Prime Minister are eligible for a special retirement allowance. Again, a special retirement allowance, for him to qualify for that, that individual must have held the office of Prime Minister for a minimum of 4 years. I went to Germany. For German chancellors are entitled to a pension after at least 2 years service. The pension amount increases with additional years service, reaching the full amount. You have to work at least 8 years to get the full amount.
Wow.
These nations affirm the principle that we are enshrining here today. Pensions must be earned Let us not romanticize this. There is real money at stake. Every dollar spent on premature, unearned pension is a dollar taken from schools, from healthcare, from roads, to fix our water supply, for social grants, for the vulnerable in society. Grants, food. This bill reverses that. It restores proportionality and plugs a long-standing leak in our fiscal plumbing. Mr. President, today's amendment is not a cure-all, but it is a signal, a firm and reasoned one. It tells the country what leaders demand for themselves. They must be willing to extend the principle to others. This law narrows the gap between how the Prime Minister is treated and how the average worker is treated. It aligns pension rewards with actual national service. It lowers the fiscal liability for taxpayers. And yes, it brings our pension framework closer in line with the very ILO standards and global norms that we have subscribed to. Let us not frame this bill as an attack on any individual, past or present. Instead, let us celebrate the principle it affirms, that in the Republic of Trinidad and Tobago, privilege must never outpace responsibility. And benefits must always be tethered to service. The law we seek to pass today is reasonable. It corrects what was unreasonable. It is progressive, responsible, and long overdue. I commend it to this Honorable Senate without reservation, Mr. President.
Honorable members, I would like to propose that we suspend at this time and we return at 1:35 p.m. This sitting is now suspended until 1:35 p.m.
Oh yo yo yo, oh yo yo yo, oh die die die, oh die die die. Them care, na. Yes, I love up my country. I love up Monday to Friday, come Sunday night. Yeah, say I love up my country. I love up. Oh, them can't burn we, them can't run we. No, yeah. Hold it high, the red, black and white. True, thick and thin, we just stand unite. We forged from fire, this our land. Firm hand in hand is these two islands where creed and race does stand as one. From the African to the Tassa drum, the motherland, so I say it proudly. Don't matter where I go, I still love up my country. Monday to Friday, come Sunday night. Yeah, yes, I love up my country. Oh, them can't burn we, them can't run we. No, yes, I love up my country. Monday to Friday, come Sunday night. I still love up my country. Oh, them can't burn we, them can't run we. No, sing Trinidad and Tobago, Trinidad and Tobago, Trinidad and Tobago. Them can't burn we, run we, na, singing Trinidad and Tobago, Trinidad and Tobago, Trinidad and Tobago. Them can't burn we, run we, na. First and foremost, I want to say big up my Trini massive worldwide, all my Trinidadian people. I was born at Trini, I was raised at Trini, and I go dead at Trini. And knowing as a Trinidadian, I wouldn't feel right without leaving earlier with something to chip to. Come now! Eh, oh yo yo yo, oh yo yo yo, oh die die die, oh die die die. Them care, na. Yes, I love up my country. I love up Monday to Friday, come Sunday night. Yeah, say I love up my. Hey, look bumper, push the bumper, look bumper, wind up the bumper, look bumper, check bumper, look bumper, wind up the bumper, wine bumper, yes the bumper, come now, hey. Off the plane in Piaco, kiss my hand and you touch the ground, Coco Jambi and Limbo, we just trip when we hear the song. How you mean, is no place else I go consider home. All I need is sweet soca and the song we create. Baby, how you sweet so, hips to the tempo, girl I can't let go. Your body is a temple, girl I love it up bad, blessed be a vessel. And I know. Wherever I stray, my love for you never go. You ran, love up from me. Scarborough. Love her from me, love her from me. Togo White to Arima, San Fernando Moruga, Port of Spain and Zaparia, Caranage Barataria. Nowhere as sweet, all creed and race come together unique. Yes. Carnival jump up and wine in the street and then come on Ash Wednesday pillow on the beach. Whoa. What's the scene? The vibes run nice to horror sketch yet how you mean we moving right the gal them spice we West Indies is six like peas them know them can't touch we. We stand as one red, white and black fires of hope. We know in fact that if them come we now go run pour up some rum, raise up the flag and sing it Lord I love we. Lavante, love her from me, love her from me, love her from me. Maraval, love her from me, love her from me. Rigo Martin, love her from me, love her from me, love her from me. Point 14, love her from me, love her from me. Charlottesville, love her from me, love her from me, love her from me. Kaisabah, love her from me, love her from me. Sawa, love her from me, love her from me, love her from me. Chigonos, love her from me, love her from me. Hey, 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 hey. Look bumper, push the bumper. Look bumper, wind up the bumper. Look bumper, check bumper. Look bumper, wind up the bumper.
Some says are small, nothing you do can stop me. So go with your heavy vibe, move them things from around me. More than corn off the thought me well, how to pray and to break this by the sea. Put my name in a fish belly, lighting candles and burning oil, so my reputation could spoil. They're mixing all kind of potion, so I won't get the promotion. Make way, make way, make way, make way. I got work to do, plenty work to do. Make way, make way, make way, make way. I got work to do, plenty work to do. Put my name in a scorpion nest, them things so without walking. For my spirit to be restless, them things so without walking. To slow me down like a snail, them things so without walking. Anything they try going to fail, cause them things so now walking on me. They're using technology, the picture on the flash drive. Scrolling TikTok looking for me, cause they want to see me on a live. But that virus corrupt the files and make the computer freeze. They deleted all of their lives, now my success can make them like bees. Make way, make way, make way, make way. I got work to do, plenty work to do. Make way, make way, make way, make way. I got work to do, plenty work to do. Good time and name on a cow horn. Them things so without walking. They could close the day I was born. Them things so without walking. Boy, my name in a crab shell. Them things so without walking. Go mountain casting spell. Them things so without walking on me.
Na 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 na. Supposed to be almighty again. Na 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 na. Na 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 na. Well, let me tell you about little Miss Hard to Get. She look good in every vet. She got all the mail, you know she turn it on and she whine it correct. She look like she in a mood. She got me don't know what to do. I isn't punchy and touchy, baby, got something to tell you. You look good, your skin smooth, your waistline just full of attitude. Show me what else you can do. I'm just here to take your stress away. You look fine, the way you whine, I wish you was mine. Me and you just having a good time. I just want you to hold on for me, push back, wind up for me. She liking my company, she like how I got, she get to know. Hold on, push back, wind up. She like my company, she like how I got, she get to know. Na 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 na. I wind it on, Miss Hard to Get, I jam it on. Miss Hard to Get, I grind it on. Miss Hard to Get, Miss Hard to Get. Lordy, Lord have His mercy. Where you wind up on me, you hypnotize me already. Oh, you're whining slow, the way how you bubble it low. You got me asking politely, baby, rest upon me once more. She really doing a lot, she really touching the spot. She got she hammering into my head, running through just like my thoughts. She tell me that she live alone, she put her number in my phone. She introduced me into her home, and I tell she to hold on for me, push back, wind up for me. She liking my company, she like how I got, she get to know. Hold on, push back, wind up. She like my company, she like how I got, she get to know. Na 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 na.
corruption back and I'll die away. In short, this is what I have to say. Let us forget fights and grudges and concentrate. Come, let us sit and try to relate. Because now, more than ever, we must show discipline, tolerance, and production to build a strong and better nation. I say that is the main foundation. So come, let us work hand in hand, because this is our land. Come, my brother, come, my sister, and let us build a nation together. Oh, yeah. Remember, the key to success is working hard. For our country we must have regard. Forget all your differences, let we start to build. And onward to progress we surely will. Because now, more than ever, we must show discipline, tolerance, and production to build a strong and better nation. I say that is the main foundation. So come, let us work hand in hand, because this is our land. Come, my brother, come, my sister, and let us build a nation together. Mm-hmm. Mm-hmm. So much of things that we need to see about. Surely I do have to spell them out. Cause you know as well as I do, the only way is put in more effort and less play. Because now, more than ever, we must show discipline, tolerance, and production to build a strong and better nation. I say that is the main foundation. So come, let us work hand in hand, because this is our land. Come, my brother, come, my sister, and let us build a nation together. Mm-hmm. Mm-hmm. This also goes for every Trinbagonian who going to live in a foreign land. Now is the time to come home and do something, instead of staying out there and freezing. Because now, more than ever, we must show discipline, tolerance, and production to build a strong and better nation. I say that is the main foundation. So come, let us work hand in hand, because this is our land. Come, my brother, come, my sister, and let us build a nation together. Mm-hmm. Mm-hmm.
and civilization. They do not know what we are capable of. No race has the last word on culture and civilization. Because my work has only just begun.
Up you mighty people, up you mighty people, up you mighty, up you mighty, up you mighty.
Feel it down in your soul till you can't control it. Put your hand up to the sky, mama don't ask why. In these dark and lonely times, we gon' turn the tide. If you're looking for a sign, turn and look inside of you. Your body is a temple, your sweat is holy water. Every move you're making is praise unto the master, yes. Yeah, 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 yeah. Because you're powerful, powerful, inside, outside, wonderful, magical, beauty, can't hide me and you, never lose, trust me, can't lie, hopeful, hopeful, till the day we die. Whoa, powerful, yeah. Oh, my beautiful people, full of wonder, wonderful. Whoa, powerful, yeah. Oh, my beautiful people, full of wonder, wonderful. Up you mighty people, up you mighty people, up you mighty, up you mighty, up you mighty people, up you mighty people, up you mighty people, up you mighty, up you mighty, up you mighty people, up you mighty people, up you mighty people, up you mighty, up you mighty, up you mighty people, up you mighty people, up you mighty people, up you mighty, up you mighty, up you mighty people.
Every world know that we coming through. Coming from this out of the archipelago. We have soul and colorful for soul. But them mashing up, we good living, we don't live so. Call your neighbor them. Rise we name again. State your claim again. Tell them we go rain again.
Because you're powerful, powerful, inside, outside, wonderful, magical, beauty, can't hide me and you, never lose, trust me, can't lie, hopeful, hopeful, till the day we die. Whoa, powerful, yeah. Oh, my beautiful people, full
tell me Indians and Negroes unite. We have won the battle for human rights. Out of years and tribulations, we built our nation. Trinidad and Tobago is ours, black and white. Now the land is mine, the sea is mine, the hills beneath the sun that shine, where steel bands play for limbo dance and carnival, stick fight and bongo. I like to hear me call it too. I jumping up his pet for soup at carnival. Freedom for many, many years. We suffered and we struggled through blood, sweat and tears. Now Masha Day is over, we won the victory through Dr. Eric Williams and Dr. Capildale. They tell me Indians and Negroes unite. We have won the battle for human rights. Out of years and tribulations, we built our nation. Trinidad and Tobago is ours, black and white. Now the land is mine, the sea is mine, the hills beneath the sun that shine. I eat in rice and peas, crab and kalalu, me roti and me dal puri, shana bara and pulari. God bless us all and make us free forever, 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 forever.
One more time. If we have any older folks here, sing the chorus. Education, education, this is the foundation. Our rising population needs sound education to be recognized anywhere you go. You gotta have your certificate to show to enjoy any kind of happiness. Knowledge is the key to success. Children go to school and learn well. Otherwise, later on in life, you go get ready. Without an education in your head, your whole life will be pure misery. You're better off dead. For there is simply no room in this whole wide world for an uneducated little boy or girl. Don't allow idle companions to lead you astray. To earn tomorrow, you got to learn today. Hit it. For employment, yes, employment, you must be intelligent. It's essential, very essential, to have your credentials. Remember, if you're block-headed like a mule, no one will employ a fool. You will be the last one to be hired, and the very first one
to be fired. Children go to school and learn well. Otherwise, later on in life, you're gonna catch real hell. Without an education in your head, your whole life will be pure misery. You're better off dead, 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 dead. For there is simply no room in this whole wide world for an uneducated little boy or girl. Don't follow idle companions, or we will get burned. To earn, you gotta learn. You gotta learn. Illiteracy is man's greatest enemy. So it's your duty, yes, your duty, stamp it out completely. Ignorance always impedes progress. Education saves you much distress. Learn, 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 learn as much as you can. This nation's future is in your hand. Children go to school and learn well. Otherwise, later on in life, you're gonna catch real hell. Without an education in your head, your whole life will be pure misery. You're better off dead, I mean dead, dead. For there is simply no room in this whole wide world for an uneducated little boy or girl. Don't allow idle companions to lead you astray. To earn tomorrow, you got to learn today. It's a treasure, yes, a treasure, beyond any measure. So secure it, just secure it, don't ever ignore it. I said to find life's battles, come what may. Education will light up your way. Without it, you'll never, never, never get through. Success or failure now is up to you. Children go to school and learn well. Otherwise, later on in life, you're gonna catch real hell. Without an education in your head, your whole life will be pure misery. You're better off dead, dead, dead. For there is simply no room in this whole wide world for an uneducated little boy or girl. Don't idle like the companions, they lead you astray. To earn tomorrow, you got to learn today.
Don't take we off. Don't take we off. Experts. Don't take we off. Viking. Tell them leave we on the stage. On the stage. On the stage. Tell them leave we on the stage. On the stage. push my hand up like the gases from a Vespa. Everybody let me see you. Tell them leave me on the stage, on the stage, on the stage. Let them leave me on the stage, on the stage, on the stage. Yeah, this whole place come mash up. If they come in to take way off, whole place come mash up. If they come in to take way off, the whole place come mash up. If they come in to take way off, whole place come mash up. If they come in to take way off. Hey, after all of that money that I don't save myself, 1 more minute on station, misbehave myself. The truck ain't ready yet, let me parade myself. A few more seconds isn't illegal. Give me 1 minute extra, just a minute extra. Let the papers catch me in the colors and me texture. Want to push me rag up like the gases in a Vespa. Everybody push up all your hand. Wow, whole place come mash up. If you come in to take way off, whole place come mash up. If they come in to take way off, the whole place come mash up. If they come in to take way off, whole place come mash up. If they come in to take way off, hey, if you want a proper visual, if we on the stage, we will treat it like a ritual. If we on the stage, even down to the residual. If we on the stage, we know the pattern it habitual. Hey, this is our hyper energy before the lunch. Before we sit down in the shade with champagne and we fudge. You get your cameras and you can film it in a one take. Here we begging for an extra minute for the sunset. Check out every color scheme, you see it's not a mistake. Every girl up on the scene is sweeter than a kiss. Security is on the stage and they pointing to this way. And all we want to do is come and display. So if we on the stage, on the stage, on the stage. Tell them if we on the stage, on the stage, on the stage. Wow, this whole place come mash up. If they come in to take way off, whole place come mash up. If they come in to take way off, whole place come mash up. If they come in to take way off, whole place come mash up. If they come in to take way off, mash up, mash up, mash up, mash up. Mash up, hey, mash up, mash up, mash up, mash up.
This is Caribbean Vibes.
I dream I was in Africa, and I was a warrior, hunting lion and tiger, brave like my forefather. And when the darkness gather, we sit around a fire, telling of the bravery and courage of our great ancestors, and we chanting. And freedom surround me, food and wealth in a quantity. If I could go back to Africa, then I could be a great hunter. Running, swimming, climbing, or on a fire dancing. Women washing and singing. You can hear their voices echo in the wind. Chanting, oh, oh, oh,
This is Caribbean Vibes.
One day the village fell in grief. Was the death of the tribal chief. The chief had a son named Mutuba, who was to take over. But then came another warrior who claimed to be the next ruler. He tested their skill in a battle, and Mutuba was the winner. So the crowd chant,
Who's next? Johnson. Who's next?
Courtney McNeish, please.
Mr. President, I stand here this afternoon somewhat between a rock and a hard place. I stand here hearing contributions of other members. And as an industrial relations and human resource management practitioner, I too live by the maxim that equity trumps the law. That guides my practice. Facts and equity. What do we have before us today? This amendment is twofold, as we have all been told. The introduction of a tiered system of pensionable earnings to be applied retroactively. As far as I am aware, a pension rarely is about deferred earnings for past service. Particularly that would apply where there are contributions to that pension plan. In this case, there are no contributions, But it is still about compensating for service. So therefore, I see absolutely nothing wrong with the model proposed. Nothing is wrong with it. As a matter of fact, to me, it is the best practice. We are aware that the proposal to effect this amendment retrospectively impacts one individual, one former prime minister. And if I take a bit out of what Senator Arwari said, it is very possible we would not be engaged in this discussion this evening if that particular individual had said, I don't want this, I don't deserve this, I've only served as prime minister for 30 odd or more days. That is no service, and therefore I will let it go. If he had said that, we wouldn't be here today. It is not my business to say what he should do. But by him not doing that, we are now caught in a discussion of what is fair and what is the law. Let's kind of look at them as best as I can. No, I am not an attorney. I'm legally trained, but I'm not an attorney. But everybody understands what fairness is as far as I'm concerned. As far as I am aware, retrospective legislation is not totally unconstitutional. There are circumstances, situations, and events that can justify them. We have heard the lawyers and the attorneys here speak about those circumstances. Is it this situation of compelling public interest? Now, how do we determine whether it is? And is a situation or condition of compelling public interest, does it justify retrospective legislation, even if it impacts on the rights of others? I challenge anyone here to walk outside, go around Woodford Square, go down Federal Street, up Charlotte Street, come to my community in Couva. This particular matter is certainly, in my view, of compelling public interest. I got calls yesterday from people who I thought were friends. One of them tried to disguise his voice, but I recognize him. Yeah, I recognize him. And saying to me, Courtney, you cannot let this man get $1 million a year for 30 years service. That's what he told me. I got another call where she identified herself with the same thing. This particular matter, in my view, the country is looking at us in this parliament, in this chamber, as to what we will do, and it could go both sides. Senator Vera, who I have the most respect for, spoke eloquently about the slippery slope. If it could happen now, then it could happen then. And what will happen? We will lose the essence of what the rule of law is. But how can I stand among my colleagues, my compatriots, my professionals, and justify $1 million a year for a month and a half of service? That is why I'm between a rock and a hard place. Mr. President, the Attorney General told us our obligation is to create laws for peace, good order, and good government. That is undisputable. Are we risking peace if the legislation as it now stands takes effect? Given the noise that I am personally hearing around this issue in the country. And this is not only political activists I'm talking about, Mr. President. Are we risking good order if we allow the legislation as it now stands to take effect? I do not believe, I, however, accept completely the Attorney General's view that retrospective legislation, and this is my understanding of what he said, could be deemed unconstitutional only if it impacts some penal sanction or tracks. I'm not sure whether I understood him correctly, but this is my understanding of what he said. But I'm certainly convinced that as a body charged with responsibility of making laws, we must ensure that the laws that come out of this chamber treat with the standards of maintaining peace, good order, and good governance. What has happened in this country, and I accept the AG's view, that there is a hole in the law, there's a loophole in the law that we have allowed to exist for 56 years. Why? How? I wasn't here, most of us weren't here. Why we allowed it to continue, even though there's evidence in the hands that somebody say, hey, what if somebody served a year? There was naivety then, and probably still existed up to very recently. That's a very highly improbable state. But that would hardly happen. And the reason why my belief is we sought not to address it was because we thought it would never happen. But if we are good lawmakers, we have to look at every single possibility. Every word of ambiguity, we must try to bring specificity to it so that we are not caught with our pants down sometime in the future. I do not think, therefore, that the government attempts to apply this law retroactively is obscene or objectionable. I think the government is attempting to plug a hole that existed so that fairness and equity and good governance could prevail. That is my view. I'm also of the view that it is in these circumstances, it is reasonably justified. It is justified on the simple grounds. You didn't serve, you don't deserve it. That to me is justice, regardless of what the exact wording in the law said. As I said before, I come from a background where there are parts of the Industrial Relations Act that tells you, that demands the adjudicators in that jurisdiction to look beyond what the letters of the law is, to look beyond the technicalities of the law and speak to the facts, speak to the truth, speak to the justice of the case. In this particular case, I've asked myself, the one person who's affected, does he deserve it? Because I had to break down all this, I really had to cleanse it from my mind. Is it deserved? Is he being denied something he deserves? Notwithstanding what the law said. And I have come to the conclusion that he does not. He has not served, and therefore, this pension, which is in fact to reward service, should not, in my view, apply as the law is written. I don't intend to take up much time because I wrote a whole long contribution, Mr. President, yesterday. The phone calls were disturbing me. But after hearing many contributions, I abandoned everything I wrote. Everything I wrote. I'm certainly impressed by the contributions of Senator Harari. I want to thank the AG for his clarification. And may I add, Mr. Attorney General, thank you for your sentiments this morning. I really appreciate it. I think each and every one of us, particularly here on the independent bench, must make that call for themselves. I have made it, I have cleared it up in my mind, and therefore I have no objections to the legislation for amendment as proposed. I thank you, Mr. President.
Yeah, may I recognize Senator De La Bastide, SC?
Thank you, Mr. President. Mr. President, as we've been told, the purpose of the bill is to ensure that a former prime minister only receives a pension under the Act if he has served at least 1 year as prime minister, and that the amount of his or her pension is tied to the length of his service or her service. Under the Act at present, Mr. President, a former prime minister is entitled to a pension equal to the full amount of his highest annual rate of salary paid to that office, which, as I understand it from my fellow senators, about $87,000 a month. So that, as we have heard, even if a prime minister is sworn into office on one day, resigns on the next day.
Mr. President.
Mr. President.
If I may, on a point of order, just ask for some clarification, because I think we have to be very delicate with respect. I heard please, I'm not speaking to you. Mr. President,
Yeah. Yeah. Everyone, apart from yourself, knew. So I'm prepared to give the leader of government business the space, even though I've set some rules down. In this instance, if you could get to your point of order quickly, I'll appreciate it.
Mr. President, what I want to say is that I heard my very learned friend say in his opening that the bill applies to a former prime minister. And I don't know if that is fair to say at this stage.
Well, that's a point of elucidation or clarification, not a point of order. Continue, Honorable.
What I mean is that the bill, if passed, it would apply to Prime Minister who ceased to hold office, and it would grant that person a pension under certain circumstances. The Act, at present, gives that person who would have ceased to hold office a pension if on one day, no matter how long they had served. So I was just making the point that if they were sworn into office on one day, they left the next, they would be entitled to a pension in the amount of $87,000 a month. They would have that. And so that, Mr. President, is a startling for me, and I think for most people. It's a startling proposition. I would say it's a disturbing proposition. And I think for all of us here, it strikes as being quite unfair. As Senator McNeish had said, it's undeserved. I think that's what most right-minded thinking people would come to the conclusion, that it's undeserved. And that when we ask why, simply because we all understand that under the usual pension arrangements, the issue as to whether you get a pension and how much it would be is tied to your length of service. Now, so I think it is commendable that the government have brought this bill to rectify things, if you like, to make sure that someone who leaves office, the office of Prime Minister, that the pension they get will be determined by their length of service. I think we all agree on that. But I think the only issue here is that the bill has a prospective element. It applies to all future persons who leave the office of Prime Minister. But it has a retrospective effect as well because of the clause that says that of the bill that says it takes effect, I think, from the 10th of March. And the question is, ought that to be included in the bill? Now, Mr. President, it means with that clause, it means that any Prime Minister who has left office after the 10th of March will no longer have the right to a pension under the Act as it stands now. And there's only one person, as we know, that as of today has left the office of Prime Minister since the 10th of March. And there is no doubt in my mind that the Act has the effect of depriving him of property and without compensation, and I think in my view, without due process of law. And that would impinge on his right under Section 4A of the Constitution, of that fundamental human right. But the effect of, Mr. President, but I don't want to get too much into case law and so, because I know as non-lawyers, when we talk too much about case law, one's eyes tend to glaze over, and it's like any other technical area. If it was a civil engineer talking, I might have the same effect on me. But I think as we're talking law, I have to go into it to a certain extent. And I'm relying on the Privy Council decision in Dominic Suraj against the Attorney General of Trinidad and Tobago, 2022, UKPC 26. I'm not going to try not to get too technical, but what the Privy Council was saying is that it is not every little impingement on one of the human rights in the Section 4A that is going to constitute a contravention of that human right. It's not going to make it unconstitutional, because we have a lot of laws that are passed by a bare majority that impinge in many ways on one or more of those rights. And if you needed a constitutional majority to pass each of those laws, or laws that do that, then you would be restricting or hindering the function of Parliament, which is to pass laws for good governance and so forth. So the Privy Council, they set down a criteria by which you apply to test whether or not a particular legislation that impinges on one of the constitutional rights does so in a manner which amounts to a contravention, if you like. And the test that they put down was a 4-part test. You have to look and see whether the objective of the legislation is sufficiently important to justify the limitation of the fundamental right you're dealing with. You have to look at whether it is rationally connected to the objective, i.e., whether the legislation is rationally connected to the objective that it is seeking to achieve. The third thing is whether you could achieve that objective in a less intrusive manner than the manner in which the particular provision does. And then finally, whether having regard to the matters and to the severity of the consequences of the measure, a fair balance has been struck between the rights of the individual and the interests of the community. And so I talk about the constitutionality of the provision in this bill, which makes it retroactive, because I think if it is unconstitutional, if it does breach Section 4A, that is something that one should, as a legislator, one should take into account. One should, if one can, form a view as to whether whether that provision breaches one of those fundamental rights. Now, and it's certainly, I mean, as a lawyer, I am able to do that. Perhaps I'm more equipped to do that than other persons. So that is how I approached it. And I'm not saying that if it does breach one of those rights, that I would vote against it, because of course, one would have to decide whether you would vote for it on the basis that if it was a 3/5 majority, it would pass. So if you wanted to join such a majority. But certainly, I looked at, first of all, whether it is constitutional and whether it passed that criteria or whether it met that criteria. And the first one is whether the objective is sufficiently important to justify the limitation of a fundamental right. Is it sufficiently important well, first of all, we define what is the objective, Mr. President. The objective is to bring into line the terms on which the former Prime Minister would receive his pension, i.e. his pension entitlements, to bring that into line, to adjust it in a manner that it makes it fair, to adjust it in a manner that makes it fiscally prudent, that his terms are fiscally prudent from the point of the state. We heard from the Right Honorable the Minister of Labor about the inequity of the Prime Minister's salary pension being as it is as compared to the rest of the country. And I think he put it he made the argument very well. And so the objective of the bill, to the extent that it is retroactive, is to rectify that inequity. And it is a startling inequity. that you have people who maybe are working every day. Some of them are, as the minister said, are going without pension. Also, we have taxpayers who are, maybe they're paying taxes, maybe they're earning 10,000, 12,000, so they pay some tax over the 7,500 limit, they're struggling. And their taxes are going to fund a pension that is being given to someone who has done maybe 30 days of service, but who is walking away with a pension of $87,000 a month, and they maybe are not getting a pension. And so I think the aim of the objective of the bill is to rectify that kind of inequity. Is the provision rationally connected to the objective? Yes. If we want to rectify it, if we want to rectify that inequity of someone who has already left office getting that sort of windfall, this is the only way to do it. Whether a less intrusive measure could have been used, I don't think so. If we had said, for example, that someone, a prime minister, had to fulfill 5 years of service before getting any pension, one could say, well, that's going too far. Let's give him, as we have done in this bill, let's give him a graduated amount as his years of service build up, 1 year, 2 years, 3 years, 4 years, and so forth. So I think on the final criteria or criterion of the test, whether it is proportional, I think it is proportional, given the stark inequity that the present act creates. The Prime Minister, or the former Prime Minister in this regard, in this case, is a legislator. He will have a pension, as I understand it. He gets a pension as all members of the House of Representatives do. So in my view, Mr. President, I don't believe, I could be wrong, the courts could hold me to be incorrect if it's ever challenged, but I don't believe this, in this case, when you apply the criteria in Surat, you can come to the conclusion that in taking away the right of the former Prime Minister to his pension is a contravention of his human rights, or his, in particular, Section 4A. It does impinge on it, but it's not a contravention of that right. Now, I apply this now. Okay, so I've determined it's not, in my own mind, it's not unconstitutional, it doesn't breach his right. Of course, I still have to determine whether, albeit constitutional, is it a law that we should have? Should this provision be retroactive so as to deprive him of that benefit? And I apply the same criteria. And I come to the same criteria as in Surat, I would apply to the question. And I come to the same answer. I think, given that it is given its objective, and it's a valid objective, and its proportionality, I believe that it's a law that should be passed. Now, a lot has been said about ad hominem, and that this law is ad hominem. Let's assume it is ad hominem. When you look at, Mr. President, when you look at the decision of the Privy Council in Steve Ferguson against the Attorney General, 2016 UKPC, when they looked at the whole issue of ad hominem legislation. If you read it closely, you will see it quite clearly that what they are saying is that just because legislation is ad hominem doesn't make it unconstitutional. It is only where, by virtue of it being ad hominem, that it breaches the principle of separation of powers, does it become unconstitutional. We have three arms of the state. We have the judiciary, we have the executive, and we have the legislation. Now, in some cases where legislation is ad hominem, it breaches the principle of separation of powers because it usurps the function. Passing such legislation would usurp the function of the courts. The legislature would be usurping the function of the courts. And we've had the example of the Bill of Attainder, where the legislation being passed is something to the effect of declaring that a person is guilty of X or Y or Z and has to be punished. Obviously, in a case like that, it's ad hominem, but it's unconstitutional because it is usurping the function of the court to determine who has committed a crime or who is liable for this or that and setting the punishment. I think there was another interesting case which shows that it doesn't have to be as direct as that to be ad hominem and to be in breach of the separation of powers and therefore unconstitutional. They refer to a case of, this is the same Privy Council in the Ferguson matter. They refer to a case of Leonage against the Queen, 1967. AC 259. Now, in that case, there's a case out of Ceylon. A group of persons had attempted to, they had conspired to effect a coup d'etat, but they were found out before it happened, and they were charged. But before they were charged, the legislature passed laws that affected, that impacted directly on their prosecution. So, for example, legislation which authorized the detention of without warrant of persons suspected of having waged war. They modified the elements of the offense. They modified the mode of trial and the rules of evidence applicable to it. They prescribed a heavy minimum sentence for those convicted. And then it was expressed to be retrospective so as to cover an abortive coup d'etat. It also contained a sunset clause, so that all these modifications would come to an end after the trial. So you'd have a special law for these persons to be tried under, and then it would end. So the Privy Council held, well, that's obviously ad hominem, and it's obviously affecting the proceedings, the court proceedings. And therefore, you're interfering with, in a sense, you're interfering with the prosecution of these persons. And it's targeted at them. The Privy Council held that even though their names weren't called, given all the circumstances, in particular the sunset clause, it was targeted at them. So I'm just referring to those cases to show that just because something is ad hominem doesn't mean that it's unconstitutional. It has to have the effect of usurping the functions of the court. Now, in our context, there are no proceedings. This legislation doesn't affect any court proceedings. It fixes the law. So I heard it said that this law is telling the court what to do. But all laws tell the court in the future what to do. Well, not what to do, but what the law is. So once there is no proceeding going on, we can't say this is ad hominem. You can say, and therefore not unconstitutional. You can say that it is ad hominem, and therefore you have a problem with it being ad hominem, and you object as a legislator to that. But we can't say that that this is unconstitutional because it's ad hominem. And I mean, like Mr. McNish, I had a whole, Senator McNish, sorry, I had a whole speech, but I'm going to leave a lot out of that because I don't want to bore all the non-lawyers with my legalese. And I know that this legislation comes in a certain context. We've just had general elections. There's been a lot of campaigning and so forth. And we're reminded that a lot that, the opposition on this side, because they didn't do X, Y, and Z, and I know all of that, and that's fine. But I think in determining whether this is really ad hominem, we have to be careful because, and we have to separate all of that political noise and see whether it is justifiable for a government to say, as a matter of policy, we want these terms to be applied not only to persons who may leave office in the future, but to anyone who may leave office in the past. Now, it may be that there's only one person, but that doesn't mean that I'm targeting you. Because in a different scenario, a government, there may be two or three, there may have been 2 or 3 different persons who would fall into that category, and the government may backdate the legislation to cover them because they want a policy that no prime minister should receive this kind, no former prime minister should receive this kind of benefit. And I don't have a problem with that, subject to constitutional limitations and subject to being a situation where retrospective legislation is justified. It may be that I don't know. It may be that the government it's for political motives and they want to target this one and it's being vindictive. But I'm looking at it from just on the face of the act, and even if as to whether that would be a justifiable policy, and even if that policy is informed in some way by some kind of vindictiveness, I can't assume that. And I have to look and see whether, is this a policy that should apply to persons in the past? Would it be unfair for a person in the recent past to walk away with this? Would it be achieving the public, a legitimate public objective that the law be rectified so they don't get that kind of boon, and not just future? And I have to say that it is justifiable. No, I don't say that lightly, because while there is nothing unconstitutional simply because legislation is retrospective, I think that it is something that generally we should try to avoid. And there is in law, there's a presumption against, when you interpret legislation, there's a presumption that it's not intended to be retrospective, but this clearly is. Mr. President, can I ask how much time I have?
And the 2:31, sir.
Because I haven't been paying attention to that. I listened with a lot of, I have a lot of respect for Senator Vera, and I think he made some substantial points, but I don't, with respect, agree with him. He talked about the rule of law, and he seemed to suggest that because this is retrospective, it undermines the rule of law. But the rule of law, you have to consider what the law is, and the law allows for legislation to be retrospective. So simply because this legislation is retrospective, I don't see that we are undermining the rule of law. He said, Mr. President, the fact that I'm addressing his points I think is a compliment to him. I think there are substantial points that I had to think about and answer. He said it created a bad precedent because, well, now you could if we're doing it now, then they might do it in the future, and we might change the terms for purely vindictive purposes and that kind of thing. But we have to vote on each piece of legislation as we see it. And so if a future amendment to a law was not, retroactive, we would have to consider that as senators, and we would have to see, we would probably have to apply I would apply the Suraj test. So I don't think it sets a precedent. I think there is room for retrospectivity when a serious error has been made in passing the previous law. And I think in this case, with all due respect to the previous parliaments, I think a serious error was made in allowing for a situation where a prime minister, a former prime minister, is able to get a pension with having done no real service. I think that is a grave error. And I think, again, the Minister of Labour has eloquently and forcefully demonstrated that error. And I think, therefore, that error needs to be corrected. And while I would like to stay away from retrospective law, I think it is deserved in this case. And I don't care whatever the motive is. The fact is, it's justified for me. Now, I don't think it's corrosive to the constitutional democracy. I think the point that it assists in good governance and peace and so forth, I think that is a good point. I had some concern about Senator Vera's point that this is really a matter for the Salaries Review Commission. And that caused me some concern, but it's not something I've been able to really dive into. But from what I read about Salary Review Commission in the Constitution, I don't think that, I could be wrong, and it's probably something for the government to consider. I don't think that it prevents the law that's being passed, and I don't think in a situation like this, while I would agree these kinds of things should maybe be the remit of the Salaries Review Commission, I think in a case like this, where it is in the interest to deal with this now, rather than allow the minister or the former prime minister to be collecting the pension, and then way down the road, I think it deserves the intervention of Parliament at this point. So forgive me if I've been a little, if I haven't been as my contribution hasn't been flowing as it should, but I did have it was only till late last night that I really crystallized my position, and so therefore I was hustling this morning to sort of do a rough draft. But I notwithstanding the retrospectivity of the legislation and the fact that that we are depriving someone of a right, and I would only ever consider doing that in very extreme circumstances. I think that in this case, we are dealing with such a circumstance, and subject to what other contributions, because I'm still having an open mind, subject to other contributions that the opposition, the independent bench might have. I am in favor at this point of the bill. Thank you, Mr. President.
Thank you. Leader of Government Business, Minister.
Thank you, Mr. President. Mr. President, I'm very honored to stand here today to make my maiden contribution in this chamber. I have already had the pleasure of congratulating you on your ascension to the chair of the Senate. And I think it is only right at the outset of my parliamentary career that I express my heartfelt gratitude to the Honorable Prime Minister, Mrs. Kamala Prasad Bissessa SC, for giving me the opportunity to serve in her cabinet and as a government senator and as leader of government business in this chamber. Mr. President, I also want to thank my colleagues on this side for the unstinting support they have given me and continue to give me in the role that I have here today. I want to take a few seconds to say that I look forward to continued cordiality with the leader of opposition bench, Dr. Amory Brown, Senator the Honorable Dr. Amory Brown, and coordinator of the independent bench, Senator the Honorable Anthony Vera, who is a friend of mine in the legal profession. So with those few words, Mr. President, let me just add respectfully that I've been an attorney at law for all of my working life, with 33 years at the bar. I will always be an attorney at law, but I have left my private practice behind in order to serve my country. And today, Mr. President, I've been given the opportunity to stand here as a legislator to make laws, because from where I sat before, or stood before, I grappled with bad laws and badly drafted laws, but I'm not seeing the person on the other side I wanted to look at. And I hope that the modest experience that I gained at the private bar will assist this chamber in crafting good law as we move forward to further this government's legislative agenda and to make a useful contribution during my time here, whether it be short or long. Mr. President, crafting good law is not only about making laws that are good, it is about amending laws to make them better, and in some cases, adjusting bad law, which after many years is discovered to be not in the best interest of the people. And Mr. President, the Parent Act, the Prime Minister's Pension Act, number 23 of 1969, is one such law. Now, Mr. President, when I prepared some little speaking notes like Senator Davis did late last night, I did not anticipate the way the debate would have unfolded. And I had to put a red pen through a lot of what I had to say and write something new on the fly, which I'm accustomed to. So what I want to do is jump, if I may, to, I think, the things that are in train in the discussion and that are fresh in our minds and that are relevant for the immediate purposes of our conversation. And then if I have some time to spare, I probably could jump back to some of the nice prepared quotes that I had about the proceedings of this Senate in 1969 and and the context in which the Parent Act, Senator De La Bastida alluded to it, the context in which the Parent Act was passed, because I think it's important that we inform ourselves as to how people thought in July of 1969, when incidentally I was a mere 6 months old. So, Mr. President, let me just jump and permit me to jump to say at the outset, it is necessary for us, all of us, to grapple some legal concepts, difficult though it may be, because this area of the law is not the most straightforward. I think we have had the assistance of Senator De La Bastide, and I just want to go over some of the areas that he had mentioned, which were very useful and which actually appear in my notes, incidentally. Maybe, what is he saying? well, I wouldn't go with, I'm going to go down that line. But I want to respond to some of the things that have been said on the other side of the room with some of the concerns, and a lot of heavy weather has been made, Mr. President, that this bill is ad hominem and it targets a particular person. Now, the Honorable Attorney General has taken pains earlier this morning to explain what ad hominem law means in its special legal sense taken from the decision in Ferguson, the Privy Council decision in Ferguson. And I think Senator de la Bastide mentioned it as well quite correctly, that that particular label refers to a law targeted against a particular person where the legislature imposes a civil or criminal penalty, like taking away the goods of Titus is a civil penalty, or imprisoning somebody on a bill of attainder in the UK. And that would be in breach of the separation of powers because it usurps the role of the court, because Parliament doesn't lock up anybody. You know, in the old days, they would do it in England to lock up people for contempt in the Tower of London. We don't have a Tower of London here. We have a constitution and freedom of expression, but that's another conversation. And I think Senator de la Bastide has assisted us in understanding that well. Now, I know, Mr. President, when people speak Latin, it tends to impress and sound very good. Ad hominem. But, Mr. President, let us not invoke this mantra of ad hominem without any legal foundation for using the term. Mr. President, the retrospective part of the bill, which we acknowledge, and indeed the entire bill is not ad hominem in the legal sense of the word. And I want to put that on record. So let's not invoke the bogeyman of ad hominem and everybody run away in fear. Mr. President, we've never denied that the bill has a retrospective element. And I say that with certainty because it appears at the first paragraph of our explanatory notes of the bill, which every member of the Senate has. It's a page that we usually don't read. We just jump straight into the bill. It's paragraph 1 of the explanatory notes. So we have nothing to hide, Mr. President. So in local parlance, Mr. President, let us not beat up, as they say, about ad hominem. Let's not beat up on that. I want to also put this on record, and I'm very serious about this, Mr. President. Both Senators Vera and Joan Simmons were very strong when they said that the bill was politically motivated. Senator Vera, I believe, and he can correct me if I'm wrong, I wrote it down, used the term political impulses. Yeah, he's nodding his head. And therefore, it would be a bad precedent, with respect. While Senator Joan Simmons said that, correct me if I'm wrong, the purpose of the bill was to address what she described as political grievances, in inverted commas. And I think I got those. But with respect to two of my learned friends who are also my friends in the profession, there is nothing, Mr. President, that has been said in the other place down the corridor, and nothing said here today by anyone on our side, on the government side, and certainly nothing that has been cited or quoted by Senators Vera and Joan Simmons to justify those statements. So, Mr. President, again, with the greatest respect to my friends, but within the bounds of robust give and take, I must register our great disappointment at those particular statements. Mr. President, let's debate real law here. not legal cliches designed to sound good and throw doubts. So, Mr. President, let us consider the correct approach, but I ask that we don't come here with preconceived notions about government motives and political motives. Because, Mr. President, and I want to be very careful, but it must be said, because I think I have a right to respond properly to the statements that have been made, and robustly, that I'm sorry to say it, but in the absence of any evidence of any statements coming from the government side of malice or some sort of government political motive. Those statements show, unfortunately, a predisposition against the UNC government. And I'm very, very disappointed. You cannot make those statements in a vacuum. Can't. Then, Mr. President, there's this invocation about the rule of law. Senator Vera spoke about the principle of legal certainty as part of the rule of law. But that, Mr. President, is what we lawyers call a principle of interpretation or statutory construction. It is when reading a law, you are uncertain as to its application. Does it go forward? Does it go backward? Or both? Because one of the many aspects of the rule of law is that it requires laws be certain so that we all know our rights. And that's why we take time here in committee, etc., when we are making laws, for the laws to be clear and certain, because one of the aspects of the rule of law is that if we are to be ruled by laws and not by whims, we must know our rights, obligations, duties, responsibilities clearly. And to say with respect, as Mr. Senator Vera said, that this bill contravenes or will contravene the rule of law is, with respect, incorrect in my very humble view. Again, Mr. President, rule of law is larger than that, and it sounds nice and high-sounding. But let's stay away with respect from legal hyperbole. This is serious business. The sky is not falling. The legal firmament of the heavens will not fall because we have incanted rule of law. It's not that. Mr. President, I want to get back to rule of law because since that term so often invoked is wide, it also means that we must regulate ourselves by laws, and also, as what we are doing here, or what we wish to do here, we must also make laws using permissible constitutional methods. In other words, our Constitution itself provides the rules for us to make different types of laws. And if we abide by that process, we are ourselves complying with the rule of law, in the sense that this parliament will not be going vai to make a law. And this is why this bill before us requires a special majority, and that has been said up front. So yes, Mr. President, there is a retrospective element, and we say that retrospective element is devoid of any malice whatsoever. And again, no evidence has been placed before this parliament, this house, or any other place, the Senate or any other place. But unfortunately, all of my learned friends so far who have spoken, save for Senator De La Bastide, have focused on objecting to retroactivity for its own sake. But they have never ventured to discuss, which I think we have a duty to discuss, trying to work out the time. I think how many minutes? How many minutes again? 3:02. Oh, thank you very much. But I think we need to journey now into some questions, and let's put the discussions and take the bull by its horns. Whether Parliament can, this Senate can, as opposed to whether it should enact law, which is retrospective, affects fundamental rights, and if so, what is our role in that process? I think it is obvious that Parliament can, but should we, is the question that we should be grappling. We should not guillotine the discussion with notions of rule of law and ad hominem and so on. The discussion goes a little further and it is more nuanced, as Senator De La Bassett spoke about. And let me start where he ended. In the case of Surat and the Attorney General. Surat, not Suraj. People tend to mix them up. Suraj is a cremation case, Surat. Surat and the Attorney General, which was a case I was honored to instruct counsel in the High Court so many years ago in 2003. And there are certain legal principles which I want to put on the floor, on the table, espoused by Baroness Hale, in that legislation frequently affects rights such as the enjoyment of property, which is a qualified right in any event. And the other principle coming out of that case is that any such limitation of rights must pursue a legitimate aim and be proportionate to that aim if it has to contravene these fundamental rights. And that is because that section 13 that Senator De La Bassett spoke about, reasonably justifiable, is what their lordships called in Suraj, a stopgap. The stopgap is proportionality. Reasonably justifiable has a legal meaning. It's not we sit down here and subjectively say, that's not looking reasonably justifiable. No, it has a legal meaning. And Senator De La Bassett espoused the 4 questions for us, which we'll get back to. But the point I want to make out of Surat is that Baroness Hale said it is for Parliament in the first instance, and that's the point I want to make, in the first instance, to strike a balance between individual rights and general interest. It is our job in the first instance to strike that balance when we make the legislation. And in my respectful view and in the respectful view of the government, that balance has been struck in this bill. We have a duty to protect the public interest, even though sometimes it might affect private rights. And the emphasis I placed on it is for Parliament in the first instance, when Baroness Hale said it, is because later on in that line, she says, however, in certain cases, the courts may be called upon to strike that balance. In other words, if somebody objects, you go to court, and the courts will see if that balance has been struck. But we are not a court of law, and we have a job to do as a parliament. And we can't wait for courts of law to strike that balance, because courts don't make legislation. Cases don't go to courts unless lawyers file them, arising out of legislation we make. So we don't have to leave it up to the court. We need to do our job here, and if anybody has a difficulty, the courts could decide. But we have a job to strike it here, because it is for Parliament in the first instance to strike that balance. Now, before I go off of Surat, I want to agree and endorse what my learned friend Senator De La Bassett mentioned, which I had to mention as well, that this proportionality test, reasonably justifiable test, very good four-pronged test, is the objective of the legislation sufficiently important to justify limiting the fundamental right, freedom of property, the fundamental right to property? And we say yes as well. Are the provisions which we propose rationally connected to that aim? And we say yes, they are, because what they do with limited retrospectivity and moving forward are connected with the aim we have with respect to the pensions of Prime Minister, bearing in mind we have to cure bad law. Could we achieve it in a less intrusive manner? We say with respect, no, because we also have to balance the public interest in contemporary times. And we feel in the fourth question that a fair balance has been struck between the rights of any individuals who may be affected, on the one hand, and the interests of the community on the other hand at large, which is, again, from that proportionality test, what is reasonably justifiable. The last, but before let me go now into Suraj, which is, of course, the case that went to the Privy Council because of COVID and the COVID regulations that affected open-air cremations. Suraj, well, that's what I meant. Thank you. Suraj, people tend to mix up Surat and Suraj. Suraj now, so we're going to Suraj. In that case, there was a joint decision of Lord Hales, and I know my friend loved to cite Surat. Every day was Surat, but we enter Suraj. Lord Sales and Lord Hamblin, they had a joint, I couldn't resist, they had a joint opinion of the board, Privy Council. And I just want to quote some paragraphs, just to put them on record, paragraph 67. The elected House of Representatives is the principal institution of the state that gives effect to the democratic principle. I'll say it again. The elected House of Representatives is the principal institution of the state, which, sorry, pardon my grammar, which gives effect to the democratic principle. And I say that, Mr. President, because if you remember the vote in the House, where it was, I believe, 27 votes for, there was a special majority in the House with respect to this bill, with votes to spare. And we cannot close our eyes to that principal institution and what happened there and the message it is sending us down the corridor of this Red House as giving effect to the will of the people, the democratic principle. At paragraph 68 of that judgment in Suraj, this is important. It says, the natural solution to accommodate the inevitable friction which always exists between individual fundamental rights and democratic decision-making in a constitutional liberal democracy like Trinidad and Tobago, what we are doing here, I continue, is that conventionally adopted so often in such states, namely to require that interference with such rights should be permitted in the public interest, but only if the interference is proportionate to a legitimate aim. So tying back to the principle of proportionality. And there's another paragraph, paragraph 91, which I think is useful for us here, which says, Mr. President, generally, and I quote, generally in a democracy, it is the democratic institutions which have the primary responsibility to identify the public interest and what is required to promote it. And later on, though the law lords say, and I quote, it's a long quote, but I think we have some time, Where Parliament gives expression to the public interest not merely by legislation passed in the usual way, but by an act passed by a supermajority in each house pursuant to Section 13, which records expressly, etc., like what we have at the end of the act. This act shall have effect even though. That's the certificate at the end. Parliament will have identified in a particularly clear and forceful way its opinion as to where the public interest lies. In a democratic state, I'm continuing with the quote, the courts must be expected to be especially respectful of the choice made by Parliament to pass legislation in that form and slow to substitute their own view of the necessity for and proportionality of the measure taken. And they say as well, to close on Surad, that the democratic credentials of the measure are especially strong when passed with a special majority. So, Mr. President, we are not a court of law, but we are entitled to look at the provisions, use the proportionality test, and put our democratic credentials on the legislation to pass it with a special majority. Bearing in mind that in the People's House, which is the other place, it was passed with a special required majority with votes to spare. So, Mr. President, before I try to get into some of the useful historical quotes that I wanted to get into from the Hansard, I think I have how many minutes? 10, 12? 12. 12, oh good, 12. I just want to put on record that it is our duty in this place, therefore, having regard to all of the things that I have just mentioned and the approach of the courts, we must take heed of the vote in the other place when we are coming to our decision. And what we have proposed, yes, but I'm emphasizing, what we have proposed are pensionable arrangements that are sensible and reasonable based on the notion of reward, based on length of service, at all times acknowledging the importance of the office of Prime Minister and balancing that with the common good. We say, Mr. President, that any interference with any private rights are being pursued in this bill with a legitimate aim, devoid of any malice, and in the public interest. The proposals that we have for the amendments are both necessary and proportionate to that aim, and in that regard, I just want to quote, if I may, in the short time that I have. I think the Honorable Attorney General referred to it, but he didn't get into it, and he couldn't remember the name of the senator. 1st of July 1969, Independent Senator Jeffrey Stallmeyer, who made a comment for posterity, and many years later I asked my colleagues here today to pay heed to his words, because he is pelting a bouncer to us from the great beyond today, and I quote him. He says, I have merely one comment to make and one disagreement with the bill, and this relates to clause 3, which turned out to be section 3 that we're talking about, which is 100% pension after 1 day. He says, whereby in my interpretation, any person who is elected to the office of Prime Minister in this country and who holds that office for merely a single day, to carry it to the extreme, or say 2 months, is entitled to the pension of 2/3 of the highest rate of annual salary paid to such person when he was Prime Minister. But that was the rate in those days. He says, continue, I think that is carrying it a bit too far, and I think that there should be some time limit established, for instance, a year, that this gentleman should be Prime Minister for at least 1 year before he was entitled to the pension. Notwithstanding Senator Stallmeyer's concerns, the bill was passed, and that the rest is history until today. I want to put a bit more relevant context as well, because I have a little bit of time left. I just want to get it on record. When the bill was passed in the Senate on the 1st of July 1969, everybody, including independent senators and government senators, voted for this bill, which became the act which we want to now amend. But there was one man, independent Senator Clive W. Spencer, who said no. Senator Stallmeyer and some of the other senators expressed their concerns, but still voted for it. But Senator Spencer said no. And I want to quote his words because Senator Batiste said something which probably it's serendipity or coincidence, echoed here, and I was going to strike it out with a red pen, but I think these words must echo again in this chamber. Senator Clive Spencer, 1st of July 1969, he said, and I quote, but simply because of, he says, as one who is charged with the responsibility of securing pensions for people, it might be a little alarming to find that I am not prepared to support this bill. It is not because I'm opposed to the principle of pensions, because that is part and parcel of my daily fight, but simply because of the fact that I am opposed to people, whether they be government, business, or whoever they are, who fail to recognize that they must do unto others as they would have others do unto them. Later on, I do not know if there's a sudden fear of certain offices coming to an end so that you must provide for them, because remember, they never had a prime minister's pension before 1969. Dr. Eric Williams was prime minister at the time, and I continue the quote, but I am concerned about the other people, the less fortunate, who have nothing, not even the means to put aside something to get a pension. And you are coming here to ask me today to pass this? No, sir. Do unto others as you would have them do unto you. End of quote. So it is clear, Mr. President, that the government wanted to pass into law at the time, the then PNM government, a special scheme for pensions for the then Prime Minister in the event that they should lose power, because these were the days before the Black Power Revolution. And I just want to put that in context, and that has carried down through all of the years to here, and we are fixing it. And Mr. President, we must fix this, and we must fix it today. So I commend this bill to the Senate, and I thank you very much.
Allow me to extend congratulations to the leader of government business, Minister in the Office of the Prime Minister, Senator the Honorable Darrell Allaha, on his maiden contribution. I now recognize Senator the Honorable Foster Cummings.
Thank you, Mr. President. Thank you, Mr. President, for the opportunity to join this debate. Mr. President, I've had the pleasure of listening for today to 4 distinguished senior counsel and 1 senior attorney who has been at the bar by his own admission for over 30 years, presenting to us several legal positions, none of which I find myself competent to speak to, seeing that at best, I may not even be a bush lawyer. But I have a responsibility, particularly because we took an oath of office to be fair and just in our office as senators in this House, and to take into account that we are here, of course, to represent not our own interests, but the interests of Trinidad and Tobago. As I listened to at least two senators before me quoting the Hansard, taking us back in time to a previous Senate that deliberated on this pension, I believe it was in 1969, it tells us that what we do today will not only affect the current situation that we are tempted to treat with, but that those who will come after us, maybe 10 years, 20 years, even 50 years from today, when we will no longer be here, at least most of us, that they will take account of what we, at this point in time, in the Senate of Trinidad and Tobago, what our positions were on this matter. On at least two occasions, the leader of government business, Senator the Honorable Darrell Alahar, mentioned what transpired in the other place, and that we should take note of what the support was for this legislation in the other place. I don't know that what we are doing here today must be guided by the vote, support, or lack of in the other place, with all respect. Mr. President, we are discussing the issue of pension, in particular, the Prime Minister's pension. And therefore, I think I can boldly say that on this side, there's no disagreement with the question as proposed by the government that there should be a tiered system. As a matter of fact, if I am to consider someone serving for 9 years and a half and someone serving for 6 weeks or about in the same office, receiving the same pension, I can understand from the public why they will have an issue with a scenario like that. And so there's no disagreement with the bill seeking to bring some order to that situation, so that to qualify for this pension, one must have served a particular point in time. I mean, there is a school of thought of some persons speaking to the question of what happens to someone who may have served less than a year. Is it that they receive zero? Is it that if someone who serves less than a year as Prime Minister and dies in office, that their surviving spouse could be left with an issue? Is it that if someone who serves less than a year and has to leave office because of ill health, there can be a scenario where someone attaining the office of Prime Minister is of senior age and may have to leave office due to ill health? Has the government given any consideration to a scenario like that? And it may be that those who initially came up with this law considered all those factors. I have not perused all of the Hansard in relation to that debate, but it is a possibility. So as we discuss possibilities and how do we respond to the clear cry in the public space that there seems to be some issue, that we consider those matters as well. And therefore, as has been said by those before me, there is no issue with the tiered system, but there are some additional issues that we need to pay attention to. Mr. President, the Constitution at 76(1) spells out clearly the question of the appointment of a Prime Minister. I need that quote because we know it speaks to a prime minister being appointed from among the member who commands the majority, etc., etc. And in our history, we have had a few scenarios of appointments of prime ministers. Most of them, but not all of them, following elections, general elections. Our first prime minister, of course, Dr. Eric Williams, and this was, of course, following a general election. Our second prime minister, however, came to office in an emergency situation where, following the death of our first prime minister. And therefore, it was the first time that we had to treat with how do we appoint a prime minister. And history is clear on how that prime minister was appointed. Mr. President, that prime minister eventually faced the polls, was victorious, and was appointed again as prime minister. Our third prime minister, Mr. Manning, came to office following a general election. In his second appointment, which was also following a general election, however, we had another new situation, an 1818 deadlock. And the president of the republic at the time made a decision and appointed a prime minister. That was another first for us. And it will go down in history as to how that appointment took place. Some were happy, of course, some were not too happy. However, his third appointment was following a victory at the polls. Our next two prime ministers, both the Honorable Kamala Persad-Bissessar and Dr. Keith Christopher Rowley, both came to election on the occasions that they have been appointed prime minister following victory at the polls. And then we have Prime Minister Young, who was appointed prime minister, another new situation. One prime minister left office, and Minister Young, then Minister Young, was appointed as prime minister following the resignation of a sitting prime minister. It was another new situation that we were not accustomed to. And that, Mr. President, is very possible, may contribute that, in addition to the length of time that the prime minister then would have served in office, may contribute to some of the anxiety and concern surrounding this pension situation. So I am not going to, in my few words in the Senate, not take into account that those matters have some bearing on some of the contributions made here today, as well as we don't live in a glass case, as well as some of the sentiments, Mr. President, that may be expressed. One particular senator did say that he received communication from members of the public on this matter. I cannot say that I have not as well received communication on this matter. And, well, I understand, Mr. President, all too well the interest of the government in knowing what happens on my phone, but I retain that my personal position. Mr. President, notwithstanding all that I've said before, most of the discussion has been revolving around the retroactive aspect of the bill. That is what is causing us pause in the Senate today. And it might be that it is because there is concern that if we pass legislation that appears on the face of it to be targeting an individual to have the effect of preventing that individual from accessing what some have termed in this debate as a right, that is something that requires us to not rush into, but to discuss as a Senate. Mr. President, when we look at legislation, we have to consider all of the matters pertaining to the legislation. In that, what are we trying to cure? We are trying to cure a situation where we are trying to tie pension to tenure. So you must have served in order to qualify. And the government in this piece of legislation is trying to go a bit further in saying, well, and somebody said it's the elephant in the room, but it is just the plain obvious that this section, clause 2 of the legislation, is intended to speak to a particular prime minister who has served before for a short period of time. One member on the government side even said that, you know, well, there's a hue and cry, the exact words, a hue and cry from the public, it has to be, over the question of this individual receiving this pension for serving for a short period of time when others will be in receipt of the same pension who have served a longer period of time. And it is a matter serious enough, possibly, for the government to have considered taking the matter to a joint select committee of the parliament to have discussion among members from both houses as to how can a matter like this be cured. How can the government achieve the objective that they set out to achieve, but yet not offend the law and have the question of ad hominem legislation being debated in the House and passed, possibly or not. What is the main conversation taking place? The main conversation is, should someone who has served for a very short period of time, less than a year, in terms of the legislation, be entitled to a full pension? We have had a lot of points of views put forward. As I said, most of them quite legal. And I took the discussion a bit into the question of how prime ministers are appointed to office. I mean, there's no secret. The parliament is now showed live to all of Trinidad and Tobago and the world. And that is not in a vacuum in itself, because, of course, other activities in the public space, it is no secret. A lot of things are no secret. That, for my own part, I have voiced publicly my point of view on appointments to the office of Prime Minister. I need not detain this debate on that matter. And I have made the point to the government to consider earlier on the question of what happens if someone does not serve the full year, and two particular scenarios I've raised. But Mr. President, I think part of the concern, and the government has to take note of this, part of the concern as well has to do with trust. A government, notwithstanding the majority that the government has come to office with, a government must have the trust of its people on its side. And there is serious concern based on some of the actions, the recent actions of the government, which is a government that is probably just about 2 months old, as to whether that trust to start and to set a precedent like this, whether that is going to open the door for this government to utilize its majority to take action similar to this that may affect individuals in a negative way. And so, whilst we as an opposition have no issue with the tiered system of the pension, we are seriously concerned, based on the government's by its own action, eroding the trust only recently placed in it by the electorate of this country, by actions taken that seem to zero in on individuals in a personal way. The removal from office of the head of the central bank. These are institutions in the country. Trust is the question at the end of the day, Mr. President. And therefore, as a responsible opposition, we have to point out to the citizens to take special note and to take special care. Mr. President, it is not too late in the day for the government to take one or two positions. Proceed, and the bill possibly fails completely. Amend and remove the retroactive clause from the legislation, or commit the bill to a joint select committee for deliberation and discussion as to how can we cure a situation that I'm sure most citizens in Trinidad and Tobago have taken attention and pause concerning. And therefore, Mr. President, with these few short words, I thank you for the opportunity.
I think I'll recognize Senator Dr. Desiree Murray.
Thank you, Mr. President. We meet today to consider the Prime Minister's Pension Amendment Bill 2025, a piece of legislation that, while narrowly focused, touches on matters of deep national significance: service, sacrifice, fairness, and legacy. The proposed legislation has generated significant public interest and wide public discussion, and rightly so. Occupying the office of Prime Minister is one of the highest forms of public service. It carries with it great authority, but also enormous pressure, scrutiny, and personal sacrifice for both the office holder and his or her family. And I want to stress the family aspect of that position. Decisions made here today will directly affect how we as a nation acknowledge and support those who have taken on that responsibility. So it is important to begin this debate by acknowledging the seriousness of what we are being asked to review. My comments are offered with care and concern for legislative clarity, institutional consistency, and above all, an equitable approach to public office holders, like the Minister of Labor and Micro Enterprises alluded to. and spoke so eloquently about, and I agree with. We have a duty to ensure that our laws are just, transparent, and thoughtfully constructed, not only for those who currently hold office, but for those who have served before and for those who will serve in the future. In that spirit, I wish to share a few observations. The Parent Act of 1969 reads, and I think I'll get this right if I say the long title, but I stand corrected, an act to provide for the payment of pensions to persons who have served as Prime Minister and to the widows and the children of such persons and for matters connected with or incidental thereto. Section 4.1 states, the Prime Minister's pension payable under this act to any person shall be the full amount of the highest annual rate of salary paid to such person at any time as Prime Minister. It satisfies, in my mind, the principle of legal certainty, which allows individuals to understand their entitlements and obligations and plan accordingly. Clauses 5 and 6 of the amendment bill introduce a tiered pension system based on the length of service, providing from none to 1/3, 1/2, 2/3, or the full amount of the highest annual salary depending on tenure. While this may seem like a rational framework, it also introduces new complexity. For example, how would we deal with a Prime Minister who sadly dies in the line of duty within 1 year, having not yet met the minimum criterion to receive a pension? How would the spouse and family be affected? Furthermore, with a Prime Minister who served for 3 years and 364 days, receive only 2/3 of the pension in the event of sudden death, would their family receive a reduced benefit even if their loved one died in the line of duty? Prime Ministers have a security detail for a reason. The Parent Act provides pensions to the widows or widowers and the entitled child or children of all former Prime Ministers. If this amendment reduces a Prime Minister's pension based on tenure, that reduction will extend to the pensions paid to their surviving relatives. At a time of grief, should families face reduced support, especially when their loved one may have died while in service? We recently amended the Children's Life Fund Act and discussed the need to protect the most vulnerable among us, our children. Could this amendment before us today unintentionally affect the child of a Prime Minister who dies in office during the first year? The existing act, dating from 1969, seems to me to provide better survivors' benefits than the proposed amendments. These provisions are not merely symbolic. They are safeguards for families who may have given up privacy. The families may have given up stability and security in support of national service. We must carefully consider whether this shift from a service-based model to a time-based calculation is justifiable in principle. My second comment, as in most of the other speakers, concerns retroactivity and the choice of commencement date. Clause 2 of the bill proposes a retroactive commencement date of 10th March 2025. I respectfully suggest making any amendment retroactive to 31st August 1962, the date of our independence and the date used in the Parent Act. That historic date would ensure that all former prime ministers are treated equally and help dispel any perception of ad hominem. This is why I respectfully suggest that consideration be given to removing Clause 5, which requires a person to serve at least 1 year as prime minister in order to qualify for a prime minister's pension. We have heard that despite being the UK's shortest serving prime minister, just 6 weeks in position, Liz Truss is eligible to receive a special allowance that is available to all former prime ministers. I must say I was surprised that the name Liz Truss hasn't come up in the debate so far, yet there has been so much reference to the UK in other matters. However, she can choose to forego the annual pension of up to £115,000 per year for life, to which she is entitled. And the allowance can only be used to reimburse expenses for necessary, and I quote, for necessary administrative costs arising from their special position in public life. The money is not paid automatically, and the cabinet releases information about how former prime ministers have claimed. So there's transparency. My third comment reflects on equity among parliamentarians. Mr. President, Clause 6 of the Prime Minister's Amendment Bill 2025 provides for the calculation of a Prime Minister's pension based on a person's length of service. This model has been executed in the Retiring Allowances Legislative Service Act, Act number 24 of 1969, which established pensions for members of the House of Representatives and holders of specified legislative offices. This act takes into account the length of service of any person as legislator. In piloting the bill, the Minister of Planning, Economic Affairs and Development stated that all persons in public service should be treated equally. If we are to amend the Prime Minister's pension, and if we are moving towards a contributory model, similar to the Retiring Allowances Legislative Service Act, then I humbly suggest that all parliamentarians be considered in line with Section 4D of the Constitution. In conclusion, my main concerns with this bill are: 1, the shift in pension calculation introduces ambiguity in my mind and could unintentionally disadvantage those through no fault of their own and who serve a shorter time, for example, through illness, injury, or even death. And it also has implications for their spouses and children. And 2, the retroactive clause has raised questions about fairness and intent. Ideally, the clause should be removed, but a retroactive date of 31st August 1962 would be more inclusive and transparent. It has been said that it is the worth of the policies themselves and not their source or sponsor which determines the position of one who is truly neutral. My position remains that of informed, principle-based decision-making. Mr. President, I will circulate proposed amendments to be considered during the committee stage, and I thank you for the opportunity to contribute to this debate.
Thank you. Senator Francis Lewis. Senator Francis Lewis, please.
Good afternoon, Mr. President. Thank you for the opportunity to speak on the Prime Minister's Pension Amendment Bill 2025, consisting of just a few clauses. I wish to state at the outset that I support the key provisions of this legislation. The inclusion of a minimum service requirement, whereby the Prime Minister must serve at least 1 year in order to be eligible for a pension. I could see the sense of it. It is reasonable, it's principled, and I think it aligns, as a number of people stated, with people's expectations of public service at the highest level. I commend the move to a tiered pension calculation, where the amount received is tied in some way to the level of service. It introduces proportionality and fairness, and it ensures a measure of accountability and alignment with what we have been advised is evolving pension reform across the public sector. Mr. President, I support these core proposals. I have a concern, though, regarding the commencement date of the Act. It's just over 3 months ago, specifically the 10th of March, which gives the legislation retroactive effect. I will defer to the legal luminaries in this room, but my understanding is retroactive legislation, especially, well, sometimes called ex post facto law, is relatively infrequent in most parliamentary systems, including Trinidad and Tobago. I stand to be corrected on that. But in looking for sources, it was not easy to find where this is a frequent practice. With, I think, good consideration, good regard, because retroactive laws potentially violate, as a number of persons said, the principle of legal certainty. And all of us need change, but we also need a level of predictability in our lives so that we could anchor ourselves to something that is fundamental, and it is fundamental to democratic systems. So retroactive systems or legislation risks undermining public trust in legal certainty, even where there are lawful mechanisms for enabling such retroactivity. Mr. President, I support the government's overall intent. My concern is, if you're going to be retroactive, it needs to pass a reasonably high test beyond what is lawful to what makes it necessary. Often, from my limited research, it is used to correct a historical wrong, or sometimes administrative error, or to clarify intent. I don't know that that is applicable in this instance. In thinking about today and this short presentation, I feel the weight of history heavy in this place. How our actions and future actions of the persons that this law will affect and what they will do as a consequence, I think matters. So what I want to do is, I will defer to the persons with the training, the experience, and their legal wisdom. I'd like to look for a moment beyond the legal and related arguments offered. In thinking about it, colleagues, I want to suggest that this bill gives us an opportunity, and that opportunity is twofold. We are offered the opportunity to act rightly as a Senate, but it also gives the individuals affected or impacted the chance to act rightly and demonstrate what the older persons in our society call character. It's an opportunity, so that's opportunity one. Opportunity two is it sets the tone of this House for maybe future discussions, and that's important, particularly in light of the President's statement at the very opening of the session. In thinking about this, it can almost be described as a Gethsemane moment. It's about coming to terms, and in a Gethsemane moment, there is challenge and there is opportunity. Now, when one thinks of Gethsemane, the phrase, wishing this cup to pass, is what comes to mind most frequently. But it also offers a chance to find and treat with a different kind of strength in choosing to face a challenge with the outcome being transformative. Given that, I wonder what the opportunity might be in this House and whether this is the occasion for it, for enabling and building trust. And let me not hesitate to say that trust does not have to be unguarded for it to be effective. It can be calculated. But it helps to build mutual regard, respect, and goodwill. And this goes a very long way in improving legal legislative discourse. The goal is not utopia, but it's how to make constructive agreement productive. My recommendation for consideration is remove the retrospective amendment. If one did this, consider for a moment how the perspective of the person or persons impacted by it. The ball is now in their court, and they now have to decide on what they will do. I expect in weighing their decision, among their considerations is a calculus about, well, I take in my money. Is my right, is my property. But on the other side, there's a realization that time longer than twine. And in the fullness of time, their decision will be judged by others and the wider population. Will this matter to them? I don't know. What will they do given their aspirations? I don't know. Will they act rightly? Will they act with character? Will they demonstrate good character if given the opportunity to do so? It is said, and this was someone many years ago, a mentor, nobody rises to low expectations. I wonder whether this might not be an opportunity to set a bar of expectations that if someone wishes to serve and work in a future capacity, there is a very clear public sentiment. And I think the government's comments reflects that public sentiment of what that person's reaction might be. Will they act in a way that generates repugnance or admiration? Now, none of us could predict that human behavior, and I may be disappointed by their subsequent action. And it is a risk. And I suppose it's a question we have to ask, is it a risk we're prepared to take in this matter at this time? But in this matter, with risk, there's opportunity. Perhaps it can help build a greater degree of dialogue and trust in this House. Perhaps we're not ready for it. Perhaps this is not the time for it. And as a couple of people close to me said, perhaps I'm being just unduly optimistic and idealistic. And that is also possible. So let me move to conclude with colleagues. Thank you for listening. I was somewhat hesitant to speak on this matter. I have been very encouraged by the quality and tone of today's debate. I have learned a lot from you and from everybody in this House. Senator Alwari, Senator Batiste, Senator Vera, among others. And for that, I greatly thank you, and I have enjoyed today. So thank you, Mr. President. Thank you for the opportunity to make this presentation.
Before I call on the Minister of Transport, I want to appeal once again to members of this honorable House, Senate. Please place your mobile on silent. 3 times phones have rung during our sitting. So I'm just appealing again to members who have mobile on them. Place your mobile phones on silent. Please. The Honorable Minister of Transport.
Mr. President, I rise before this esteemed House today to debate the Prime Minister's Pension Amendment Bill 2025 in my capacity as a government senator and Minister of Transport and Civil Aviation. Allow me to begin by extending my most sincere congratulations to you, the newly appointed President of the Senate, on your well-deserved elevation to this distinguished position. Your appointment represents not merely a personal achievement, but a testament to your unwavering commitment to democratic principles and the noble art of governance. Today also presents an opportunity for me to express my deepest gratitude to the Honorable Prime Minister, Mrs. Kamala Persad-Bissessar, SC, for her exceptional leadership in guiding our party, the United National Congress, into government to what can only be described as a resounding and historic victory. Mr. President, I am especially grateful to the Honorable Prime Minister for the confidence she has shown in appointing me to serve in this capacity. This appointment represents not merely a personal honor, but a sacred trust, a responsibility to serve the people of Trinidad and Tobago. Mr. President, I stand in strong support of the Prime Minister's Pension Amendment Bill 2025, which stands before this honorable House. This bill is about fairness, it is about responsibility, and most importantly, is about correcting a serious legislative flaw that, for far too long, has worked against the interests of the people of Trinidad and Tobago. There are many things in my notes that I don't want to repeat here, so I would highlight. The bill introduces two key reforms, and the bill also has a retroactive effect, and as such, it requires a special majority to pass. Mr. President, the fact is there's currently no minimum service period for a Prime Minister to qualify for a pension. That is not fair, that is not right, and today we are fixing it. We are not reinventing the wheel. My colleague mentioned, if you look across the Caribbean, like countries like Antigua and Bermuda and the Bahamas, who already have a similar or even stricter requirements. In Antigua and Bermuda, it is 5 years. The Bahamas is 8 years. You also have Jamaica, which is 5 years, and Barbados, which is also 5 years. By comparison, this bill proposes just 1 year as a minimum threshold. This is not extreme, it is measured, and it is reasonable. The proposed tiered structure ensures that pension payments will now be proportionate to years of service. Mr. President, I often think about the masons and builders across the country. No builder lays one brick and then says, I've built a house. They put in the work brick by brick, day by day, until the structure stands strong. Likewise, holding the office of Prime Minister is about building trust, building leadership, and building the country, not just holding a title for a brief moment and expecting lifetime rewards. This bill reflects that. It is acknowledgement that the existing law is flawed and that this reform is necessary. We need to correct a wrong that should never have existed. The bill is justified, the bill is legitimate, and the public interest is clear. Mr. President, it's about restoring fairness and accountability to our system of governance. The people of Trinidad and Tobago deserve to know that pensions for prime ministers are earned, not automatically awarded. They deserve to know that their elected parliament has the courage to fix legislative flaws. With this bill, we will align our laws with both regional standards and common sense principles of fairness. We will protect the public purse, we will strengthen public trust, and we will ensure that the title of Prime Minister remains not just a position of privilege, but one of true public service and accountability. With those few words, Mr. President, I thank you.
Allow me to record on behalf of the Senate our collective congratulations to the Minister of Transport on his maiden contribution. I recognize Senator Zola Phillips.
Mr. President, I thank you for the opportunity to rise and make a contribution on this bill, the Prime Minister's Pension Bill Amendment Bill 2025. As I do so, I pause to acknowledge the immense honor and responsibility I feel in standing here today, not only as an independent senator, but also a proud daughter of Tobago. Mr. President, I want to begin by expressing my support for the bill's core intention, which is the introduction of a tiered pension system for persons who have held the office of Prime Minister. This is, in my view, a welcome step towards more equitable and sustainable governance. It reflects an understanding that not all service in that office is equal in time or impact, and therefore benefits ought to correspond with the length of that service. For too long, as most of our friends have shared, our pension arrangements have operated on an all or nothing basis, where the mere fact of appointment, regardless of duration, qualified someone for the same benefits as another who may have led for years under immense national pressure. The move toward tiered eligibility reflects a maturity in our legislative thinking, one that signals that public service must be accountable, proportionate, and merit-based. In this regard, I believe the government has made a commendable attempt at reform. However, Mr. President, I cannot support the provision within the amendment that excludes entirely any person who has served as Prime Minister for less than a year. Let us not forget that the Prime Minister is not simply a ceremonial figure. It is the highest executive office in the land, carrying the full weight of national leadership, of international representation, of policy oversight, and at times crisis management. Even a short tenure in that office is not without real cost, physically, emotionally, politically, and professionally. It is not reasonable to presume that a person who served under a year as Prime Minister did not carry significant burdens on behalf of the nation. Moreover, the history of democratic governance shows us that transitions in leadership do not always follow predictable patterns. Sometimes a Prime Minister may serve for a short time due to the untimely resignation, illness, or even death of a predecessor, as some of my colleagues have also shared. Other times, political instability may shorten a government's tenure. Should such persons who may have had to take up the reins during difficult national moments be entirely excluded from any form of pension? Mr. President, fairness does not mean equal treatment. It means appropriate treatment. What I would humbly agree with is the consideration of a prorated pension structure, one that ensures individuals who serve for less than a year are still recognized, but receive benefits in alignment with the duration and nature of their service. This would preserve the principle of proportionality, while also honoring the dignity of the office. Further, I believe it is important to guard against a utilitarian or transactional approach to public leadership. We must not begin to calculate service only in terms of months and years, but also by the depth of contribution and the context in which that service occurred. We often speak about upholding the sanctity of our institutions, but institutional strength is also preserved by how we treat those who lead them, even for a time. If we are to foster a healthy political culture in Trinidad and Tobago, one that encourages qualified persons to step forward in moments of need, then we must also build structures that affirm the legitimacy of short-term, transitional, or emergency leadership. These are not anomalies. They are a part of the life of any mature democracy. Mr. President, as someone privileged to sit on the independent bench, a space not driven by party interests, but by conscience and country, I feel compelled to raise this point, not as a political objection, but as a constitutional concern. We cannot allow legislation to unintentionally undermine the very offices it seeks to regulate. We cannot say, on one hand, that a person is fit to serve as prime minister, but on the other hand, that their service, however brief, merits no form of state recognition after they demit office. In conclusion, I affirm my support for the tiered system as a whole, but urge this honorable House to reconsider the total exclusion of those who have served for less than 1 year. Let us send the message that we believe in measured accountability, yes, but also in measured respect. Let us be mindful that how we legislate today shapes the tone of our governance tomorrow. I ask that we pass laws that reflect not only fiscal prudence, but also human dignity. I thank you.
Thank you. Senator Timal, please.
Mr. President, I thank you for the opportunity to contribute to the matter before us. And before I do so, Mr. President, I must express my deepest appreciation to you for the motion that you presented at the beginning of the sitting here today. It provided reassurance, and it, to me, indicated a commitment on your part, a noble commitment, I must say, to uphold the institution of this Senate and this Parliament. Mr. President, I rise today not as a constitutional expert, nor as a partisan figure, but as an independent senator entrusted with a serious responsibility to contribute thoughtfully and conscientiously to the laws that govern our republic. I make no claim to legal training, although like my colleague, Senator Foster Cummins, I do fancy myself at times as a bush lawyer. But I approach my role with humility to learn, the discipline to research, and the duty to reflect on all views presented before this honorable House. And I've always believed that my strength as an independent senator does not lie in specialized expertise alone, but in the capacity to weigh complex issues with fairness, to listen attentively to the contributions of my colleagues on all sides, and to make decisions not on political instruction, but according to the dictates of my conscience and my constitutional oath. So as I consider this bill, complex as it is in both legal structure and, we must admit, political consequence, I do so with a pragmatic lens, guided by the principles of justice, good governance, and institutional integrity. And despite the very limited time offered to prepare for debates, I always try my best to read, to listen, and to think deeply. So when I vote or speak in this chamber, I do so with the full weight of my responsibility to the Constitution, the public interest, and with my own sense, though limited at times, what may be right or wrong. This is the spirit in which I believe an independent senator serve as an independent senator, neither blindly differential nor politically reactionary, but always trying my best to be principled, thoughtful, and faithful to the law and to the people we serve. I stand in this chamber not as a representative of a political party, nor a voice swayed by populist sentiment or public emotion, I stand here under the solemn oath I've taken to uphold the Constitution of Trinidad and Tobago and to discharge my duties to the best of my ability with conscience, integrity, and independence of mind. Mr. President, I know I've probably been a bit long-winded here, but I just felt that it was necessary that I put that on the record. Now, in this instance, I support the reform objectives of the bill that is before us. But at the same time, I am vigilant against any provision that may compromise constitutional values, including fundamental principles of natural justice, equality before the law, and separation of powers. Now let me begin by stating clearly, I support the central purpose and direction of this legislation. I agree with the principle that the conferral of pension benefits upon those who have served as Prime Minister should be tied to a minimum period of service and scaled accordingly to the time served in that office. And in many ways, this bill reflects a more modern, structured, and merit-based approach to public service rewards, one that aligns with evolving expectations of fairness, accountability, responsible stewardship of public funds, and public expectations. Mr. President, it is entirely reasonable that a person must serve for a defined period, perhaps one full term of the majority of a term, as we are seeing in this bill, before being eligible for such a pension. Likewise, a graduated scale proportionate to length of service ensure that long-standing prime ministers are rightly distinguished from those who held office for shorter periods. It's only fair and reasonable. These are welcome reforms. But, Mr. President, I am troubled by one aspect of this bill, and that is the proposal to apply these changes retrospectively to a date that would prevent former Prime Minister from qualifying for pension benefits under the previous regime. Now, I would just like to look at this from two aspects, legally and then morally. And in terms of legally, of course, I think for the first time there are so many senior counsels in this chamber, and I'm guided by the many contributions of our respective senior counsel and in addition to all other senators and those who are not senior counsel. And from what I understand, my understanding is that our legal system is founded upon certainty, predictability, and rule of law. And retrospective legislation disturbs those foundations. I'm not saying it's not permissible, but it has the potential to disturb those foundations. And citizens, particularly office holders, must be able to plan their conduct and decisions based on the law as it exists at the time. And they must not be left vulnerable to sudden legislative reversals that may strip away previously accrued rights or alter legal consequences after the fact. And our courts have long recognized that while Parliament has the power to pass retrospective laws, that power must be used with restraint, especially where the laws affect individual rights, property, or legitimate expectations. In the case of pensions, as is the case before us, particularly for constitutional officers as Prime Minister, one could argue that entitlements accrued under existing laws may amount to legitimate expectations or even vested rights, depending on the timing and context. and revoking or altering such entitlements retrospectively may invite legal challenges on the grounds of procedural unfairness, legitimate expectations, and potentially even in brief of natural justice. Now, Mr. President, although I wasn't present for the early part of the sitting, I still had the opportunity to listening on the radio. And I've heard a lot, including the time I've been here, about ad hominem law and bill of attainment. And from what I understand, the term bill of attainder, originates from English constitutional history, where Parliament could pass a law imposing punishment on a specific individual, often without trial. Now, bill of attainder is obsolete in form. In fact, it is nowhere found in the American Constitution. But in some Commonwealth legal systems, a principle is upheld that no law should target individuals for punishment without due process. And in most democratic systems and of the Commonwealth, although outright bills of attainder are prohibited by constitutional norms or judicial precedent, legislation with such effect may violate constitutional protections of natural justice, due process, and equality before the law. And while such bills are rare and prohibited in modern democracies, courts in some of the Commonwealth countries have recognized what I understand is referred to as the bill attainder effect, which recognizes certain things, retrospectively disqualifies or punishes an individual or a narrowly defined group of people, where the intent or consequence of the law appears aimed at that person, where the penalty is imposed legislatively, not judicially, where it violates separation of powers as the legislature takes on the role of judge and jury, undermine natural justice, often viewed as politically motivated, and could also be challenged on constitutional or administrative grounds. Now, in our particular context, from what I've heard in the debate thus far, yes, there are times contributions seem to indicate that we are bordering on a bill of attainder effect. But from what I've heard so far, I'm still not clear that enough has been presented, at least for me, and I would hesitate to draw a conclusion in this regard. Then, Mr. President, I've come to the view that not all retroactive legislation is inherently unjust or unconstitutional. Constitution of Trinidad and Tobago does not prohibit retrospective application of civil legislation, especially in matters of public administration and entitlements, provided it does not violate protected rights such as liberty or property. Now, yes, the timing may affect one recent former prime minister more visibly than others. But that alone, I think, does not render the law discriminatory. Laws frequently have disproportionate effects, but that is different from targeted punishment. Importantly, Parliament retains the authority to legislate with retrospective effect when no constitutional prohibition is violated. This includes service rules, pension structures, and standards for office. And in past cases across the Commonwealth, courts have upheld retroactive pension reforms, especially where they serve public policy objectives and are not punitive in nature. So if we are to build trust in public institutions, we must be willing to review and correct practices that no longer serve the public interest. This bill sends a clear message The privilege of serving as a prime minister must be matched by a standard of sustained service, and public rewards must reflect public responsibility. Now, Mr. President, in this debate, I've chosen not to get into whether the bill is politically motivated, despite what has been transpiring in the public domain over the past few days. And I must say, and I'm being restrained in my words here, the attacks on my integrity and my character as an independent senator, and also personally. Based on the oath I've taken, I will not let that affect the clarity of my thinking in the matter before us. Even if retrospectivity was legally permissible, we must then ask. I've tried to just summarize the legal thing in terms of how it came to me. Is it morally justifiable? Is it ethically sound? And yes, the timing that I mentioned may seem to or will affect one former prime minister more visibly than others. But if we are to build trust in public institutions, we must be willing to review and correct practices that no longer serve the public interest. And this bill sends a clear message. The privilege of serving as prime minister must be matched by a standard of sustained service, and public rewards must reflect public responsibility. This bill also sends a message that high office would be held to high standards. We are talking about the highest office in the land under our constitutional terms of prime minister. So high office is expected to be held to high standards, and that public rewards will be grounded in merit, service, and time, irrespective of how high the office may be. I'm of the opinion that the reform intended by this bill moves our governance structure towards a more equitable and responsible position, and one that aligns with evolving expectations of fairness, accountability, and sustainable public finance. Mr. President, and over the years, in our nation, we are seeing that. Our people are demanding it actually, for our high levels of accountability, high levels of performance in all our undertakings. And under the question of morality, I think I didn't have this originally to say in my contribution, but I felt I should add it in. The question of morality, there's another question that needs to be asked. Whether someone who has served for such a short time deserves a pension of the amount and expected longevity that will result if this bill is not passed. And is it fiscally responsible to expect such? And is it fiscally responsible for our government to allow this? Now, in closing, Mr. President, if I decide to support this bill, I will not be doing so out of deference to the government, with all due respect to all members on that side, nor succumb to the strategy adopted by the political party forming the government over the past day. And I'm using the word strategy in a good way. I could have probably chosen other words, but it is not, if I decide to support them, I'm going to succumb into that. Nor out of disregard for the valid concerns expressed by other senators here today, including, Senator Vieira, who I have tremendous respect for. But because I am satisfied, if I do decide to support, is because I'm satisfied that the bill meets the constitutional threshold, satisfies public accountability or seeks to improve public accountability and fiscal responsibility, and it will uphold the long-term credibility of our democratic institutions. Mr. President, I mean, all those of us who have been around for a while, not only in the chamber, but just living life in our nation, would realize that today's majority is tomorrow's minority. And how we conduct ourselves and how we conduct the business of this house is not only about how much we do and how much change we bring about, but it's how we go about the business of this house, business of the Senate. I think that is also intrinsic in how we would be evaluated and judged in the future. Mr. President, I thank you very much.
Senator Dr. Emery Brown.
Thank you, Mr. President, for recognizing me. Considerable content and delivery has already been offered in this debate, quite a consequential exchange in the life of this parliament, and I want to commend those who've already spoken, particularly some colleagues who've really put into context the weight and import of the matters under consideration that the government has put under consideration of this upper house by way of the Prime Minister's Pension Amendment Bill 2025. Mr. President, I would like to begin on a note established by the highly esteemed independent Senator Timal, and to take this opportunity to reaffirm this opposition's respect for the Constitution and democracy of Trinidad and Tobago in no uncertain terms. Mr. President, we will never yield to the temptation of attacking independent institutions, such as the Elections and Boundaries Commission, such as attacking our head of state. And worst of all, Mr. President, we've seen too many recent examples of attacks on independent senators in the upper house of Parliament. Mr. President, this pattern was established, unfortunately, in the last session, and I won't dwell on it. But I want to join those colleagues who've commended and saluted you for an intervention which hopefully will benefit us throughout this particular session, and a warning that there will be consequences should those admonitions not be heeded. Unfortunately, even as we are here engaged in this matter, there are those in public life who have continued making Facebook and other social media posts that appear, designed to pressure and intimidate members in the course of their deliberation and contemplation on how they would vote on matters. So, Mr. President, I begin by reaffirming our commitment to the Constitution and democracy. And we will have no hesitation in standing in the defense of those who might be menaced or pressured, as we've done before. Thank you, Mr. President. And I'm not going to yield to any disturbance, but there's another pattern of public officials resorting to social media to undertake analysis and introspection of proceedings here, and those will be properly scrutinized for action as well. I sound due notice in that regard. Mr. President, we've had a number of debates already in this short session. We had a debate on the Children's Life Fund, which has been the subject of a lot of analysis, post-analysis. And yes, there were exchanges in the committee stage, which resulted, the record is clear, in a casting vote on 3 occasions. But in the end, the bill carried with the support of this chamber and with the support of independent voices. I heard no one from the opposition seeking to put pressure.
Mr. President, I'm just wondering, we have given my friend a long room.
Is there a standing order?
Let's just get standing order 46-1.
Just connect.
Thank you, Mr. President. It's easily connected, Mr. President. I'm just going through the sequence of 3 bills that bring us to this particular point. With respect to the TTRA, which the opposition was very clear in our disagreement with the formula.
Mr. President, once more, what does that have to do with the bill before us? 46-1.
I'm just asking you to just quickly, and let's move on, please.
And we made no protest when that succeeded, notwithstanding opposition. And here we are today, Mr. President, with this particular bill, responded to initially by Senator Faris Alwari, and we've also had a very strong contribution from Senator Foster Cummings. And it is clear that this opposition is in support of the reform of the Prime Minister's pension arrangements in its broad sweep. It is also clear that we have concerns and serious questions about certain aspects of this bill. I'm going to go a little further into a few of those concerns, Mr. President, but I feel compelled to state that notwithstanding whether we find support from the independent voices or not, we will respect our democracy and we will respect this chamber. I said it before. There's a reason the framers, and you know, Mr. President, there's a reason the framers of our Constitution designed the Senate in this way. And therefore, if this or any measure is able, Mr. President, is able to cross that hurdle, you know exactly the point I'm making, Mr. President. We will accept it. Mr. President, let me go immediately to the core of the government's disquiet. Clause 2. This act is deemed to have come into force on the 10th day of March 2025. Mr. President, we've had so many contributions. I was listening keenly and quietly. I did not hear any presentation, analysis, or question of that date. Mr. President, there's a member who is seeking to establish the wrong pattern of conduct in this chamber, and I ask that I deliver my presentation in silence in accordance with the standing orders. Thank you for your guidance, Mr. President. What is special, and they're continuing. What is special, and maybe the good minister in his winding up will take us, the members of this chamber, into the confidence of the government. What is special and particular about that date to cause the government to draft this legislation in this manner? Put your cards on the table. I listened closely to Senator Dr. Murray, who hinted at a similar question. What is special? So I tried to answer. The government hasn't offered any insight into their thinking on this, I tried to do my own analysis. So I looked at the 10th of March domestically, regionally, and internationally to see if there was some trigger, some event that may have caused the government to be particularly concerned about dating this, about bringing into force these measures on that specific date, because that is what we as senators are being asked to support. So this is a request, as I've done before, to the government to put their cards on the table and explain the phrasing of this measure. I saw a lot of things that took place on March 10th, 2025. I couldn't find anything remotely related to the consideration of prime ministerial pension. There was civil war in Syria with some horrible developments on that day. I couldn't see a relation. There was a ban in British Columbia on alcohol imports from the United States of America. Didn't see any trigger there. The situation in Gaza was continuing to deteriorate. I do note that 7 days later, exactly 7 days later, there was a development in the politics of Trinidad and Tobago. So I would want the government to indicate whether or not this is connected to developments that took place on the 17th of March. If so, why go back 1 week before that? What is the logic? What is the intelligence behind this particular drafting? If you are asking me to consider a legislative measure, I think it is only fair to me and other colleagues to be very clear about what would have caused you to draft it in this particular manner. So that's a question that remains on the table, and an invitation for the government to respond substantively. Take us into your confidence. I ask those questions, Mr. President, because there's been some dancing around this ad hominem question. The government has made a case, and I thought in his maiden contribution, Senator Alahar, the leader of government business, went to great pains to make a case that in and of itself, ad hominem legislation is not necessarily radioactive or beyond consideration. He went to great pains in that regard. But my question to the government is whether or not they accept that this is an example of ad hominem legislation. If it isn't, should I, Mr. President, you didn't give the full guidance. And so to the leader of government business, wait. You have two options. One is to move a standing order. The other is to request of the, you'd only learn if you listen, to request of the member speaking to give way. So you can do so,
Mr.
or you can
Speaker,
move a standing
Mr.
order.
President, thank you for the lesson 42.9.
Mr. President, I will continue my...
Yeah, please. Are you raising a point of order?
Mr. President.
40?
42.9. Mr. President, very briefly.
No, 42.9 will only take place after his contribution.
I want a chance to explain, and if you give me after.
Yes, but after his contribution. Continue, please.
Mr. President, if he had asked to give way, I would have given way. But anyway, let's move on. I think it may be an attempt at distraction, unfortunately. So I would want the government to be clear on that. And they took us on a tour of the region, Antigua and Barbuda, the Bahamas, etc. There were other references even to Jamaica, Barbados, Guyana. Someone went to India as well. I think quite topical, seeing that we have an esteemed visit coming up very soon. Sorry? Of course, right? So, Mr. President, I think what the government was able to establish is that there are a number of jurisdictions in which there's a tiered approach to the Prime Minister's pensions arrangements or head of government pension arrangements in a number of jurisdictions, depending on duration of service. And that we accept. And that aspect of this amendment bill, we find some favor with us for consideration. What I did not hear in this tour of the region and the world and India and other places is a precedent for the approach of the government with respect to Clause 2. So again, it begs some further information and content with respect to the decision to bring the act into force on a date in the past. I would want to remind, Mr. President, all members of the solemn oath that we undertake as parliamentarians to act without fear or favor, malice or ill will. And in so considering, we must acknowledge strong public sentiment around this particular matter. Members have read from their WhatsApp communication. Other members have indicated that their phones have been ringing off the hook. And I mean, once you're in Trinidad and Tobago, you must recognize that the society is paying attention to this. There are some, Mr. President, who really don't have any objection. I would say the majority appear to have no objection with their Prime Minister and more broadly, their parliamentarians having a suitable pension arrangement when they no longer hold office. There are views that have come to me from the public space that it would be a grave injustice to go back in time, to reach our hands back into time to reduce or remove or reduce an entitlement to which an office holder or a former office holder would have had a legitimate expectation at the time. And that's something I also want to place squarely on the table, that there are also those views. So in giving the public sentiment, let us not just assume that everyone is saying the same thing. So if we are giving due consideration to the will of the people and what the voices in society are saying, there's also such a view. There are views that this really is a very unique situation that we are treating with. And I heard several senators suggesting that there might be a formula for us to avoid this conundrum in the first place. I do wonder, Mr. President, whether the framers of the Parent Act ever really gave contemplation to what we experienced in the first half of 2025. I really do wonder quite sincerely. And it would be unfair if I don't say, yes, there are some in society who are very disquieted about the reality that there could be a very brief period of service that would have led to a very large pension entitlement. There are those views as well. So where does that leave us as decision makers on this matter? Mr. President, I'm of the view that people in this society, by and large, don't like injustice and are made uncomfortable if they have a feeling that an injustice was perpetrated. And so that's something that we also have to treat with as parliamentarians and as politicians. But is it the right thing to do to try to cure or treat with a perceived injustice if we do so by committing a further injustice, particularly with respect to the law and constitutionality. So those were some of the questions. You might deem them rhetorical, but I think them important for how we arrive at a final conclusion on this matter. And I don't think the problem is as simple as the government might wish it to be. But part of the answer is how they would respond to the questions I have already asked. Do you seek to correct a perceived injustice via an unlawful or unconstitutional action or bill? And is that a responsible position for the Senate to arrive at? Mr. President, we cannot go back in time. We can't go back to March or last week. We have to look ahead. There was a recommendation in the other place, and it was recommended here as well, that the government give consideration to the prospect of a joint select committee, which would allow all sides to put their heads together. I've heard no one resisting the overall broad implication of reform of these pension arrangements. I've heard numerous interventions which demonstrate discomfort and disquiet with respect to the retroactive nature of Clause 2 and the inescapable ad hominem application of these measures, unless the government can point to multiple individuals or former office holders or former prime ministers who would have their circumstances not positively, but negatively impacted by Clause 2. So that's another invitation to the government. If this is not directed at one individual, to so demonstrate by indicating the other members of this small or large group that would be negatively affected by this March 10th application. And the Prime Minister of today started her journey with a public address, her journey in this chapter with a public address that struck a chord of collaboration. The leader of the opposition did the same in her inaugural address as leader of the opposition. And my suggestion is this may be an opportunity to put their words to the test, seeing that all benches find some harmony on the issue of reform. It would only be a very small minority that appears not to generally accept the overall formula presented by the government in Clause 6, but likewise, there is a significant number of senators who are very uncomfortable about Clause 2. My suggestion in this debate and in this regard to the government is to avoid crossing this line. Because once you cross a line like this, it can be crossed again. And our actions today, Mr. President, will be cited, maybe not by this government, or maybe by the next or the one that comes after that. The line of withdrawing or reducing a pension entitlement of an office holder who we don't have to like, or former office holder who we don't have to like. And part of our duty in fulfillment of our oath is that we have to be able to take actions to defend those who we may dislike or dislike intensely at times, if we are to be fair in the discharge of our duties. So that's a broader message going out to the chamber. You don't have to like someone in order to defend their rights. You do not have to like or admire someone to defend their rights. Mr. President, I want to make a few remarks. The Minister of Labor has intervened on 2 occasions thus far in this Senate, and his comments today have been remarked upon in a flattering light, with commendation by some of the speakers who've entered the debate before me. To my ear, he didn't focus on the clauses of the bill essentially, but painted a broader picture of the labor context against which this measure is to be viewed or juxtaposed according to the government. And he did make a bit of a political case, citing the experience of one citizen who worked at WASA, and some other examples. I would say appealing, making a bit of an emotional appeal that there are a number of categories of nationals of Trinidad and Tobago who, unfortunately, have expectations and entitlements far, far lower and far different to the world of a prime minister with respect to pension. So he made that type of political case. But Mr. President, I want to refer to a judgment that several have referred to already in the Privy Council appeal numbers 0014, 0015, and 0016 of 2015. Of course, this is the Steve Ferguson versus the Attorney General of Trinidad and Tobago. And I want to take you to page 12, paragraph 27 of that particular judgment. And I'm going to quote here just a few lines. How is the court to ascertain a more specific purpose behind an act of parliament than its general terms would suggest? Although this question commonly arises in politically controversial cases, in the board's opinion, the answer does not depend on an analysis of its political motivation. The answer does not depend on an analysis of its political motivation. The test is objective. So notwithstanding the case being made that this addresses a political concern or a political trigger, we have to apply very objective tests, as a number of senators have attempted to do in coming to a final determination on this particular matter. Mr. President, the other thing the Minister of Labor offered us today is a very useful truism when he said privilege must not supersede responsibility. Am I quoting you fairly correctly? Privilege must not supersede responsibility. I agree with this wholeheartedly, Mr. President. But I also want to say that the privilege of an electoral majority does not supersede our responsibility as an upper house to make and approve good and sound and constitutional laws in Trinidad and Tobago. One of the worrying references, and it's becoming a bit of a refrain from the other side, is that somehow if a matter carries in the majority in the other place, we have to be guided by that, or that should guide our consideration. Mr. President, I strongly disagree with such a presentation. As we know, the business of both chambers is separate. And when a matter comes here, it has to stand on its own legs, and the presentation and case has to be built on its own merits. So we are not persuaded by that line of approach, and I would suggest that the government discontinue that line of approach. The privilege of that majority does not supersede our collective responsibility as senators to make laws that are fair, just, constitutional, and designed not to target one individual in a negative manner, whether you like him or dislike him, whether you like her or dislike him. So, Mr. President, I do not intend to take all of the time. I heard a reference to the likelihood of an amendment being circulated to amend Clause 2 specifically. I want to give the government due notice that we on the opposition bench will also be circulating an amendment in this regard. I look forward to consideration of such amendments in committee stage. I invite further detail on into the insight of the government with respect to the 10th day of March. I remind all senators that this legislation, this amendment bill, is clearly ad hominem in nature. It is a view of the opposition, and I would say any reasonable observer, that the category of citizens, of nationals affected by Clause 2 amounts to a grand total of one person. The government should put those cards squarely on the table and give some additional insight into their decision to bring this into force on the 10th day of March 2025. So, Mr. President, we do not believe this bill as it is currently structured is constitutional. We do not believe it is just. We do support significant reform of the Prime Minister's pension arrangements, and it is our hope that a collaborative approach in this chamber can achieve a just and fair and constitutional, socially accepted outcome in the best interest of all citizens of Trinidad and Tobago. With these few words, Mr. President, I thank you.
The Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, thank you, and thank all members for their worthwhile contribution. And has been pointed out several times, this is a very important debate, and a lot has been said. Like Senator Timol and others, I am not a lawyer, but the AG reminded me that in his contribution, he was at pains to point out that in this legislation, nowhere can it be construed as being ad hominem. And just to remind you what the AG talked about in the Ferguson matter, let me just read a small paragraph, Mr. President, if I may. The amending act not only looks like general legislation, it is general legislation. It affects all cases to which Section 34 would otherwise apply, past, present, and future. And again, this needs all to be emphasized. It affects all past, present, and future. It is wrong then, it is wrong now, and it will be wrong in the future. This includes a very large number of persons and cases against which it cannot have been targeted. Again, because the future hasn't yet happened. It is right to add that if the concern had been only or mainly with the appellants, the logical course would have been to amend Section 6 so as to add the offenses with which they were charged to the list of those excluded from Section 34. That was one of the options proposed by the DPP, but it was not the one adopted. I hope I got that right for the lawyers who are here. Just to go back, Mr. President, I have also tried in my opening remarks and in this debate to really stay away from the politics. In fact, it is those opposite that have sought to insert politics into this debate. To go back to Senator Lewis's comment about the Gethsemane moment, and Honorable Senator, you just don't talk to somebody like me about Gethsemane. But seeing that you introduce it, I will gladly expound on it. I just want to say, based on my limited knowledge of the topic, that Gethsemane moment led to a transfiguration on a cross. It requires courage, Senator Lewis, to take up your cross and walk to that journey when nobody else will. That is what true strength is. Knowing what you believe and being prepared to stand on that belief. And that is why, Mr. President, members of the Senate, it is important for us to recognize the fact. And and I just want to, as I'm on that, let me just also say to my colleague, the Honorable Minister of Labor, it is so important for us to recognize that. And going back to Senator Brown's comment, to put our cards on the table. You know what card we want to put on the table, Mr. President? The card that this government stands for the working class. Yes, please.
For us to take a suspension, refresh, and we should come back here at 5:30 p.m. 5:30 p.m. This sitting is now suspended until 5:30 p.m.
Now warming up.
You see?
Give praise. I give praise, children, yeah. Give praise. I give praise, children, yeah. Give praise. I give praise, children. Our Father who has given us this earth so we can all feel like we're a part of this earthly heaven. Forgive us this day our daily weakness as we seek to cast our mortal burdens on your city.
Well, this one is class. The charge a magistrate for driving too fast. You mustn't doubt me. Well, this one is class. The charge a magistrate for driving too fast. But there's one courthouse in the district. He is the only magistrate there to run it. If you see how the people flock up the place, you see how the magistrate go try your own case. He self tell himself you are charged for speeding. He self start to shout the policeman lying. He self tell himself to shout. He said no sport and he charge himself for contempt of court. He said, go ahead, let me hear what happened. So the police said, so you see how this man could speed, and he pointed at the magistrate, Johnny Mead. The magistrate asked him who he talking about. Is you even mean? The policeman shout out. The magistrate pick up a looking glass and ask himself, is it true he was driving fast? He self told himself, you are charged for speeding. He self started to shout, the policeman lying. Himself told himself to shout, this is no sport, and he charged himself for contempt of court. Then Mr. Carruth, he came up and he started to prosecute. The magistrate then called his lawyer to defend the defendant, who is your honor. And all the time that the lawyer talking, the magistrate serious, sometimes he laughing. At that the magistrate tell you himself, look, I have a great mind to take away your license book. He self told himself, you are charged for speeding. Himself told himself, the policeman lying. Himself told himself to show, this is no sport, and he charged himself for contempt of court. Yes, I nearly dropped when the man take out the pen and start to sum up. Partner, I start to study if he gonna put his own self in custody. I was wrong because again he took out the mirror. He tell himself to pay $20. He bust out a cry. He turn around and say, give me a chance. I want a little time to pay. He told himself, you are charged for speeding. Himself told himself, the policeman lying. Himself told himself, all right, I will be kinda giving you 5 years to pay the fine.
of many varied races. May we possess that common love that binds and makes us one. Let it be known around the world that we can boast of unity and take our pride in our liberty. God bless all isles of tropic beauty, a flaming point sea and the shady warm and sparkling waters that break upon our shores beat out a tune that seemed to tell we take our pride in our liberty. God bless our leaders. Give them grace, God. Give them grace to God. Bestow on them thy judgment. Bestow on them thy judgment wise to rule the land aright. Keep a flag of freedom high. To keep the flag of freedom high. We may sing, that we may sing most constantly. We take our pride in our liberty. We take our pride in our Thank God for life every day. As my rise, me say I pray. The sunshine shining on me face. Me thank the Most High for His grace. As me jump out of me bed and me open me word and me start to breathe. I know me physical self, but me spiritual self for me I go free. Some boy want me dead with gunshot in my head, but that me not pray. Cause Jesus guide me from my enemy. Thank God for life every day. As my rise, me say I pray. The sunshine me face. Me tongue the most high for his grace. Me not trying to make it seem like life is easy. Sometimes life get hard like mathematics, believe me. I never KFC on a Friday, but Satan busy. But me not study that because she's a sweet in my life like a sweetie, yeah. Ooh, thank God for life. Ooh, as me rise. Ooh, thank God for life. Ooh, yeah, as me rise. Thank God for life every day, yeah, as me rise. Me say I pray, yeah, the sunshine shining on me face. Me tongue the most high for his grace. Ooh, thank God for life. Ooh, as me rise. Ooh, thank God for life. Ooh, yeah, as me rise. Thank God for life every day, yeah, as my rise. Me say I pray, yeah, the sunshine shining on me face. Me tongue the most high for his grace. As me jump out of me bed and me open me bird and me start to breathe. I know me physical self, but me spiritual self for me I go free. Some boy want me dead with gunshot in my head, but that me not pray. Cause Jesus got me from my enemy. Thank God for life every day, yeah, as me rise. Me say I pray, yeah, the sunshine shining on me face. Me tongue the most high for his grace. Me not trying to make it seem like life is easy. Sometimes life get hard like mathematics, believe me. I never KFC on a Friday, but Satan busy. But me not study that because she's a sweet in my life like a sweetie, yeah. Ooh, thank God for life. Ooh, as me rise. Ooh, thank God for life. Ooh, yeah, as me rise. Thank God for life every day, yeah, as me rise. Me say I pray, yeah, the sunshine shining on me face. Me tongue the most high for his grace. Ooh, thank God for life. Ooh, as me rise. Ooh, thank God for life. Ooh, yeah, as me rise. Ooh, Me lover, I have to mention in my confession to you, me lover, and must discuss what we should and shouldn't do. As a me lover, a good relation is a relation based on trust. Me lover, we too jealous and suspicious. It's outrageous and ridiculous to see we messing up in mind. See how we messing up in mind. I tell you no. Me lover, let's have a good time. No, me lover, let's have a good time. No, lover, let's have a good time. Oh no, let's have a good time. Me lover, I used to worry about you having a second hand. Me lover, as if to help me fulfill my duty as a man. As a me lover, you know we tripping, we really stupid for true. Me lover, it's so amusing to hear we abusing and accusing. It's so confusing. I know they're messing up in mind. Oh, I know they're messing up in mind. Me lover, me lover, me lover, me lover, me lover, me lover. Oh, let's have a good time. No, me lover, let's have a good time. Me lover, let's have a good time. Me darling, no, let's have a good time. I said, me lover, your love too precious and too delicious to lose. Me lover, and you too vital and too special to abuse. Me lover, what good for ram goat is good for gander and goosey too. Me lover, you must remember me baby lover. When you out yonder, protect me pleasure and don't go messing up my mind. No, don't go messing up my mind. Me darling, no. confession to you. My lover, and must discuss what we should and shouldn't do. As a lover, a good relation is a relation based on trust. My lover, we too jealous and suspicious. It's outrageous and ridiculous to see we messing up with mine. See how we messing up with mine. I tell you no. My lover, let's have a good time. No, my lover, let's have a good time. Let's have a good time. Oh no, oh no, oh no. Let's have a good time. My lover, I used to worry about you having a second hand. My lover, as if to help me fulfill my duty as a man. As a lover, you know we're tripping, we're really stupid for true. My lover, it's so amusing to hear abusing and accusing. It's so confusing. I know they're messing up your mind. Oh, I know they're messing up your mind. My lover, my lover, my lover, my lover, my lover, my lover. Oh, let's have a good time. No, no. I'm telling now. I'm telling you. I'm telling them now.
The Honorable Minister of Planning, Economic Affairs, and Development, and the Minister in the Ministry of Finance.
Mr. President, thank you. And thank you for that nice break. Seeing that some of my colleagues who I wanted to try to reach out to in this debate are not here, let me then begin my contribution this time around using the words of Senator Timur. And just to say that I agree with fiscal responsibility, and I would have shared some data with you, and I'll share it with my colleagues, that our pension, annual pension at this time, Senator Dan Paul will probably know the figure better than based on his own experience, but annually we pay roughly about 145 million every month in pensions. More, yeah. And possibly cumulatively from an annual perspective in the budget, we would have budgeted probably about 1.7, 1.8 billion in pension payments. So pension is no small matter. It does cost significantly a lot. And as we add to that, we keep adding to that cost. And my colleague, Senator Roberts, reminded me that government daily rated workers do not receive a pension, just a retirement benefit. And they have to wait until the age of 65 before they could access it. So to say that the discussion on pensions is one where we can easily focus on the impact that this may have, or to use the words, I think, of one of the contributors talked about legislation that will allow someone. This is not, we can't pass legislation based on what people may or may not do. And I'm sorry that Senator Lewis isn't here, but I wanted to expound a little bit on the Gethsemane. But let me just add Senator Candace Jones-Simmons. You know, when you talk about law, in my own training as well, Senator Simmons, the Sabbath was made for man, not man for the Sabbath. Laws must give life, but laws must also seek to be fair and just, and to use the words of my brother, equitable. It is the reason why, to expound further on the Gethsemane metaphor, when I was doing my own research early on in my life, I used to enjoy reading the documents of Vatican II. And in the Vatican II documents, there's a chapter about church in the modern world. And one of the institutions that have been slow to change is, of course, the church. And in the Vatican II documents, in the church in the modern world, it says that in every era, the Catholic Church must seek to be relevant to the people to which she serves. The issue, therefore, of relevance also impact on the time and the nature of how things were done, when it was done, and when there is need to update it. And therefore, this legislation that was cast in 1969 is an urgent need on updating. Now, I would leave the legal discussion to the Attorney General, but suffice it to say that that lacuna in the law must not be a reason for us not to look at it and to see how we can then make better legislation. In fact, the Attorney General in his contribution did point out the fact that when we had erred, we came back and we fixed it, notwithstanding the retroactive activity in it, if I'm correctly stated, with the matter of Ferguson. So, my dear friends, members of the Senate, I want to therefore, in the words of Senator Brown, put on the table this government's decision to be fair, to recognize that our oath, the oath we take, is to the people of Trinidad and Tobago, to be proportional, to be even-handed, but to be complete in the things we seek to do and to make sure we do it without fear or favor or any ill will. So, permit me then to go back to some of the other comments that were made. First thing, of course, just to say that we will not move, we will not ever, on this discussion, seek to move to a joint select committee. Second thing, of course, is to remind senators, I was in a cabinet before, and in that cabinet, SRC reports did come. And it goes to the cabinet, not to the parliament, it comes to the cabinet first. And cabinet can amend, could accept, could reject. In fact, in our case, when I was there, I remembered it being rejected at one time and sent to come back with amendments. So to say that the SRC reports are sacrosanct is nothing could be further from the truth. They are subject to cabinet provisions before they come to parliament for sign-off. And I stand to be corrected, but I think that is at least I remembered that being the procedure then. And therefore, senators, when we come to this bill, you know, going back, Senator Simmons, to something that my friend, the Minister of Labor, talked about, and I want to just remind us that there are so many people in this country. If you think, for example, of the hundreds and the thousands of workers who wait And all, I do think I'm wrong in saying most collective agreements are done retroactively. Most. All go back in time. Because it is never at a point in time when the last one outstanding, that when those opposite wing governments in 2022. 2013. So this is no stranger to us as government. It is no stranger to them as government. Part of what we have to do in seeking to do anything is to make sure that we are consistent. And I mean, I used it earlier on, but you know, as I said, I'm trying in this debate not to go down a political road. But to be consistent is to make sure that what we ourselves want, you know, I think I can't remember how the Minister of Labor put it, but what we want for ourselves, we must also want for other people. And what we do to them, do unto others as you have them, do unto you. So what's good for the goose is good for, that's how he said it. I was trying to remember. But I want to go back to some of the things that Senator Timol raised. That public reward must reflect public responsibility. Could not agree more, Senator Timol. Could not agree more. Could not agree more that we must also do things that are morally justifiable. That we are building trust with the public. These are some of the reasons why all senators must support this legislation. That high office, those in high office will be held to high standards. Senator Timol reminded us that public reward must be grounded in tenure of service. And I think Senator De La Bastide spoke to that as well. These are some of the reasons why, to go back to the Gethsemane moment, that we are asking all senators to have the courage of conviction to stand with the government in support of this legislation. It is high time, you know, we talked in a past moment, we talked about all the pieces of legislation that need updating. Talked about the Public Service Commission, about all the things that we frown upon, that we have faced time and time again, with decisions of how can we make this better. This is one case that we can take a piece of legislation and make it better. Better for those who are here, better for those who are yet to come, and also put a great body to it that will make it withstand the scrutiny of time. Because as we reminded, there will be those who will come after us, who will look at it in time to come. So, Mr. President, I want to remind all of us in this honorable House that we are making sure that we start to address deficiencies that exist one by one. We are starting here, but there are others, I am sure, that will come. And we are asking this House, this honorable House, to support us in making sure that we all recognize the fact that this is something not only that we have to do, but we must do. We must do this. We must send a signal to people that any worker is worthy of their wages, that every reward is given based on person's contribution. You know, I remember distinctly when we had faced a difficult moment, and when we had to face the times when we have to make difficult choices, This is not one of those times. This is not a difficult choice to make, and I disagree with my colleague, Senator Brown. This is the right thing to do, and all of us know it. All of us know that this is what we have to do. What we must find is the courage to do it. I will therefore remind this honorable House with the words that Senator Timol ended in his contribution, that the law is for public good, for past, present, and future. It is that kind of view that in commending this legislation to this honorable House, we want to ask for your support. We hope that, like us, you too feel that there is a need for us to make sure that provisions such as these are supported, not just by those in government, but by all of us. It is high time that there are things we can play politics with, and there are things we have to do because this is the right thing to do. So I have, and I will refrain from responding to any of the political comments. When we agree to be part of this journey, we embraced a huge part of our platform and agenda was what we call the workers' agenda. A huge part of why we went to the electorate and asked them to put us in government was to support and with the support of that workers' agenda. And every time we come and we stand before you, at the back of our mind remains that commitment to do good by all people and all manner of persons, including those that have been significantly ignored over the last 10 years. And so it starts by making sure that we address this. It will continue when we address other deficiencies that have not been looked at. But it will also require us to remember, and I want to remind the honorable senators, we talked about it earlier on, but let me say it again, that there are a large number of persons who have to spend time in the trenches, who have to spend time on their job. Members of parliament, no less than 5 years. Diplomats, no less than 8 years. Public servants, 10 years and up. Teachers, 10 years and up. Police, not less than 10 years. Fire, not less than 10 years. And if my memory serves right, people in the defense force, no less than 20 years. This legislation is not a cure for all, but it is a symbol of trust. Trust that people are putting us to do the right thing for the right reason, so that all could see that this is a government who listens, this is a government who cares, and this is a government who is not afraid to make the hard decisions. So, Mr. President, I am asking all of us to support this legislation and to make sure that we lay a framework that is consistent with all the things we all agree, with all the things we all believe, with the oath that we have taken, and with a decision before us to make sure that all peoples are served, all manner of peoples are served, and that we are part of that collective unit that is not afraid to say, this is not right, let us fix it. Mr. President, I beg to move.
Honorable Senators, the question is that a bill entitled an act to amend the Prime Minister's Pension Act, Chapter 251, be now read a second time. Those in favor say aye. Those against say no. I think the ayes have it. The Honorable Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance. Just a second, please. I think my colleague has a long title. Sorry about that.
A bill entitled An Act to Amend the Prime Minister's Pension Act, Chapter 251.
Yes, Honorable Minister, you can now.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Prime Minister's Pension Amendment Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
The question is that the Prime Minister's Pension Amendment Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. All right, colleagues, we have a bill with 6 clauses before us. We have amendments from Dr. Amory Brown, Senator Dr. Amory Brown, and we also have amendments from Senator Dr. Desiree Murray. Okay?
Clause 1.
The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favor say aye. Aye. Any against? I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. There are several amendments before us. We have from Dr. Amory Brown, and we have from Senator Dr. Desiree Murray. So, Dr. Brown, could you?
Refer to Senator Murray
Okay,
with
Dr.
her
Murray.
amendment, and then we can consider mine.
All right, Dr. Murray, the floor is yours.
Thank you, Mr. President. My proposal is to delete clause 2. The reason being that there's a perception in my mind of ad hominem, and I believe that it's in the best interest in the public good to not have that perception, and I'm proposing that clause 2 be deleted.
Yeah, Honorable AG, your thoughts on this proposal, this amendment rather?
Chairman,
Yes.
we think that the bill is, as it's drafted by the public servants, meets the criteria set out in Ferguson with respect to retrospective legislation. Just to recall that in that case, they say that in Ferguson, they say that there's a presumption, that is to say, the courts, in construing something, will look at it. But the default position would be that there's a presumption against. If you state that the legislation comes into force on X and Y date, there's no room for the operation of the presumption. It is clear, the courts do not have to interpret that. What they have to do is to ensure that the legislation passes constitutional muster. And they do that by reference to the tests which are set out in Ferguson and the cases before it. So we don't agree, although we appreciate the spirit behind the helpful suggestion. We think that to make it damages the equilibrium that we have sought to have here. We think that the law will stand constitutional muster.
All right, I think that, so the question is that clause 2 be amended as circulated by Senator Dr. Desiree Murray. Those in favor say aye. Can I ask for the undivided attention of all members of the Senate, so you do not sleep whilst I am speaking, or you do not speak whilst I am putting the question, else you would not be aware of the question. So let me put the question again, and please listen attentively. The question is that clause 2 be amended as circulated by Senator Dr. Desiree Murray. All in favor say aye.
Aye.
Any against say no? No. I think the ayes have it. We have an alternative from Dr. Desiree Murray, Senator rather, Dr. Desiree Murray. Dr. Desiree, Senator?
Thank you, Mr. President. My alternative amendment would be to delete the words 10th day of March 2025 and substitute the words, and may I beg your leave to make an amendment?
Yes.
Substitute the words 23rd day of July 1969. And that would be because that was the day that the Parent Act came into effect. The reason for requesting this substitution or proposing the substitution is that there is a perception in the public domain that there is ad hominem, even though I understand the explanation put forward by the Honorable Attorney General. And in order to alleviate that perception and assuage some of the difficulty some people have with that date, of 10th March 2025, making the amendment retroactive to 23rd July 1969 would help with that perception of bias, because it would then apply to all former prime ministers of the independent nation and subsequently the Republic of Trinidad and Tobago. Thank you, Mr. President.
Thank you. Honorable Attorney General.
Chairman, the response is the same as it was before. We thank the senator for the helpful suggestion. We do not at this time think that this amendment would benefit us. Again, the public servants have advised that we pass constitutional muster by using the 10th of March 2025. It's a date certain. It ousts the presumption, which is a rule of construction. It makes a date certain. And in Ferguson, in any event, they spoke to legislation which had both a present, a past, and a future dimension. And we think that this legislation does that. It addresses a general problem within the language of Ferguson, which was highlighted by the specific facts, which of course bring us here today.
Okay. All right. Honorable members, the question is that clause 2 be amended as circulated by Senator Dr. Desiree Murray and be further amended by substituting the words to the 23rd day of July 1969. All in favor say aye.
Aye.
Any against say no? No. I think the ayes have it. No.
Division.
No, my error. I have to apologize. Yeah. No, let me just put back the question. Okay. My error. I apologize to my colleagues. The question is that clause 2 be amended as circulated by Senator Dr. Desiree Murray and be further amended by substituting the 23rd day of July 1969. All in favor say aye.
Aye.
Any against say no? No. I think the noes have it. So we now go to clause 2. Oh, you're not going for division. We put the question. Okay, a division.
Mr. Alaha.
No.
Mr. Jeremy SC.
No.
Mr. Roberts.
No.
Dr. Swarat Singh.
No.
Mr. Maraj.
No.
Mr. Batiste.
No.
Mr. Alexander.
No.
Professor Prasad.
No.
Dr. Chaitan Maharaj.
No.
Mr. Beg.
No.
Miss Charles.
No.
Mr. Zakur.
No.
Mr. Smith.
No.
Mr. Nakid.
No.
Mr. Rashid.
No.
Dr. Brown.
Yes.
Mr. Al-Rawi SC.
Yes.
Mrs. Roberts Rajman.
Yes.
Mr. Dan Paul.
Yes.
Mr. Cummings.
Yes.
Mrs. John Bates.
Yes.
Mr. Vieira SC.
Abstain.
Mr. Timal.
No.
Mr. De La Bastida C.
No.
Mrs. Jones Simmons. Mr. Lewis.
Yes.
Dr. Murray.
Yes.
Mrs. Lolita Etienne.
No.
Mr. McNish.
Yes.
Ms. Phillips.
Yes.
Mr. President, the results of the division is as follows. 10 senators voted for, 18 senators voted against, and there were 2 abstentions.
Honorable members, as a result of the division, 10 members voted yes, 18 voted no, and there were 2 abstentions. The amendment is not carried. So we now go to Senator Brown. Your amendment, sir.
Thank you, Chairman. Mr. Chairman, with respect to Clause 2, proposal of the opposition is to delete Clause 2 and replace it with a new Clause 2. And I read, this act comes into operation on such date as is fixed by the President by proclamation. Mr. President, in listening to the Attorney General with respect to the response on Senator Murray's proposed amendment, we've taken note, but we feel that the date of March 10th, 2025, though yes, it is certain, it has not been justified in the presentation of the government. So it is difficult to have confidence that it is reasonable in the law. In that regard, we are offering an amendment to remove this retroactive clause altogether, and upon proclamation, the act would come into effect. Again, the question arose in the debate, and we did not hear any justification of the specific date in Clause 2, and that's the rationale for this.
Honorable Attorney General, please. Any response?
Well, this formulation, unlike the others, it's completely devoid of merit in our view, in the sense that it puts the statute on the books without any consequence. If it is said to come into effect on a date to be fixed by proclamation, that's the worst possible of all worlds. It means that whatever we do here today has absolutely no effect. It sits on the statute books. It might never come into effect, and it destroys every attempt that we have made strenuously to fix a problem. So the government will, unlike the other 2 amendments, which are designed to make the legislation workable, we think that this one is designed to cripple it, to kill it in the womb. And we vehemently oppose this.
Okay. All right. The question is that Clause 2 be amended as circulated by Senator Dr. Amory Brown. All in favor say aye. Aye. Any against say no? No. I think the ayes have it. Clause. The noes have it. The noes have it. A division, please.
Mr. Alha. No. Mr. Jeremiah C.
No.
Mr. Roberts. No. Dr. Swarat Singh.
No.
Mr. Maharaj.
No.
Mr. Batiste.
No.
Mr. Alexander.
No.
Professor Prasad.
No.
Dr. Chaitan Maharaj.
No.
Mr. Beg.
No.
Ms. Charles.
No.
Mr. Zakur.
No.
Mr. Smith.
No.
Mr. Nakid.
No.
Mr. Rashid,
No.
Dr. Brown,
Yes.
Mr. Al-Rawi SC,
Yes.
Mrs. Roberts Rajman,
Yes.
Mr. Dan Paul,
Yes.
Mr. Cummings,
Yes.
Mrs. John Bates,
Yes.
Mr. Vieira SC,
Abstain.
Mr. Timal,
No.
Mr. De La Bastide SC,
No.
Mrs. Jones Simmons,
Abstain.
Mr. Lewis,
Abstain.
Dr. Murray,
Abstain.
Mrs. Lalit Etienne,
Abstain.
Mr. McNish,
No.
Miss Phillips,
Abstain.
Mr. President, the result of the division is as follows. 6 senators voted for, 18 voted against, and there were 6 abstentions.
Honorable members, the question, as a result of the division, 6 members voted against. No, 4. Is 4? Yes, 4. 6 members voted for or in favor of the amendment. 18 members voted against the amendment, and there were 6 abstentions. Therefore, the amendment as proposed by Senator Dr. Amy Brown is not passed. Let's go again.
So put the question that clause 2 stand part of the bill again.
The question is that clause 2 stand part of the bill. The question is that clause 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 2 now stands part of the bill.
Clauses 3 and 4.
The question is that clauses 3 and 4 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 3 and 4 now stand part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. We have an amendment from Senator Dr. Desiree Marie. Dr. Marie, the floor is yours.
Thank you, Mr. President. My proposed amendment is that clause 5 be deleted. The reason being that this would make ineligible a prime minister who served for less than 1 year. And this would have serious implications in the event of injury or illness, which was beyond their control, and would then have a knock-on effect with implications for their widow or even surviving spouse, and any children who were any dependents, but there's a word in the legislation, sorry, that doesn't come to me, any entitled children. So I feel that because of the potential negative impact on the spouse and child or children of any prime minister who serves less than a year due to injury or illness or even death, I feel that I cannot agree with clause 5, and I respectfully request that it be deleted.
Attorney General.
Yeah. Chair, this is
Yes.
again a useful amendment, but it cannot be taken in the Prime Minister's Pension Act. If you look at the Parent Act, there is no provision, I am told. Again?
So this is okay. This There's no way to consider this. We have to consider this.
The same. And as long as you also up to 1 year, up to 1 year, there's only 1/3. That's what it's understood. You want to just leave it as it is. But it's not because of the proviso. The proviso to the table. This is what's on the table. They stick to the policy.
Okay, yeah. Chair?
Yes.
Yeah, so the public servants have advised, and we agree as a matter of policy, that it will be best to stick with the policy of the bill as it is drafted in 5. Now, when we come to the alternative, are we taking that now?
No.
Okay.
We'll take it after. Okay, the question is that clause 5 be amended as circulated by Senator Dr. Desiree Marie. All in favor say aye. Aye. Those against say no. No. I think the noes have it. Right. So we go on, Senator Desiree Marie, we go on to your alternative, please. 5.
Thank you, Mr. President. My alternatives proposal would be as follows: to delete clause 5 and substitute the following. Under section 3(1) of the Act, amended by 1, inserting after the words "any time after" the words "1 year from the date of," and 2, inserting after the words "appointment to be Prime Minister," and I do beg your indulgence, there's a slight amendment again. After the words "appointment to be Prime Minister," the words "provided that this is not due to illness, injury, or death in the line of duty." So I'm apologizing because there's an amendment where I'm adding "in the line of duty."
Yes, Honorable Attorney General. Senator Dr. Murray, where are we putting in the line of duty?
Those would be the last 5 words to the amendment. Illness, injury, or death in the line of duty.
Okay, okay.
I don't know if I should read how the clause would now read as amended. It might make it easier, I'm not sure. Okay. So if the amendment is carried, the section 3(1) would now read, "Every person who, having been appointed Prime Minister on or after the 31st day of August, 1962, ceases at any time after 1 year from the date of such appointment to be Prime Minister, provided that this is not due to illness, injury, or death in the line of duty, shall be paid pension under this Act with effect from the date on which he ceases to be Prime Minister, and subject to subsection 2, the pension shall continue to be paid during the lifetime of that person."
AG, you want to respond?
Sure. Chair, again, well-founded, but the policy of the act is to tie benefits to service for a minimum period of time. And while we take the point that someone who serves for less than that period of time might unfortunately fall within one of these categories, it's open to Parliament, to Cabinet, as it does from time to time, to make an ex gratia payment in the case of hardship. Of course, just in case persons are worried about any particular individual, I don't think the Minister of Finance in his winding up pointed out that what we are doing here does not affect materially, it does not impoverish any person, because this act applies to prime ministers. If someone was serving in the office for less than a year in March, that person would be entitled under the Retiring Legislative Allowances Act to a healthy sum of money. And there's no prejudice that is being created in any one individual. I sense that persons here think that someone is being prejudiced. That is not the case. And I say that as an aside because our position is this legislation is not ad hominem. But I just want you all to know that what we are seeking to do is to protect the revenue ultimately from contingent liability of something like $50 million as opposed to one of, let's say, $6 million. That's what the maths would work out to. So we're not able to take the amendment because of the policy, which is that you have to serve for a year. But we appreciate the sentiment behind it. Now, and in the Retiring Allowances Act, there is provisions for widows and children and so on, as we would all know.
Okay. So I'll put a question.
If I may,
Yes? Yes, Senator John, please.
if I were to, could I give a case scenario, just hypothetical? And it does not apply to any one individual. Should a prime minister and his or her spouse be involved in a tragic accident, for example, while in the line of duty, and they have young children who would now possibly be orphans, or even if the prime minister and the spouse survived, they may be incapacitated. Then if they served, or if they had served for less, if the prime minister had served for less than a year, then their entitled children would be severely impacted by this law because they would not be entitled to a prime minister's pension having served for less than a year. So I feel that there are possible scenarios in the future, not directed at any one individual, that could have significant negative impact on the survivors or the children of somebody. So I feel that this is a reasonable clause, and I would respectfully ask that the members consider it.
Yes, Senator Bates.
On the term in the line of duty, because in my mind I'm thinking that implies to me that you died while doing something like attending an official function. For example, you're in an Independence Day parade and somehow you were killed there versus you were driving to the beach with using that with your spouse and you die in a crash. When I hear any line of duty, it implies that you have to be doing something government related, not on vacation. So I was just wondering if that is what Dr. Marie is trying to impart by having that section there in the line of duty.
Yes. Honorable
Chair, I just want us to sort of focus our minds on the mischief that we are trying to address this evening. Now, I take into account the very valuable concerns raised in general terms about, well, what if X happens within a year? Of course, these things happen sometimes outside of a year. So the fundamental question that we are addressing here this afternoon, Senator Brown, is when does someone become entitled to $1 million a year? That's a fundamental question. We say that entitlement should begin at a point in time when that person has served a reasonable amount of time to entitle that individual to the benefits which will flow from having $1 million a year for the rest of one's life. And as I say, no one at present, if any one of you were in this position, I'm certain that you'd be able to walk away with a monthly income of, I don't want to say what your business would be, but you'd be getting close to $0.3 million a year. You would hardly be poor. So we're trying to fix a particular problem. We understand because there has been some discussion about the other things that we are not dealing with today. Some of those issues, what happens if X were to occur. But the fundamental thing that we're fixing today is entitlement being linked to minimum service and tiers thereafter. Perhaps we can, and I would undertake to come back to us with, I think we as a group have had discussions about what happens with respect to other persons, other officers, to ourselves perhaps, if some of these events occur. And that should be the subject of a wide-ranging review. But it's not part of the policy that we are trying to fix today.
Yes.
I hear the Attorney General and the Cabinet's policy. But just for the record, I want to state, I did raise it in my contribution, that I think, notwithstanding, this has nothing to do with any person, which came up quite a lot in the debate. But the fact remains that it's very possible in the future that someone who has attained the office of Prime Minister through the normal channels may assume office, and it's possible that that person could, due to illness, not be able to continue in the office of Prime Minister. And I am not at all suggesting anything about $1 million per year, but just that there's a third system for over a year, there can be some consideration as to, in those circumstances, what such a person will be entitled to. We spoke a lot about the dignity of the office and maintaining the dignity of the office of Prime Minister, and therefore someone in such a situation, cancer patient, you name it, may not be able to continue in office and should be given some consideration. And in keeping with the amendment raised by the senator, the question of accidents, things like that can happen. And while I understand what the government is trying to cure, those things, I think, need to be seriously looked at. And it's not every day you're going to come to Parliament to amend the Prime Minister's pension bill?
No, but perhaps the time has come for us to look at the Retiring Allowances Legislators Act again, so that you don't only focus on prime ministers who would invariably be drawn from legislators, but what is before us, of course, and I noted carefully that you said, don't want to tie you to your words, but you said someone might come to office in the normal way. I heard it. I'm not saying anything about that, but I just want you to know that I heard what you said and all the implications which might have flowed therefrom are not lost on me. We're dealing with a particular problem today, Chair, and we wish to solve that problem.
Okay. All right. Well, I think that most persons have expressed their views. The question is that clause 5 be amended as circulated by Senator Dr. Desiree Marie and be further amended in Roman 2 by adding the word in the line of duty. All in favor say aye. Aye. All against say no. No. I think the noes have it. Let's go. The question is that clause 5 stand part of the bill. The question is that clause 5 now stand part of the bill. All in favor say aye. Aye. All against say no. Clause 5 now stands part of the bill.
Clause 6.
May I beg your indulgence, please?
Are we on clause 6?
No, clause 5.
No, well, we passed that.
I have a second alternative that I would beg the indulgence of the chair.
Listen, Senator Dr. Desiree, in light of the fact that that has not been circulated, I would not allow it at this time. So we'll have to go on to clause 6.
Thank you.
Okay.
I'm guided accordingly.
Thank you. Go ahead on to clause 6, please.
Clause 6.
The question is that clause 6 now stand part of the bill. I think that there is an amendment from Senator Dr. Desiree Marie. Dr. Desiree, the floor is yours.
Thank you, Mr. President. The proposed amendment is that subclause A delete the words not less than and substitute the words up to.
Yes, you want to explain? Or it should fall?
Sorry. This is in section 4. That's being used to calculate the Prime Minister's pension.
Okay.
So it would mean that the person would be eligible if they would be eligible for 1/3 of the salary, even if they had served less than 1 year, so that it would still be part of a tiered system, but it would not be that they would get the full salary. So in other words, seeing that clause 5 amendments were not passed, this is still a way to ensure that somebody who had served less than a year as Prime Minister would still get 1/3 of the salary as a pension. Thank you.
Okay, thank you, Senator Desiree Marie. AG? Attorney General,
Chair, we appreciate again the sentiment, but for reasons similar, we are unable to accept it. We just wish to point out that in the case of ordinary legislators, you have to serve a period of 5 years before being entitled, I think, to 1/6 of a pension. So we felt that as a matter of policy, the Prime Minister being perhaps a super legislator, that period of 5 years could be truncated right down to 1 year. And the entitlement could go up instead of from 1/6, right up to 1/3. We felt that that was proportionate and that it met the test in Surat. And our advice is that this is, from the technocrats, this is what is likely to withstand scrutiny. Now, I hate to say that as legislators, our job is to pass law and to pass the best law that we can, bearing in mind the guidelines set out by the Privy Council. We are not judges. And at the end of the day, very few people would have thought that what happened in the Ferguson case would survive muster. You have a parliament after the fact saying, I am taking away a vested right, and one that involves the courts and adjudication. This has nothing to do with something like that. Even if it's a vested right, there's no court process that we are ousting here. We think that this is a less steep hill to vault, but the technocrats tell us that this is the way it's done.
Is that okay, Dr. Desiree? Senator?
Yes, Mr. President.
Yeah. The question is that clause 6 be amended as circulated by Senator Dr. Desiree Marie. Those in favor say aye.
Aye.
Those against say no. No. I think the noes have it. The question is that clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6 now stands part of the bill.
The preamble.
The question is that the preamble be approved. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The preamble to the bill is approved. Honorable Senators, the question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. The ayes have it. The bill will now be reported to the Senate. The Honorable Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, I wish to report that the Prime Minister's Pension Amendment Bill 2025 was considered in Committee of the Whole and approved without amendment. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that the Senate agree with the committee's report on the Prime Minister's Pension Amendment Bill 2025. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance.
Mr. President, I beg to move that a bill entitled an act to amend the Prime Minister's Pension Act, Chapter 251, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled an act to amend the Prime Minister's Pension Act, Chapter 251, be now read a third time and passed. This bill requires a special majority, and the clerk will now conduct a division. Clerk.
Mr. Alaha,
Yes.
Mr. Jeremy SC,
Yes.
Mr. Roberts,
Yes.
Dr. Swarat Singh,
Yes.
Mr. Maraj,
Yes.
Mr. Batiste,
Yes.
Mr. Alexander,
Yes.
Professor Prasad,
Yes.
Dr. Chaitan Maraj,
Yes.
Mr. Beg,
Yes.
Ms. Charles,
Yes.
Mr. Zakur,
Yes.
Mr. Smith,
Yes.
Mr. Nakid,
Yes.
Mr. Rashid,
Yes.
Dr. Brown,
Abstain.
Mr. Al-Rawi SC,
Abstain.
Mrs. Roberts Rajman,
Abstain.
Mr. Dan Paul,
Abstain.
Mr. Cummings,
Abstain.
Mrs. John Bates,
Abstain.
Mr. Vieira SC,
Abstain.
Mr. Timal,
Yes.
Mr. De La Bastide SC,
Yes.
Mrs. Joan Simmons,
Abstain.
Mr. Lewis,
Yes.
Dr. Murray,
Abstain.
Mrs. Lalit Etienne,
Yes.
Mr. McNish,
Yes.
Ms. Phillips,
Abstain.
Mr. President, the result of the division is as follows. 20 senators voted in favor, no senators voted against, and there were 10 abstentions.
20 voted in favor. Honorable Senators, as a result of the division, 20 members voted in favor of the bill. No members voted against the bill, and Johnson, how many abstained? And there were 10 abstentions. The bill is approved.
A bill entitled An Act to Amend the Prime Minister's Pension Act, Chapter 251.
Honorable members, honorable senators, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Friday, June the 27th, 2025, will be resumed. A bill entitled An Act to Supplement the Appropriation of the Sum, the issue of which was authorized by the Appropriation Financial Year 2025 Act 2024. Those who have spoken thus far are as follows. The Honorable Dr. Kennedy Swaratsi, Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance. Move of the motion. Senator Vishnu Danpal, Senator Timal, Senator Dominic Senator the Honorable Dominic Smith, Minister of Public Administration and Artificial Intelligence, Senator Janelle John Bates, Senator Brian Big. Honorable Senators, as I said, on the last occasion, these are the people who spoke, right? The debate on this bill will now be resumed. Anybody who's coming? Who's our next speaker? Who? All right, the Minister of Transport. Minister of Transport.
Mr. President, I rise before this esteemed House to address the Finance Supplementary Appropriation Financial Year 2025 bill. The portfolio of transport and civil aviation is one of critical importance to our nation's development and to the daily lives of our citizens. Transportation forms the backbone of economic activity, connecting communities, facilitating commerce, and ensuring that every citizen can participate fully in the opportunities that our democracy provides. Civil aviation, meanwhile, positions Trinidad and Tobago as a hub for regional and international connectivity, supporting our tourism industry, facilitating business development, and maintaining our strategic importance to the Caribbean region. Mr. President, it would be remiss of me not to acknowledge the state of affairs I inherited upon assuming office. By all accounts, there was an absence of leadership and engagement at the ministry. I have been told by staff, some of whom have been there for many years, that during the previous administration, ministerial presence and interaction was minimal at best. One senior member, whose role involves direct engagement with the minister, shared with me that in 2 full years, he never once set foot in the minister's office. Mr. President, to borrow some words from my colleague, if the population knew then what we on this side know now, the votes that my colleagues on the other side so desperately wanted but didn't get still would not have helped them. They will still be sitting right there. Within the ministry, what I have seen is astounding. I've encountered instances of corruption, misappropriation of public funds, improper procurement and hiring practices, gross misconduct, and clear conflicts of interest. These issues are being addressed with the seriousness they warrant, and systems are being strengthened to ensure accountability and transparency moving forward. Mr. Speaker, we are seeking a supplementary appropriation of $325,208,000 under Head 43, Ministry of Works and Transport. I would like to start today by addressing the issues surrounding the priority bus route, which was one of the first things I addressed when I got into the ministry. And Mr. Speaker, please give me some leeway. This is very relevant to why we are here today, because giving out PBR passes costs money, especially when you give out as much as the previous minister did. But please permit me to give you a little background on the PBR. Subsequent to the shutdown of the Trinidad government railway and the railway system in Trinidad, which I will note was shut down by a P&M administration. It was conceptualized to implement a 16-mile-long major transit route on the east-west corridor. There are 4 categories for passes. You have maxi taxi permits, then you have 3 for private motor vehicles, permanent, temporary, and letter passes. Permanent are giving out to a category of persons, primarily public officials. Others get temporary passes, as well persons in office. Then there's another category called letter passes, which is given out to the minister's discretion to individuals, mostly persons who have private businesses. When I got into the office 2 months ago, one of my first acts was recalling all 645 letter permits that were issued between January and April. Today, all of those permits, well, tomorrow I should say, all those permits are invalid. Permits were even given out after the election, and my colleague, the former Member of Parliament for Lohokatat Paru, would have collected a pass actually on the 30th of April, 2 days after the general election. I would like to remind him that he has to bring it in by tomorrow. Mr. Speaker, in the last 5 years, the previous Minister of Transport gave out 8,330 letter passes, many of which with no justification, at a cost of $786.20. Mr. Speaker, before I move on, I would like to just address another issue with the PBR passes. There are over 66 maxi taxis waiting since as far back as 2018, waiting for permits. But the previous minister refused to issue any because of a cabinet limit that was implemented many years ago. And it raises the question, why did he give out so much permits in other categories by crossing those cabinet approved limits in the hundreds? But he did not go back to cabinet to increase the amount the maxi taxis could get. Well, I stand here to say that cabinet has approved the increase of 100 additional permits for maxi taxis, and they'll be distributed soon. I'm gonna move on to BounXup, the Vehicle Management Corporation of Trinidad and Tobago Limited. And again, please permit me, Mr. President, to give you a little background on BounXup. BounXup is mandated by the government of Trinidad and Tobago to serve as the central agency for the provision of full fleet management services to the public sector, primarily the PTSC, Public Transport Service Corporation, and the Trinidad and Tobago Police Service. Part of BounXup's responsibility is also to certify any private garages that the TTPS may choose to engage for vehicle maintenance and repairs. In 2022, 18 private garages were approved for use. None of them were formally certified. The police service continued to take vehicles at private garages with no accountability and no transparency. I'll give you one example. One particular garage charged $20,000 for a service, which would have only costed $7,000 at BounXup. In the last decade, $368 million was spent maintaining police vehicles. I am sure, based on what I have in front of me, tens of millions of dollars have been wasted in the last decade. Senator Murray, in the debate, asked, where's the money coming from? Well, cutting out corruption is a start. Mr. President, I have a letter with me dated April 10th, 2023, addressed to the Dr. Honorable Keith Christopher Rowley, Prime Minister of the Republic of Trinidad and Tobago. This letter was also sent to the Minister Ruhan Sinanan, Minister of Works and Transport, Mrs. Frances Yearwood, Permanent Secretary, Ministry of Works and Transport, Ms. Urla Christopher, Commissioner of Police, and the DPP. This letter requests an urgent intervention on independent audit of BounXup. This comprehensive report shows high levels of corruption, gross nepotism, misappropriation and mismanagement of state funds, along with improper practices. This document has a substantial amount of information, but I'm going to highlight about 14 of them. One, The CEO, along with the chairman, goes to PriceMart, spending thousands of dollars to purchase large amounts of alcohol. 2, the chairman's sister is the sole supplier of food for all VEMCOT events. No 3-code system was ever used, breaching the Procurement Act of Trinidad and Tobago. The chairman has been peddling pies and lunches for his sister business. So he is delivering pies and lunches with a state-owned vehicle, PCU3, using it as a courier service. This letter, let me remind you, was sent to the Prime Minister at the time, the Republic of Trinidad and Tobago. The CEO paid $20,000 to the police service to cover child maintenance for one of her close friends. The government is asked to examine large quantities of T-shirts ordered with no procurement. During the COVID lockdown, the CEO had a party to celebrate the awards of contracts to his friends. 7, board meetings were held virtually, yet thousands of dollars every month was spent on food. The food was delivered to VEMCOT and taken off of the compound. It goes on. The government is also asked to investigate why the chairman is living at VEMCOT. He has a room where all his clothes are stored. Amid all the financial worries, VAT has not been paid in years. Millions owed to NIB and BIR, millions owed to WASA and TNTech, millions owed to creditors. Yet the CEO requested a vehicle for $500,000. The list goes on and on, Mr. Speaker. Sweetheart deals for friends. A friend of the executive got his vehicle fixed for $80,000 and VEMCOT refused to collect any money from him. VEMCOT received an overpayment by the police service for $17 million and could not have proved it. The list goes on and on. $4 million in unused parts. Instead of liquidating the parts, they spent $50,000 for 2 storage containers to house the parts. Mr. Speaker, the list goes on and on regarding the corruption I have seen in VEMCOT. I'd like to move on, Mr. Speaker, to the Airports Authority of Trinidad and Tobago. The Airports Authority, we are seeking an allocation of $45 million for recurrent expenditure to settle arrears arising from the recently concluded wage negotiations between the Airports Authority and the State Police, EPA. The payment will benefit 444 individuals, 122 former employees, and 322 employees. Regrettably, the authority is unable to meet these obligations from its own accounts. One major factor is the write-off of $205 million owed to the authority by Caribbean Airlines. The same Caribbean Airlines the previous Minister of Finance speaks so highly about. In my view, this was reckless and irresponsible. Not to mention the $300 million to acquire lands in Tobago for the new airport, even though state lands were already available nearby, raising red flags about who really benefited. And I have seen the list of the property owners, some very, very familiar names and surnames, and we will discuss that at another time. Mr. President, in Airports Authority, millions of dollars awarded without any tendering. Millions spent in private security. And I will touch on that briefly. The previous board had a plan to prioritize all security in Airports Authority. Tenders went out for private security companies. And I have it here. But what they were doing, Mr. Speaker, they were doing it through the back door. Instead of going out for a tender for security for the entire airport, they were putting out small tenders for selected areas. But multiple tenders for selected areas, eventually, you would select the whole airport. millions of dollars in contracts in security. And here is, Mr. President, sorry, the date of acceptance of these letters are April 22, 2025, 1 week before the general election. But I'll move on. I would like to move on, Mr. Speaker, and I'll spend my remaining time on this topic. I would like to address now PTSC. Mr. President, PTSC, we are seeking $58,937,000 to support the implementation of the first phase of the project to supply and deliver 300 buses. The PTSC once serviced 165 routes across the country. However, due to the previous government's neglect and lack of care for the people of Trinidad and Tobago, that number has been reduced to just 73. As a result, many sectors of society, especially those in rural areas, have been left severely underserved. PTSC has 21 litigation matters, plus more incoming matters, which redirect funding originally intended for the organization to achieve its mandate. Mr. Speaker, attorneys have been paid millions of dollars, with one attorney benefiting more than the rest. I'd also like to bring to your attention, Mr. Speaker, in the last 5 years, PTSC received over $1 billion in government grants, over $1.4 billion in government grants. I would like to ask the previous Minister of Finance who's here, I'd like to ask him some questions, but unfortunately, he wasn't in the job very long. No disrespect, sir. 1.4 billion with an income of only $183 million. There was no attempt to acquire any buses years ago to improve the operations of PTSC. PTSC has 430 drivers with just 100 buses. Up to 30% of the drivers are currently not driving. I'd like to move on to security. PTSC in the last 5 years spent $92 million in security. Again, with one company benefiting more than the rest. But why so much in security, Mr. President? Mr. President, do you know that PTSC has security officers by all their restrooms? Not to protect customers, to make sure that persons paid the $2 charge to use the bathroom. This was free under the previous administration. But when my colleagues came into office, it was re-implemented. But very soon, that $2 charge will be removed. I'd like to move on to spare parts. Spare parts, yes. Mr. Speaker, I have been going through the companies that sell PTSC spare parts for buses. And one company caught my eye, Sukai's Diesel Service. Mr. Speaker, wasn't there a government senator and minister in the Ministry of Transport with that same last name? So I had some digging done, and I have with me here the Form 28 annual returns for 2023 and 2024, and Form 45 return of beneficial interest for 2023 and 2024 for Sukai's Diesel. That individual during this period was a director and shareholder of Sukai's Diesel. Now, I am not an attorney, but that is a conflict of interest. You are a minister in the ministry responsible for PTSC, and I'm being told that you were instructed to buy from Sukai's. In 5 years, Sukai's went from number 20 to the 4th preferred supplier. And I'm going to go into a little more detail if you permit me. In 2021, $342,000 purchased. 2022, $170,000. January of 2023, $3,300. February, when the individual was appointed to the Senate, $64,000. And in April, when that person was appointed minister to December, $662,000. 2024, $2.3 million. And in 2025, January to April, $837,000. This company benefited from $4.3 million in 5 years. I'm going to go on. In the last 5 years, PTSE spent $106.8 million in spare parts. Now, my colleagues on the other side may be thinking, why is that important? Obviously, buses need parts, obviously. But I'm going to get to that now. The financial statements of PTSE for September 30th, 2024. Mr. President, at the end of 2024, PTSE had $65 million in stock in spare parts. And I'm being advised that up to $57 million is unusable. $57 million. PTSE has been buying parts that they do not need, Mr. President. There have been no attempt in the last 10 years to liquidate those parts. I have asked for an investigation to determine exactly how much parts are there and the value of those parts. It goes further, Mr. President. PTSE has an arrangement with a foreign company, the supply of their current fleet, to provide parts. What PTSE has been doing, they have been buying imitation parts from a local supplier. That local supplier has benefited in the last 5 years at a sum of $36 million. So PTSE is buying parts they don't need, and they're buying from a company counterfeit parts. It was raised at PTSE in February 27, 2025, and PTSE claimed that the procurement of these parts was substitutes rather than counterfeit. However, this is inaccurate and legally untenable. Under Regulation 14(1)(2)(b) of the Public Procurement and Disposal of Public Property, 2021, substitutions are not permitted where goods can only be provided by one supplier due to technical and exclusive rights. Mr. President, the previous administration ran PTSE into the ground. There's so much more I could say, and I would like to ask the previous Minister of Finance, who's here with us, through you, Mr. President. When he was debating this bill, he mentioned that the previous government took loans right before the general election. I believe you said in February, if I'm not mistaken. You said, and I quote, all these loans were taken way before anyone knew of the general election. Well, sir, it was way before you knew of the general election, because there were many things going on in the background that all my colleagues did not know about. That's why you guys are sitting there and we are sitting here. And Mr. President, I wouldn't leave you out and you're sitting there. And so February to April, you said way before. That's only 3 months, sir. Mr. President, there's so much more I could say, but I will wrap up. As I bring my contribution to a close, I want to assure this House, and more importantly, the people of Trinidad and Tobago, that I'm fully committed to driving positive change across the Ministry of Transport and Civil Aviation and all the state agencies under my watch. My focus is on strengthening governance, improving performance monitoring, and embedding a culture of continuous improvement throughout the sector. The goal is simple but critical: to deliver higher standards of service, better value for public funds, and a transportation civil aviation system that our citizens can rely on and be proud of. Mr. Speaker, the approval of this supplementary appropriation bill is not just a financial exercise. It is an investment in our country's future. It is about making sure that the infrastructure and services we provide today will meet the needs for generations to come. With the continued guidance and leadership of the Honorable Prime Minister, I am confident that we will achieve these goals and set new benchmarks for excellence in both the transport and civil aviation sectors. In closing, I thank you and all members of this House, and I look forward to your support as we continue this important work on behalf of the people of Trinidad and Tobago. I thank you.
Senator Rashid Daniel. Senator Rashid Daniel.
Thank you, Mr. President. First, I would like to congratulate the Honorable Kamala Persad-Bissessar and the United National Congress for their resounding victory at the polls on April the 28th, taking the mandate of the people to the forward. Allow me to express my deepest thanks to Mrs. Persad-Bissessar, Senior Counsel, Prime Minister of Trinidad and Tobago, for having faith in me and bringing me in the Senate as a temporary senator. I wish to, at this time, thank her for allowing the youth a voice in this chamber. At 25 years old, I now stand as the youngest senator in the 13th Republican Parliament. It's an appointment in a milestone of my life. It is a message of hope to young people all over Trinidad and Tobago. To the young boy or girl in Mova, Lavantil, to the young boy or girl in Penal, Debe, in Chagonas, in Sandy Grande, in Mayaro, in Charlottesville, in Boko, and in Carenage. It is a reminder to you that there is a space for you in the nation's highest institutions. That your voice belongs not just in protests, not just on social media, Mr. President, but here in the chambers where decisions are made. That your future is not something to survive off of, but something to build, defend, and shape with your own hands. So I make this promise today, Mr. President, with full humility and conviction. As long as I sit in the Senate, I will never speak for myself. I will speak for every youth who have ever been told that they're too young, too inexperienced, and too far from center. I will speak for the young people who feel unseen and unheard for the last 10 years. I will speak for those in schools, those who are out of schools. I will look to speak for those who are working, who are trying to build a business, raising a child, or simply, Mr. President, in service. To be seen by a system that overlooks them. Mr. President, my voice in this chamber belongs to them, and I will use it with honor, with courage, and with purpose. Mr. President, before I proceed with my substantive contribution, allow me the honor of extending the deepest congratulations to your extension and your election of office from Senator the Honorable Wade Mark to President of the Senate. It is not only a well-earned appointment, but a historic one. You now hold the singular distinction of being the first person in our nation's history to have served both as Speaker of the House of Representatives and now President of the Senate, It is not only a personal achievement, it is a national milestone. I thank you, Mr. President, for the example you continue to set for the entire nation, especially to me, someone who you have had the honor of mentoring. Mr. President, let us be clear about our debate today, what we're debating. This is not just about a bill of dollars and cents. It is about priorities. It is about who we choose to see and who we allow to disappear in national development. Once again, we are left here cleaning up the mess left by those opposite. The government is seeking $3.143 billion in supplementary appropriation to cover urgent and underfunded priorities before the close of fiscal 2025. It is not a blank check. It is a course of correction aimed at fixing what was broken and abandoned by the People's National Movement. Mr. President, I want to look at the Ministry of Education and their request. I spoke to the Minister of Education last night, member for San Fernando West, Dr. Michael Dowlatt, and we had a very long discussion, and I was very interested in some of the areas in which he requested funding for. I'll start with salaries and cost of living allowance. The government is seeking $37 million for this. And this is only to simply cover salaries up to September 30th, 2025. No upgrades, no acting allowances, no increments, just the basic salary. The Minister of Education, Dr. Michael Dowlatt, Member of Parliament for San Fernando West, made this very clear at the Standing Finance Committee. Though I was not present at the Standing Finance Committee, and I'm new to this chamber, but I went home and I did my homework. Something I wished all of us would have done. And I tuned in to the Standing Finance Committee. Even though this line item, and I'm looking at the 2025 budget here, was not correctly budgeted for, it raised some questions. I started to ask questions. Mr. President, how can you say that you care about the youth of the nation if you leave the people who teach them unpaid, or you don't budget to pay the people who teach the youth of our nation? We moved on to contract employment, which looked for $33.04 million, which covers contract workers, including ECCE teachers and critical education support staff. These are the early childhood educators who nurture our youngest learners. These are the school officers and aides who help keep order, fill gaps, and build confidence in our youngest of young children. Yet under the People's National Movement, they were invisible on paper, underfunded, unprotected, and treated as though their roles were optional. I want to move over to janitorial services. I'm moving fast. I'm not planning to spend my whole time here. Janitorial services. We're asking for $26.6 million. In fact, Mr. President, the ministry owed $90 million in arrears left by those on the other side. In the 2025 budget, the People's National Movement decided to just budget $26 million. I left less than half of what they owed. So what was the plan? This is janitorial services we're talking about. What was the plan? Was it to pay for half a mop? Clean one floor and leave the rest to mop, to rot? Schools were left in filth. Bathrooms broken, classrooms unsanitized, corridors reeking, while the PNM ministers bragged about physical discipline. 7 janitorial companies were owed, still owed, and that's why we need the money. Still owed today. Century 21 Janitorial Limited, Building Maintenance Services, National Maintenance Training and Security Companies Limited, Super Industrial Services, LSA Healthcare Services Limited, Rent-to-Kill Initial, Magic Mist Services Limited, still owed. Hundreds of janitors, Mr. President, many of them young workers, single parents, and breadwinners, were expected to keep schools clean for free. They showed up, they cleaned, they protected our children from disease and from disaster. And the government, they could not even serve them a check. You cannot claim to be running an educational system when the toilets don't flush, the bins overflown, and the people scrubbing the floors can't even afford lunch. This is not mismanagement. This is exploitation in a tie and a jacket. Let us call it for what it is. The UNC inherited, and forgive me, Senator Cummins, we inherited a raped treasury. And now we're being asked to rescue the people left behind by a party that thought budgeting was a performance art. You know, they like to have their little thing in Napa. If I know I have 100 workers, that is teachers, early childhood educators, janitors, and I deliberately under budget for them, Mr. President, what kind of employer does that make me? It was not a mistake, it was not an oversight. It was willful disrespect. Because budgeting is not a lottery. It's not a lottery. It is not a prayer. It is a statement of values. And when you exclude workers from the budget, Minister, you don't forget, you're not just forgetting them, you're erasing them. This government will not do that. We saw what the PNM did. Or in this case, what they did not do. And we are willing to, Senator, fix it. We're willing to fix it. We budgeted, we allocated, and Mr. President, we will pay them. We will pay them their monies. That's the difference. Their silence versus our action, their lip sync versus our leadership. Their silence versus our action, their lip sync versus our leadership. Moving over to school supplies and book grants, we're asking for $20 million on this. This one is a real gem. Listen. In 2023, and I have the budgets here, In 2023, the PNM spent $0, 0 cents. This is school supplies and book grants, $0 in 2023. In 2024, Mr. President, they budgeted $0. They came in the mid-year, like they do, and they asked for $20 million. In 2025, same story, budgeted $0, and now we are here asking for $20 million. For years, not a cent under this line item, and they have the gall to talk about caring for the vulnerable. That's not just poor planning, it is willful neglect. A neglect so consistent, you can set it in your calendar and forget it. The real cost of youth neglect, physical breakdowns of schools, emergency school repairs. We're asking for $83 million. Listen, we have 279 schools which are in need of urgent repairs out of a total of 833 schools. That is 1 in every 3 schools, Mr. President. 1 in every 3 schools need urgent repair in Trinidad and Tobago. This did not happen last night. This did not happen the 29th of April. This did not happen last month. Years of neglect. This is what happens when you ignore infrastructure for a generation of our nation's youth. You treat school repair like a last-minute emergency instead of a long-term investment. I went back into the budget, 2025, and I looked. In 2023, guess what? PNM budgeted nothing for emergency repair. In 2024, they budgeted nothing again. They came back in the midterms and begged for $5 million. And in 2025, they budgeted $19 million, when $83 million is urgently needed. Urgently needed. The PNM did not just ignore education, they abandoned the whole ship. Mr. President, I'm moving on to laptops and tablets. We're asking for $76 million. Now, this is a very close project to my heart. This is a new project. Well, fairly new project to our government here. Let me remind this chamber, it should not have been a new project. It should not have been. We are here today trying to fix a digital divide that was widened under the People's National Movement. Mr. President, it was them on the other side who shut down the laptop program and left entire communities without access to education during a pandemic. And they have the nerve to say, let parents buy their own. Means test it. Let me quote from the Standing Finance Committee report, Mr. Levine's member of Parliament for Diego Martin Central, speaking on this very same line item, and I quote, would it not be more fiscally responsible to be doing a means test for this particular item? He was asking the Minister of Education. Mr. President, that is nonsense. Utter nonsense. That was utter nonsense. Many families may look okay on paper, but the reality is they have 5 children, some of them have many children. They may have lost their jobs, unstable incomes. They may have been working Petrotrin, and you know what happened there. Oh, come on. And guess what? A means test would have missed them entirely. A means test would have missed them entirely. Worse yet, means test delayed the rollout of the program. Mr. President, we don't means test chalk, whiteboard markers. We don't means test textbooks. So why are we pretending that laptops, now core to learning, are some sort of luxury? Mr. President, I am a product. I am a product of the 2012 laptop program by the United National Congress. Mr. President, in fact, when I received this laptop so many years ago, I kept it, and I kept it working well. And I took the challenge of this debate and doing all the research, and with your permission, which I sought, I did all my research on this laptop, prepared my entire thing on this laptop. So said, so done. Let us talk about the collapse of youth programs, a decade of disrespect. Where did the money go? Let me look for the mayor there. Where did the money go? This is a finance bill, one that deals directly with how we manage public money, how we correct past shortfalls, Mr. President, and how we fund national priorities. So it would be irresponsible of me, the youngest senator in this chambers today, to debate this bill and not ask how money that was supposed to serve our nation's youth over the past decade was actually used. For 10 years, youth development was funded, and yet youth facilities collapsed, programs shut down, and opportunities vanished. During the PNM's tenure, the Ministry of Youth and National Service was transformed from a space of opportunity to vessel exploitation. I would encourage all honorable senators to listen or to read from the Hansard to the Minister of Sports and Youth Affairs contribution. The member for La Hocketa Talparo exposed the PNM's political actions in my DNS. I'm not going to go into the details. I'll save you the embarrassment. 61 individuals were awarded contracts under suspiciously convenient terms. 61 of them. Mr. President, note that these were not technical experts. I'm not going to call no names, unlike the minister. Youth workers, or they were not youth workers, they were not program leaders. Instead, they were politically connected individuals, some with no prior background in youth development or public service. Contracts were issued without competitive processes, lacking transparency or accountability. In multiple cases, individuals were receiving monthly salaries of over $20,000 with no deliverables, no office hours, and no project output. There was no published scope of works, no monitoring systems, and no reporting obligations for many of these hires. Internal ministry staff described these hires as ghost advisors, people who never reported to duty and never attended meetings, and could not be located when contacted. Funds that should have supported MyLat, the reopening of MyLat, expansion for the youth entrepreneurship programs, repairs to the underutilized community centers, and revival of the vocational training camps were instead used to finance political favors and revival of the vocational training camps were instead used to finance political favors under the guise of youth engagement. Many of these same individuals were seen on political platforms in branded shirts weeks later in their public service roles, looking more like campaign rewards than national contributions. While legitimate youth workers and program officers were left without contracts or stretched upon multiple sites, unsupported and underpaid. This was not a youth policy, Mr. President. This was a political retirement scheme designed to protect insiders while neglecting youth on the ground. Every dollar spent on those non-performing advisors was a dollar taken from a young person waiting on a training certificate, a startup grant, or a second chance. Let us call it for what it is. No youth investment, but youth exploitation. And then here we are today, asking for a supplemental allocation because of the misuse and abuse of allocations by the People's National Movement government. What did the PNM deliver to our youth? So I went and I looked through, did some research on the same laptop. 93 school construction projects abandoned. Many nearly completed, some 95% left to rot. Today's allocation for school repairs, $83 million, is because of the failure to complete yesterday's work. ECCE centers underfunded, understaffed, and in some cases, empty, Mr. President. Right in my own constituency of Couva North, the Waterloo ECCE Center abandoned and left for the criminal element to feast off of. Now we're forced to use part of the $33 million in contract employment to support the same ECCE teachers the PNM left out in the budget. Student suspensions skyrocketed by 87% between 2022 and 2025. Yet there was no nationwide disciplinary strategy, no investment in our youth mental health. We are not just funding buildings, we are restoring systems that support students before they fall through the cracks. Youth training gutted. While MILAT collapsed and youth camps shut down, the PNM's focus was on t-shirts and stage lights. A fake textbook grant promoted in headlines, never funded in reality. The $20 million under school supplies and book grants is not a new policy. It's money to fulfill a promise the PNM made and they abandoned. Youth on Stage costed the taxpayers $839,000 while MILAT trainees could not eat. That's why this government is investing in matters not vanity events, but devices, salaries, and structural repairs that give young people real support. That's not just failure, Mr. President. It is betrayal. And because of that betrayal, Mr. President, because of that betrayal, we are here today. What will this bill do for youth? Can I ask how much time I have remaining?
Yes. I think you end at 7:48.
Okay, thank you. What will this bill do for youth? It will restore funding to essential services in education. From janitors to teachers, every dollar spent restores safety, dignity, and functionality of schools that failed under the People's National Movement. reopen the doors that the PNM slammed shut. Doors of ECCE centers, secondary schools, and digitally locked classrooms are now being reopened with this allocation. This bill will pay the people who show up every day for our children, our teenagers, our youth. The $37 million in salaries and $33 million for contract staffs, investment in youth, because without the education, without the educators, there is no development. We'll deliver laptops because modern youth development needs modern tools. $76 million for laptops because bridging the digital divide is not optional. It is long overdue. We're going to bring Tobago's youth into the national plan. Tobago is tired of being left out. Excuse me. This government isn't playing geographic favorites. Every school, every district, and every youth matters. And all of this, Mr. President, is made possible by this supplementary appropriation. It is not a wish list. It is a necessary act of rescue and restoration. We're not just here to spend money. We are trying to fix the intentional misappropriation of the 2025 budget by the previous PNM administration. We are repairing what the PNM broke and rebuilding what our youth deserves. Every line item in this bill speaks to the youth, not slogans, just action. So, Mr. President, as I conclude, as I look to wind up here today, this is a closing call for the youth. Let us not pretend that this budget, let us not pretend this is just about budget lines and bottom lines. This bill is not about numbers on a page. It is about the names, faces, and futures behind those numbers. It is about a generation of young people who have been systematically failed, overlooked, and politically sidelined, Mr. President. It is about a Milat cadet who put on a uniform with pride, showed up ready to serve, and was told to go home because there was no food. It is about a young man in Barrackpore or Mason Hall or Baxter Hall, eager to learn a trade, turn his life around, and contribute to his community. But who walks past a locked, overgrown training center every single day? It is about the young woman who has filled out application after application for youth programs, skills training, and grants, and still waits on a call that never comes. The amount of young women I knew applied for the YAP program and still waiting for a call. It is about the teenager in a wheelchair whose country promised inclusion, but who still cannot access seating in a national stadium because the ramp was never installed, because the elevator cannot fit her wheelchair. This bill is for them. To the PNM, you were given stewardship of dreams of our nation's youth, and you turned that trust into transaction. You turned youth policy into political marketing. You padded payrolls, issued last-minute contracts, and inflated event budgets while core programs collapsed. You built public relations spectacles instead of lasting systems. You spent on big stages, banners, and brand consultants, and gave very little to actual lives, Mr. President. You had 10 years, 9 national budgets, and the youth of this country are still waiting for a return on their investment. You gave them photo ops and wait lists. You give them excuses. To this honorable House, honorable senators, this vote is not merely about authorizing funds. It is about choosing our legacy. It is about deciding whether we will be remembered as Parliament, as the Parliament that debated numbers or the Parliament that delivered hope. This vote is about who we choose to stand for, Mr. President. This vote is to rebuild trust that was broken, to recenter youth in national development, not just as a campaign slogan, but as a sustained commitment. To the youth of Trinidad and Tobago, we hear you. The UNC, this government hears you. We hear your frustration. We hear your hunger for opportunity, for access, for a system that sees you. We see you. We see your talent, your discipline, your potential, even when others may pretend that you're invisible. We believe in you. Not just as a demographic, not just as a policy target, but as a driving force behind the future of this nation. And we are fighting for you. Not just to fund the future, but to deliver. It is our responsibility, not as politicians, but as custodians of the generation to come. Mr. President, with this bill, we are not just correcting the failures of the past. We are sending a message to every young person in this country, and that is, your future matters, your voice matters, and the UNC government is here for you. Mr. President, with that, I thank you.
Honorable Senators, on your behalf, may I extend my heartfelt congratulations to Senator Daniel Rashid on his maiden contribution. I now recognize the Honorable, in fact, I now recognize the Minister in the Ministry of Housing, the Honorable Philip Alexander. Well, Minister, just 1 second. We have a procedural motion that we have to move. I call on the Leader of Government Business to take the floor.
Thank you, Mr. President. Mr. President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until 10 p.m., inclusive of the matters on the adjournment.
Honorable Senators, the question is that the Senate continue to sit until 10 p.m., inclusive of the matter on the adjournment. Those in favor say aye. Aye. Those against say no. The ayes have it. This Senate will continue sitting until 10 p.m. I now recognize the Minister in the Ministry of Housing, the Honorable Senator Philip Alexander.
I thank you, Mr. President. Once again, I am moved to pay you the respect that you due for the way you manage the business of this house, this chamber. I am somebody who watches a lot of Parliament channel. Well, now I'm in the Parliament, but I watched a lot of Parliament channel, and you could have a school, a master class in how to handle a house. I think you're the best at what you do. Mr. President, I don't think anybody really wants to follow Daniel Rashid's maiden. If that is the youth that coming up behind us, the future of our politics is in good hands. So, getting down to the business of the business, I am one of 3 housing ministers. We have a line minister, the Honorable David Lee. We have Senator, the Honorable Anil Roberts, and myself. And the reason we have an unprecedented amount of ministers in that ministry is that we were told that we have a mandate to lift this country out of poverty and crime and squalor by giving families a start with a home. That's our mission. So, with a plan in hand and enthusiasm, we went forward to the Ministry of Housing. And like any good custodians, we first had to do a stock check. What we have, who we owe it. This bill that we are debating, the Finance Supplementary Appropriation Financial Year 2025 bill, the object of the bill is to supplement the appropriation provided for by the Appropriation Financial Year 2025 Act 2024 by authorizing the issue from the Consolidated Fund in the sum of $3,143,983,761. $3,143,983,761. We found in the Ministry of Housing that there was a significant shortfall in the funds required to just continue the business, to keep the lights on. And that sum was $81 million, give or take. And it's made up of pedestrian items, basic recurrent expenditure items. When I listen to the talented Senator Janelle John Bates, the last time we debated this, and she asked what made these items, why are they on the list? And I wanted to tell her, and she was trying to make an excuse as to why it was possible that you didn't properly budget. But some of these items are not things that you have to guess at. Some of these things, when you're making a budget, you know that you have 12 months of this bill. You have 12 months of the rent. You have 12 months of the electric bill. You have 12 months of your staff. Those things should not form part of us coming in a mid-year review for more money. Those things should have been covered in the original appropriation. And they weren't. But worse than that, when we were doing our investigations, Minister Lee, Minister Roberts, and myself, we found that there were things that was in no bill. It was in no budget. We found that there were ad hoc decisions made, money spent, and that we found ourselves having to pick up the cost of things that not even in the budget. As an aside, and I want to tell you about the performance of the Housing Development Corporation, because as I said, going about our business, We had to investigate what was going on there, how we get to be here. We found out that at the close of play of the People's Partnership government, there were 169,557 people whose names were on a list applying for houses. By the 28th of April 2025, that had mushroomed to over 200,000 people. The United National Congress-led People's Partnership Kamala Prasad Visesa government built 7,596 houses between 2010 and 2015. The People's National Movement government built 4,700 houses in the 10 years, almost 10 years that followed. So it looked like the HDC under the People's National Movement wasn't so much interested in building houses as they were in taking names. We found a stock of houses that are already allocated, most of them by ministerial decree, not random draw, not by application and your name comes up, but by some minister deciding who gets a house and who doesn't. And we found that almost everything under construction is already allocated by ministers. And we found projects that are just at the application stage, the drawing stage, the basic, barely out the ground stage, those are allocated too. We found an HDC that was being used as a political tool. So when we were doing these investigations, one of the things that popped up was temporary workers hired in the month of March and April 2025. And we were told that it was an annual exercise. But when we asked for evidence of previous years, there were no such hirings at that particular time of the year. And the only thing that was going on at that time of the year, this year, was a general election. And it seemed like the Housing Development Corporation was being used as a political tool to provide human resource to politicking for elections. Now, I have in my hands here a document that I spoke with the Attorney General about earlier that I am supposed to put in his hands after. It has names that I cannot call in here, in this house, but you would get the information because it is a signed statement of a senior member of the Housing Development Corporation. I do not plan to cause any embarrassment of anyone, and I would leave that up to the authorities to deal with. But this document, out of the investigations, when we summoned the entire management and senior members of the Housing Development Corporation, the question Minister Lee asked was, are you aware of these people who were hired to work and were not paid? And the consensus around the room was yes. They were aware of these people. And he asked, what was the purpose of their employment? And that answer was not straightforward. So both Minister Lee and Minister Roberts requested files so that we could dig a little deeper. And we ended up speaking with a senior manager whose name was called. And he, in a meeting with him after that meeting, gave us this information. With your permission, I'd like to read some of it. The Community Internship Program 2025 was initially designed to facilitate rehabilitation works in HDC rental developments throughout Trinidad. This initiative was aimed to utilize local labor and building contractors. The hiring of these contractors was to be conducted through the HDC procurement process, overseen by our procurement department and guided by OPR regulations. Projects were identified from the Estate Management Complaints Database, known as the YARDI system. Residential complaints are inputted into YARDI, and projects are developed based on the most frequently reported issues. Additionally, projects are also determined based on instructions from the HDC board and the managing director. Estate Management submitted all projects to the managing director, Ms. McFarlane, and also forwarded them to the procurement department for tendering. Ms. McFarlane indicated that the work would be divided, with some tasks allocated to localized labor, as was the plan initially, within the communities, while the remaining jobs would be tendered to contractors. Local labor was initially supposed to be 600 workers across all developments. The HR department's divisional manager, Ronnie Spencer, under the direction of Managing Director Giselle McFarlane, received names for employment from various constituency offices. These individuals were hired and issued temporary employment letters for 1 month, 2 fortnights. Meanwhile, the procurement department advertised opportunities for building contracts. The issuance of temporary employment contracts and the advertisement for building contracts in our developments occurred approximately 2 months before the general election on April 28, 2025. Localized labor began working in the first week of April 2025, with employment staggered throughout the month. As a result, some developments started work later in April, lasting only 1 month. This is where it gets worse. During the temporary employment period, the managing director continued engaging with the human resource department to hire additional employees, increasing the total from 600 to 2,300 temporary workers. This resulted in variations in employment start dates among temporary employees. While initial plans called for 600 localized workers, pressure from senior officials resulted in the rapid expansion of the temporary workforce to 2,300 employees. Upon receiving instructions from the managing director regarding the ongoing increase in temporary employees, I was directed to find work for them. I communicated with the managing director about the lack of materials and actual tasks for them to undertake. However, she informed me that these instructions had been issued by 2 then government ministers and other PNM ministers overseeing marginal constituencies, and that it was her directive to ensure their execution. During the month of April, the procurement department conducted site visits with interested contractors for rehabilitation work across various housing developments in Trinidad. However, these contracts did not materialize because HTC lacked the necessary funding for the program. Mr. President, these workers were not gainfully employed in HTC work and were used for political purposes, paid through the HTC, and that bill is now due and owing. I am not calling any names. But there is a reality that faces Trinidad and Tobago today. And that reality is what took place in the operation of the nation state of Trinidad and Tobago under the previous government was never about serving the people. And this government, through every single minister that is going to stand up and speak here and in the other place, will tell tales of where the money gone. So when the people who are responsible for where the money gone, asking us where the money is supposed to come from, I find that a little bit disingenuous. It's almost like they're provoking us to come out and say, you have the money, give it back. The money to run Trinidad and Tobago that was budgeted for A and spent on B, or never budgeted before but left to be budgeted in a mid-year review, that is deliberate mismanagement of the country. And to the voters and to the people looking on now and listening to all of this, listening to Senator Zakur, listening to Senator Smith, listening to Rashid, Senator Daniel Rashid, what they're going to hear from Senator Kama Maraj, I know for a fact that we're not finished with the fallout of April 28, 2025. Trinidadians are going to get sick and upset when they learn what was really taking place in this country. And God bless Kamla Prasad Bisesa and United National Congress. Because we were, I don't know what would have happened. We were heading for a disaster. And I feel sorry for the new members, because they're bright and intelligent people, and we can't beat up on them, because they're not part of that. They have no idea what's going on there. But I want to tell them, that's why, unfortunately, and it has nothing to do with you all, but that's why the PNM couldn't fill City Hall. That is why the voter turnout in the internal elections was worse than the voter turnout in the general elections. The supporters of the PNM are not to be abandoned by Trinidad and Tobago. The supporters of the PNM are citizens of Trinidad and Tobago. And I want to say that when we said, when UNC win, everybody wins, it includes them too. So when the leader of the opposition told them, listen, I want to say that I am not responsible for CPEP, but I want to say that I know for certain with what I know that not one person that has been let go will remain without a job. This government will make sure that all of our people are gainfully employed. That is one of our mandates. Get them jobs, get them houses, affordable food, good education, quality of life. Those are the simple things that the people voted on. And like a lot of people who abstained today, the PNM supporters abstained on April 28, 2020. That's what they did. They abstained. And we are aware that we have a responsibility. And I was saying just now, when the opposition leader told them, come back home, I want to tell her, they're not homeless. They're coming here. We're taking care of everybody. Yeah? The UNC is home for all. And I'd like to say again, this is not malice anymore. This is not bad mind. We reached to the point where we have to treat this country as a rescue mission. This government cannot allow naked politics to take the place of good governance. We are not about hiring people for strictly political motives. Under the stewardship, astute leadership of Kamala Prasad-Bissessar, we are going to transform Trinidad and Tobago into the country that it was meant to be. With those 2 words, I thank you.
The Honorable Parliamentary Secretary in the Ministry of Health.
I wish it was Ministry of Health. It's People, Social Development, Family Services. Okay. Good evening, Mr. President and honorable senators. So far, we have addressed transport, education, housing. Tonight, I would like to spend most of my time, yes, on health. Tonight, we are here needing a supplemental appropriation of funds of $3.14 billion. This is the habit of the PNM. Oh, she's gone. Because they are not forward thinkers. They promise everything and deliver on nothing. The supplementary appropriation that we must do here is not proof of the PNM's prudence. It is the last chapter in their now too familiar story, where missteps are swept under the rug and the people of Trinidad and Tobago are left to suffer the consequences of PNM failure. Even in what are supposed to be more prosperous times, I will take you back to 2022, when it was proposed that oil prices were expected to rise more than 7-fold, from $180 to around $1,400. The then former Minister of Energy was interviewed by CNN's Quest Means Business. And when asked what they would do with what would have been the predicted income of tremendous amounts of revenue, the interview called it, the then Energy Minister said, and I quote, "Well, Richard, I don't put it as tremendous amounts of revenue. You know, as a government, we're really making revenue off taxation. So what will we do? We have bills too. We'll be paying our bills." It means that that government, even when times of plenty were anticipated, they had no plans to deliver growth and prosperity to this country. Their best plan in a time of prosperity was, we'll pay our bills. Far less for the last 9 years with deficit budgets and the tragedy that has followed. I rise this afternoon then, not in celebration that we present this bill, but in sobering duty. I rise not to obstruct, but like my colleagues, to demand accountability. I rise to lend my voice with a heavy heart but steady hand to the discussion of this finance supplementary appropriation bill, financial year 2025. The bill asks $3.14 billion in spending, and we cannot oppose it. Because if we oppose this bill, it will stand in the way of nurses who need their salaries. It will stand in the way of students who need functioning schools. It will stand in the way of patients who need working hospitals. I care about this country's well-being and its basic functioning. I care that a recipient child of the Children's Life Fund can access a ventilator post-operation, that a pensioner can fill a prescription, that a public servant can bring home their salaries without a fear of disruption. But I must also say this: I am disgusted, but not surprised, that this is where the PNM has left us.
Shame.
We are being asked to approve billions in what has to be called emergency allocations to ministries that should have had their financing properly planned from day one. But this is not the PNM's way. Now we are being made to look as if we condone mismanagement by having to facilitate this bailout. We are being forced to rubber stamp panic spending caused by their poor governance, all to keep our country running. So I will turn to health. Let us begin with what should have been a national scandal. $728.5 million of this appropriation is being directed to the Ministry of Health. That's nearly a quarter of the entire supplementary sum, even though a quarter of the original budget was also dedicated to health. If this had been a meaningful investment that we were allowed to make now, if it was investment in infrastructure, in innovation, it might have been worth celebrating. But that is not what this is. This is not to pay for bold new visions and national wellness that we wish the last government had. It's not to pay for strategic collaborations. It's a bailout. It is a cash transfusion to keep a bleeding system on life support. So let us face the facts. The last government has mismanaged the funds of the health sector, and it has led to the physical hurt of our citizens. I am going to outline what the PNM government has done to the health of this population, to the health of our citizens, while managing the Ministry of Health and the public healthcare system in the last 10 years. What their funding has done, what their allocation has done, what their value for money has given us. Diabetes. The prevalence rose from 11% to 14% in the 7 years across 2016 to 2023. That means now over 1 in 7 citizens live with this chronic life-altering condition that shortens lives and drains families' revenues. Hypertension, worse, now afflicts more than 30% of adults. That means this government has led us to a place, that government, where 1 in 3 of our working class citizens are hypertensive. Among our elderly, that climbs to 60%. Cancer. Deaths have increased by nearly 18% in the last decade. Our Minister of Health lamented where NIPDEC had to dump over $80 million in expired medications. Over the tenure of the last government, chemotherapy drugs have been in and out of stock in public facilities. The deaths included deaths from breast, prostate, colorectal cancers took center stage. These are cancers that could have been screened for. There is no robust screening program. Childhood obesity now affects 1 in every 4. A quarter of our children are now obese. These are the highest rates in the Caribbean. And most tragically, Senator Rashid, suicide rates have surged by over 30% since 2019. In the last term of that PNM government, their last tenure, particularly among youth aged 30%, particularly among youth aged 15 to 29, the very age group meant to carry our country forward. So what does that say about the PNM government's approach to prevention, wellness, and national health education. To me, Mr. President, it says what every citizen waiting 8 hours in an emergency department already knows. They don't care. The PNM did not lead on health, it reacted to crisis. It did not fund for resilience. It scrambled for survival. Under their tenure, the Ministry of Health had become a revolving door of requests, excuses, and crisis management. It says they didn't spend a cent truly effectively on preventative health care. There was no effective spending on the health of our nation. This brings me to the statements made, it's a shame she has walked out, by Senator John Bates on the last day we debated this bill, where she said, and I quote, she was scoffed at when she stated that she had a good experience and her relative had a good experience in the public healthcare system. Now, I did not scoff, Mr. President. I would not. I am trained to express complex ideas as simply as I can to my patient or my client so that they understand clearly. If I failed in that on my last occasion, then let me try to correct it. Any person who has a good experience in the public healthcare system has had that experience owing solely to the healthcare workers who interacted with them. To the healthcare workers, doctors, nurses, PCAs, escorts, top to bottom, who would have been doing the best they had with what little they have. It means that Senator Bates and her relative would have felt like they were getting plenty with the little resources that our healthcare workers graciously used. Now, if they could have been given, if she and her relative could have been given best care with proper funding, with best facilities, then we would be able to say that the experience was truly a good one. As the adage says, your health is your wealth. Well, the PNM has done away with both our health and our wealth. I'll move now into more detail of the funding given to the Ministry of Health. We will break it down heading by heading. So moving on, the first line, 14,480,000. The paragraph may be a bit confusing to read. To provide for the award of reimbursements of 12,260,717 to GORTT for expenses arising from the maintenance of the Couva Hospital. A further 2,219,283 is also needed to pay GORTT management for supervision fees for works conducted at the facility. That means, Mr. President, that this new government has been saddled with a $14+ million bill owed by the last government to maintain a facility that the public is yet to use. I will move on now to the allocations given to each of the RHAs. I must pay particular attention to the NCRHA. Broken down, the NCRHA has received is to receive $146.9 million. That is nearly 3 times more than any of the other RHAs, where the Northwest is to receive 76, Southwest 56, and Eastern 40. One might hope that the explanation for 3 times more would be something along the lines of they have a much wider catchment area, they serve 3 times as many patients, offer 3 times more services. I can't see where that is the case. So, going down into the NCRHA is $146.9 million. $143.5 million, the majority of that allocation, is needed by the NCRHA for part payment, not full payment, of trade payables. The term trade payables refers to any monies the RHA owes its suppliers and service providers for goods already received. Again, we are paying their bills outstanding. So that should translate to mean that the NCRHA ordered and received more goods and services than any other RHA. I wonder then if my past colleagues in the NCRHA felt better resourced than those in the other RHAs. Examples of things that fall under the trades payables in the RHA context would include medical and clinical supplies. So did my past colleagues in the NCRHA have more pharmaceuticals and drugs? They didn't. Did the NCRHA staff have more surgical instruments and consumables? Because I remember when I couldn't get the right size glove to put on my hand to operate last year. Surgeries were postponed because no catheters, urinary catheters used for patients put to sleep before surgery that cost 50 cents to $5 when bought in bulk were not available in the NCRHA. Did the NCRHA have more laboratory reagents, chemicals to run their tests in labs? No. Countless patients were regularly asked to do blood tests privately for urgency because the reagents were not available in the public labs. Did they have more non-medical supplies, just as janitorial supplies were lacking in education? Janitorial supplies and sanitation products are covered in trade payables. Also, trade payables are due in the Northwest Regional Health Authority, where I've already previously gone through the tragedy that happened in the Port of Spain NICU, owing to improper sanitation. Other trade payables the NCRHA has in the largest amounts outstanding are contracted maintenance to air conditioning, equipment repairs. I know of operating theaters in the NCRHA that are plagued with constantly malfunctioning air conditioning units. Trade payables includes IT support services, yet not one hospital can boast of fully electronic patient notes. Security services are trade payables, yet I know of young doctors who have had their cars broken into in car parks when they work 24-hour shifts. So, why do I choose to hone in so much on the NCRHA's huge trade payable debt in this supplemental appropriation bill? Why do trade payables matter in budgeting? Because these outstanding payments, these delayed payments, they indicate cash flow issues, which should be looked at in the NCRHA accounting and management teams. It proves the underfunding that we can see the PNM clearly did to, well, everyone. Delayed payments of trade payables impede delivery services because suppliers then refuse to provide more goods until they are paid. Trade payables accumulate into arrears that affect the overall national fiscal, which leads us to right where we are. Trade payables are not wages, they're not salaries, but I'll come to that in a minute. Trade payables are not capital expenditure to improve the existing system. They are just operating costs, as has been the trend from ministry to ministry to ministry. The operating costs, the baseline running needs were not budgeted for. So, Mr. President, let us be clear. Let us be clear. The NCRHA is not being rewarded for its performance by getting a bigger slice of the pie than the other RHAs. It's being propped up for survival. It is a bloated bureaucracy. And I'll not comment on loyalty to what, but it seems to me that service to the people has not panned out. Yet still, Mr. President, this UNC government, Philip, will fix it. We have also proposed in this bill, as was questioned by Senator Bates, I will clear it up tonight, about what she wondered was possibly a copy and paste error, where $3,443,664 are allocated to each RHA for the months June to September 2025 for expansion of services at local health centers. Despite having to be saddled with every bill the PNM has left, this UNC government will deliver our campaign promise of extended health center hours. The tidy copy and paste sum that Senator Bates asked for will account to open each health center in the RHAs with extended hours Monday to Friday from 8 a.m. to 8 p.m. and on Saturdays from 8 a.m. to 4 p.m. Staffed with 1 extra doctor during the week, 2 extra doctors on Saturdays, and necessary nurses, clerical staff, and pharmacists. As it is the same package rollout at each RHA, it is the same cost in each RHA. It is not copy and paste. This shows a UNC government led by a strong woman like our Honorable PM, Mrs. Kamala Prasad-Bissessar, SC. We can multitask. We can fix their problem and keep our promises. We will clean up their mess and deliver to this nation. That's the Ministry of Health, it's RHAs. We've covered CUVA. So now I can come back around briefly, as Senator Rashid has also covered salaries. Salaries as a supplementary request does not make sense. Going through our bill, a total, each ministry has asked for extra to cover salaries. These are not short-term contracts. These are substantive posts. This supplementation for salaries is not due to increases in salaries across the board. These are salaries that were known last year, the year before, and all the 9 years before. Why do we need supplemental funding for them? Why was it not budgeted before? How did we get here? We got here because the PNM doesn't plan. It patches and it panics. Then it revises and has the audacity to spin that revision as a success. They want us to believe that every supplementary appropriation is routine, it's normal, that it is good governance, when truly they are patching potholes in a road they refused to pave properly in the first place. So it is not about this government and that government and its good planning. This is about that government's political malpractice.
Aye, aye, aye. Love it.
More of their overdue bills just to cover. The Office of the Prime Minister needs 128 million, 98 million of which is for NALIS, mostly in arrears and allowances. Ministry of Works and Transport, 327 million, going towards repaying debts it never should have incurred without clear revenue streams. So, before I finish, I will turn to my own ministry, the People, Social Development, and Family Services. In my own ministry, the sad story of their disdain for public servants and citizens continues. To cover this fiscal year, $2 million was under budgeted for salary arrears. The PNM literally did not pay its own bills. $500,000 is owed to TNTech for the head office building alone. Pensioners, as part of our grants, were left suffering. Over 2,000 applications had processing delays, which my line minister has cleared up in short order. We, this UNC government, sorted out the issue in 1 month, where the PNM left our needy and elderly languishing for years. The PNM talked the talk, but never walked the walk.
Don't even talk.
They promised citizens safety and financial protection during the years of COVID. Do you know what we found when we came into office? They offered rental assistance grants to citizens in need. COVID ended how long ago?
2022.
To date, 1,132 of those rental assistance grant applicants have not been paid.
Nah, man. Oh, God.
More of their unkept promises, more of their mess that the UNC government will find solutions for.
They should hold their head in shame.
In closing, Mr. President, to the people of Trinidad and Tobago, I say this. You were literally being shortchanged. You were being asked to pay more, wait longer, and settle for less. Tighten your belt, use coal pot, eat less macaroni pie. You were being told to believe that patchwork is progress. But you know better. You felt it in your pocket. You saw it in your health centers. You heard it in your silence when you asked for answers. And now you have given them your reply. This $3.14 billion is not a triumph. It is an indictment of the PNM's reckless government and a failed former finance minister. It is proof that we were running on fumes. But hope will not be abandoned. We will do better. Thank you, Mr. President.
Yes, honorable senators, let me just, for the record, correct the title. Parliamentary Secretary in the Ministry of the People, Social Development and Family Services. I now call on the Honorable Leader of Government Business.
Mr. President, I beg to move that this Senate do now adjourn to Tuesday, July the 1st, 2025 at 10:30 a.m.
Honorable members, honorable senators, before moving for the adjournment, I have granted leave to Senator the Honorable Anthony Vieira to raise a matter on a motion for the adjournment. Senator Anthony Vieira.
Thank you, Mr. President. I rise this evening to address a matter of urgent social and developmental importance, namely the provision of affordable, decent housing for our citizens, particularly the vulnerable, the young, and the aspirational. It is a matter that goes to the heart of dignity, security, and national development. I have noted with interest that the new administration has appointed not one, not two, but 3 ministers with responsibility for housing. This, I hope, signals a serious intent to tackle what has become a deepening housing crisis in our country. So I therefore use this opportunity to call on the government to either adopt a policy recommendation I will outline, or alternatively, to clearly articulate its housing policy so that citizens may know what to expect. Mr. President, too many of our citizens, particularly single persons, young professionals, low-income earners, and the indigent, live in conditions that are not only inadequate, but in many cases, destitute and desperate. Families are crammed in overcrowded quarters. Young people delay independence, relationships, and family formation, not out of choice, but out of necessity. Some never get to start a life of their own at all. There is, Mr. President, an untold social and economic cost to this hidden housing crisis. One of the reasons our young, bright, and talented citizens emigrate is not merely the lure of foreign opportunity, but the simple yearning for a decent standard of living, including a place to call their own. A roof over one's head should not be a luxury in Trinidad and Tobago. What is urgently needed, I submit, is a rethinking of our housing paradigm. The traditional model of a 3-bedroom house on a parcel of land is unaffordable for many, unsustainable for the state, and unresponsive to contemporary urban needs. On the other hand, brutalist housing blocks or poorly maintained tenements often produce social ills rather than remedying them. So I therefore propose a middle path: micro apartments and urban living units in and around our cities and dormitory towns. Compact, well-designed, energy-efficient, and affordably priced units targeted particularly to young persons, low-income earners, and retirees. Such a model could simultaneously address the demand for affordable housing and help revitalize decaying town centers, bringing back foot traffic, commerce, safety, and vibrancy. These micro units, if placed near transport hubs, commercial centers, and civic spaces, could form part of a holistic urban renewal strategy. The idea is not new. Many progressive cities around the world have embraced this approach to good effect. So, moreover, Mr. President, there is also an opportunity for the government to relocate informal settlers who live in dangerous and ecologically sensitive areas, hillsides, flood-prone areas, watersheds, into proper, secure, and planned communities. It's not only a housing issue, it is a climate resilience and public safety imperative. So what I urge is not a piecemeal solution, but the articulation and implementation of a coherent national housing strategy, one that meets people where they are, that adapts to the new realities, and that is inclusive of the most marginalized. Therefore, I call on the Honorable Minister of Housing to indicate whether government is open to or actively exploring micro-apartment solutions as part of the national housing policy, disclose the current policy posture regarding urban renewal and infill housing, explain the government's position on the relocation of squatters from ecologically vulnerable lands, and whether this will form part of a national plan for managed resettlement. And finally, to advise what portion of the national housing allocation will directly target young, single, and low-income persons as distinct from larger households. Mr. President, the housing crisis cannot be solved by concrete alone. It requires vision, policy innovation, and a willingness to think differently. Think differently about space, sustainability, and equity. If we get it right, we not only solve a basic human need, but we also catalyze urban regeneration, reduce risk, and stem the exodus of our most promising citizens. I look forward to the Minister's considered response. Thank you.
The Honorable Minister in the Ministry of Housing and Urban Development, the Honorable Anil Roberts. Senator,
thank you. Thank you, Mr. President, and thank you for the motion on the adjournment. Let me first of all agree with you, Senator Anthony Vera. Housing is in a crisis in Trinidad and Tobago, but the crisis did not begin on April 28th. So I will show you how we have reached to a crisis point. It has been decades in the making, and most of it is stamped with the PNM. First of all, the public sector, which plays a critical role in the development of affordable housing, has significantly reduced its construction efforts. This has resulted in a significant shortage of accessible housing, especially for the vulnerable and low-income groups, as you have said. Many families are forced into substandard living conditions, overcrowded homes, or the informal housing sector. Mr. President and Honorable Senator, in the budget statement of fiscal 2021, the then PNM Minister of Finance announced that the Housing Development Corporation would aim to deliver 25,000 units into a 10-year period through an accelerated housing construction program. Well, let me just say, total, complete failure. PNM promises never materialize. People never matter. However, since the announcement of the initiative, HDC has completed only 1,804 houses over a 5-year span, spending $2.8 billion, significantly below the annual average necessary of 2,500 needed to achieve the 10-year target of 25,000 homes. I can't even call the numbers, they're so low. The PNM 2017-18, 871 houses. This is while the number of people applying for houses went up from 145,000 to a maximum of 214,000 citizens applying at the HDC. But this crisis didn't just occur like that. Well, you have to look at leadership. It's a crisis of leadership. Let me quote from the former Prime Minister, the one who was duly elected and not selected. On the 23rd of November, 2015, just 2 months after the Prime Minister became the Prime Minister, he said, and I quote on Hansard, "There is a big problem in this country with respect to the shortage of housing." Now, keep in mind, this is 10 years ago. Prime Minister Dr. Keith Rowley said on Friday, when questioned on the need to increase the housing stock, the state assumes a role in providing housing. The question is, what exactly is the size of the role? He continued, and he ended in a sad philosophical position. The Prime Minister then, the Honorable Member for Diego Martin West, said, and he was a former Minister of Housing, queried whether the state should be building homes at all. And that is why we are in crisis, because that was the policy of the PNM. They built no homes, the money disappeared, and then the genesis of this entire crisis occurred way before that. But I will pause there. What they went on to do, as the Honorable Minister of Labor said in a debate yesterday, was that they restructured something that had been restructured already. So they restructured from NHA to HDC. And when we arrive now, there's another restructuring. They restructure HDC into CCL, AMCOL, FEMCOL, and nobody knows what they're doing and who's doing it, and they produce nothing. So for the last 5 years, houses have not been built. People are waiting, people are dreaming. They give out fake allocations because of election, hand out keys, but the house is not finished. They build houses without approvals and then allocate houses without WASA approval, TNTEC approval, and people cannot go into it. Why do they do this? Well, we go to the genesis of the crisis, and the crisis begins with a member called Keith Christopher Rowley, the then Minister of Housing, November 2003 to 2007, when he said, the Honorable Prime Minister back then was quoted in an article when the Greenvale matter came up, and the Honorable Senator Faris Al-Rawi will know about that because he was on the HDC board when Greenvale houses went, when the government purchased John Rahal's land in Greenvale and they had no planning approval. They did not get planning approval from then Minister of Planning Camille Robinson Regis, but they went ahead. They didn't get change of use. It was agricultural land in a floodplain. But the Senator Al-Rawi was on the board that approved it. And we found out in 2012 when people nearly drowned, when there were about 10 feet of water in flood, and citizens had to go in boats and save people. That is the PNM. They don't follow the law. And when they were asked, the Prime Minister was asked, but how could you do this? Because they were seeing projects at HDC since 2003 to 2007, $2.4 billion in projects that were incomplete. And there weren't statutory approvals, no planning permission, incomplete designs, and you have Edinburgh 500, well, you know about Las Alturas, Harmony Hall, Wellington, across the country, while the then Minister of Housing was Keith Christopher Rowley, the member for Diego Martin West. He was asked, but how could you build housing without approvals, without statutory authority? Isn't that illegal? And the Prime Minister said, and I quote from an article, November 4, 2018, Guardian front page. On Friday, Prime Minister Dr. Keith Rowley confirmed that pressure to provide state housing to a growing market meant that the HDC was sometimes forced to bypass approvals and procedures to complete projects on time. But the projects were never completed. Money was wasted, and it continues so to be. When we see now we're at the HDC, and have no fear, I'm laying out the problems and the crisis for you, but that is why we have a minister, the Honorable David Lee, we have the Honorable Philip Alexander and myself. So yes, we will fix it. We will come and build houses. We will get back to the basics of providing affordable houses, because the PNM built no houses, but yet they were there allocating elite executive Victoria Keys and Federation Park villas, expensive luxury condominiums to friends and financiers. Guardsman gets 3. Even the lady in charge at HDC, the allocations executive officer, allocated herself a unit at $3 million in Federation Park. So this PNM is not funny. We are in crisis by design, a crisis designed by the PNM. The UNC will fix it. We've seen in the HDC now, with all of this transformation of different factions and a total disconnect with a managing director doing as she wants, when she wants, and wiring money without proper procedure, and a permanent secretary disrespected, lack of accountability. The auditing unit is the only unit that's understaffed. When money has been spent, no houses built. We also see, well, no approvals and so on. But there's an implementation crisis, and that implementation crisis comes from the PNM. The HDC currently has 37 incomplete housing projects, some of which are plagued by poor construction, terrestrial, for example, quality. Additionally, there are 5 public-private partnerships, PPP projects, and 11 initiatives under the small and medium contractors that remain unfinished. PNM could not build house. Simple. Housing allocation crisis. The average citizen who believed that they had a fair opportunity to obtain a home through the HDC, not through the PNM. There's a policy since Cabinet Note 2007 that says a certain percentage of houses should be made available. 25% should be made available through ministerial recommendation, fine, from MPs and so on. Do you know that ministerial recommendation under the PNM, could you imagine what it was, what percentage it reached? It's supposed to be 25%. PNM batting at 64.37% of ministerial recommendation. On top of that, there's also a segment called recommender unknown. So whoever recommend, we don't know, but that equated to 15.4%. So 15.4, when you add that to the 64.37, you get 79.77% of allocations being done by the PNM. That is why people out there feel that they have no hope, they have no chance. They have a reference number and the PNM is telling them random draw. You know what the random selection was under the PNM? 10.63% of the houses that they allocated. They didn't build none. The few that they build, they hand out to their friends and financiers and leave the rest of the population hoping and praying for God to bless them. But they blessed them on April 28 with the UNC and Kamala Prasad, Mr. Sir. The PNM don't even like the most vulnerable. Most vulnerable. They're supposed to give 10% of the houses to differently able, to people who are struggling. 10%, you know, that's a little bit. You know what the PNM did? They allocated 1.1%. PNM don't even love differently abled people. That is PNM. And this is why we're in crisis. This is why you now have 3 ministers. This is why you now have a prime minister who cares and would not do this. The last part that I would tell you, our police officers, our fire officers risk their lives and they hope and they feel, and I see all of them. Everybody want house, reference number. I get allocated, I pay this, right? The PNM does not even love and respect those who serve us and put their lives at risk. They're supposed to allocate 10 for protective services. It's supposed to be 10% of the houses. Would you believe that this PNM allocated to police, fire, and those in service 4%? 4%. So let me assure you, I thank you for this motion, Honorable Senator. The Minister David Lee, the Prime Minister, and the Minister of Planning, we are coming with a holistic strategy, and we will return housing to back to basics to provide affordable communities with creative, innovative, environmentally friendly, and we will implement, we will build, and we will allocate fairly, not through Balize House. Thank you very much.
Honorable Senators, the question is that this Senate do now adjourn to Tuesday, July the 1st, 2025 at 10:30 a.m. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, July the 1st, 2025 at 10:30 a.m.